Good morning, and what a welcome diversion from the national obsession with vote counting. I'm Michael Scharf. I'm the co-dean of Case Western Reserve University School of Law, and it is my pleasure to welcome you to the 2020 George A. Leet Business Law Symposium. The Leet Symposium is one of the law school's most prominent events, and it's part of the reason our business law program was ranked by Pre-Law Magazine as one of the top in the country again this year. At Case Western Reserve, we seek to train the lawyers and the future corporate leaders who will thrive in the fast-changing business landscape. Through innovative courses, special programs, and a concentration in business organizations, we offer our students the knowledge and skills to be effective advocates, negotiators, and counselors. Moreover, the cutting-edge scholarship of our faculty, ranked 30th in the nation this year in scholarly impact, brings great value to the legal profession and the business community. This symposium was endowed back in 1999 by a generous gift from George Leet, a 1946 graduate of our law school who spent most of his career with the National Labor Relations Board, ultimately rising to Senior Associate Executive Secretary. Past Leet symposiums have focused on topics such as the role of lawyers in strategic alliances, the legal and ethical duties of corporate attorneys, and most recently, fiduciary duty, corporate goals, and shareholder activism. This year, we're excited to focus on equity holdings in the 3 index funds, anti-competitive effects, fiduciary duties, and environmental, social, and governance issues. Yes, it's a mouthful, but it represents one of the most important issues in business law today. Today, our 4 panels and our keynote speech will be focusing on the fiduciary obligations of index fund managers, the implications for corporate governance and stockholder activism, potential anti-competitive effects, and effects on market dynamics and efficiency, and then finally, the rise of environmental, social, governance investing. Our 15 esteemed panelists include judges, leading academics, prestigious practitioners, and government officials. We have speakers joining us from Israel and Spain, as well as from across our nation. The panels are going to be moderated by our very own professors, Charles Korsmo, Robert Rapp, Anat Beck, and Juliet Kostritsky, who is also the director of our Center for Business Law. And I especially want to take a moment to thank these incredible professors who have spent the past several months putting this symposium together. Our lunchtime keynote address will be presented by Professor Edward Rock of New York University School of Law, whose speech will be entitled, "For Whom is the Corporation Managed in 2020? The Debate Over Corporate Purpose." Now, without further ado, I'm happy to turn the program over to Professor Anat Beck to kick off the first panel. Anat?
Thank you so much, Dean Scharf. Thank you so much. It's really an honor to have you here today. That was amazing. Thank you. I'm really excited. I wanted to thank everybody for showing up today and my amazing colleagues for making this happen and all the amazing panelists. I want to quickly start with some administrative work, and that is with regards to your CLE information, okay? What I wanted you to note is that the CLE information will be made available at the end of the symposium, and that Patty Harbold, thank you so much for your help. She will occasionally put a link to the form for the CLE in the chat throughout the day, okay? Now, each attendee should have received the link to the form in their registration confirmation email. We'll kick it off today with an amazing panel on fiduciary obligations, where we will have Jill Fish, Ann Lipton, Darren Rosenblum, and Bernard Scharfman. I just want to say a few things about each one of our amazing panelists. We'll start with Jill Fish. Professor Fish is a professor at the University of Pennsylvania, Carey Law School. She's an internationally known scholar whose work focuses on the intersection of business and law, including the role of regulation and litigation in addressing limitations in the disciplinary power and the capital markets. She's written more than 70 scholarly articles that have appeared in top law reviews, including Harvard Law Review, the Yale Law Journal, and the University of Pennsylvania Law Review. Her current projects include experimental research into retail investor decision-making, analysis of the structural and practical challenges posed by the financial regulatory process, and ongoing work on the theory and goals of private securities fraud litigation. Professor Fish has also explored the role of institutional investors in corporate governance, particularly shareholder voting. She traveled extensively in Europe and Asia to teach and to lecture and to meet with scholars and regulators on issues involving corporate governance. She received the LM Award for Excellence in Teaching and the Robert A. Gorman Award for Excellence in Teaching, and she's the director of the European Corporate Governance Institute, a member of the American Law Institute, and a former chair of the Committee on Corporate Law of the Association of the Bar of the City of New York. She's also a member of the National Adjudicatory Council of the Financial Industry Regulation Authority. So without further ado, I think that Professor Fish is our first panelist. Okay, I see that, just a second. Okay, let's actually start then with Professor Ann Lipton. Professor Ann Lipton is an experienced securities and corporate litigator who has handled class actions involving some of the world's largest companies. She joined the Tulane Law Faculty in 2015 after 2 years as a visiting professor at Duke University School of Law. In 2016, she was named as Tulane's first Michael M. Fleischman Associate Professor in Business Law and Entrepreneurship. Professor Lipton clerked for the U.S. Supreme Court, Justice David Souter, and the Third U.S. Circuit Court of Appeals, Judge Edward Becker, before handling securities and corporate litigation at the trial and appellate level at the firms in New York City. She also worked briefly for the Securities and Exchange Commission. As a scholar, Professor Lipton explores corporate governance, the relationships between corporations and investors, and the role of corporations in society. Her articles have appeared in the Journal of Corporation Law, the Fordham Law Review, and the Georgetown Law Journal, among other publications. Beginning with the 9th edition, she will be one of the authors of the Securities Regulation Cases and Materials Casebook, published by Aspen Publishers. I have to say, I'm a huge fan of her blogs. She blogs regularly for the Business Law Prof blog, and she's very active on Twitter. So without further ado, Professor Lipton.
Okay. And Professor Fish is here if you want to, or if that was your original order, but I'm happy to.
It's up to you, Professor Jill or Professor Lipton. It's up to you. What would you like to do?
What do you want me to start?
It's up to you. It's up to you too.
Okay, I'm happy to do that.
So we just introduce you and thank you. By the way, Professor Fish is one of my mentors. She's an amazing scholar. I love her work. And I just gave the audience a long introduction of your bio, which is amazing. And by the way, she wrote over 90 law review articles. Professor Fish, thank you. Please, the stage is yours.
Anat, thank you. And I'm glad that I missed your introduction because then I'm not embarrassed by it. So hang on, let me just get my slides up here. So I think this is the right screen. Can you see my slides?
I saw that you started sharing the screen.
It says slide sharing is paused. I don't know why it did that.
Let me just ask Martin. Yes. Okay. Great.
Now, can you see them?
Yes. Perfect.
Great. Okay. So thanks. It's a great pleasure to be here. And I guess if I'm starting things off, I should try to set the stage for our discussion. So let me see if I can do that. Our panel is entitled Fiduciary Obligations of Index Fund Managers. And I guess what I'm going to focus on, and I'm going to try and raise a couple of themes that maybe will help overall for today's discussion, is some practical questions that are sort of implicated by the fact that fund managers are fiduciaries. They're fiduciaries to the funds that they manage. Arguably, they're fiduciaries to the investors who invest in those funds. And I'm going to talk about why that difference matters. And they may also have obligations, and increasingly we're thinking about their obligations to the companies in which they invest, to their portfolio companies. So, and the reason we're increasingly thinking about this third role, and technically it's not a fiduciary role, but we are globally, we're thinking a lot about institutional investor stewardship. The idea that asset managers, index fund managers, and other institutional investors should engage and vote to influence positively the assets in which they invest. And we see this, as I said, globally. We see this in many countries like the UK, framed as an affirmative obligation. And we also see a lot of academic commentary saying, with respect to their portfolio companies, institutional investors aren't doing enough, right? Either they're not engaged enough, or they're not taking their votes seriously enough, or they're not engaging on a broad enough range of issues. This particularly comes up with respect to ESG, environmental, social, and governance issues. And I know there's a later panel that will focus on that. But these questions have been increasingly raised. And institutions are taking these questions seriously and trying to think about, okay, how can we do more? But they have to do this in the US in the context of their obligations to their funds and to the investors in those funds. And as I said, this can create some tensions, right? So the focus of this panel and this program is index funds, right? So here's our little picture and our little definition of index funds. But what is key about index funds? Three things. Number one, they hold a lot of companies, right? It's not like a hedge fund that's engaged in 8 or 10 or 12 companies at a time. They hold hundreds of companies in their portfolios. They invest in those companies because the companies are included in an index. So they don't do firm-specific research. They don't decide this is a good company, this is a bad company. They just invest. And three, they compete largely on costs. So they try to manage their portfolios in a very low-cost way, right? So these attributes create potential risks, right? And these risks are associated with institutional investor stewardship, right? There's a risk that they'll make mistakes. They don't do firm-specific research. They could get it wrong. They could propose something that's just wrong for the company. And people have raised this as a particular concern when we're talking about transactions, right? A merger or something like that. They could, and some commentators have actually suggested that they should, sacrifice firm-specific value in favor of portfolio value. So Madison Condon has taken that view. Jeff Gordon has a recent draft basically saying, well, it doesn't matter what happens at Exxon if Exxon, it doesn't matter if this proposal hurts Exxon. If it benefits all of the other companies in the portfolio, that's something the index fund should do. There's a risk that they'll sacrifice economic value in favor of non-pecuniary goals. Doing something because it's the right thing, even if it costs the firm, even if it costs investors money. And there's a risk that they may be subject to agency costs, that they may act to further interests of the fund managers, of the head of the company that aren't shared by their investors. It also creates complexities. Which interests should the index fund prioritize? How should it figure out what its investors' interests are? And what if the investors in the funds have different priorities? How does an index fund navigate that? So here's just a picture on sort of the complexity of priorities, right? These days, everything is on the table. So when we talk about investor stewardship, we say investors should deal with climate change, they should promote supply chain compliance issues, they should deal with diversity in the workplace, they should deal with wealth and income inequality, right? The list goes on, too many things even to put on the slide, right? So how do we figure out what the fund should pay attention to? And how do we figure that out in particular in an index fund, right? Index funds are part of an overall fund complex. Should the fund complex manage its index funds differently from its other funds? Do we pay attention at the fund level, or do we recognize that index fund investors may also hold other funds? Is the relevant interest the interest of the investors or the fund itself? A fund's just a portfolio of assets, right? It's just a pile of stock and bonds and maybe some cash, right? It doesn't have any interests of its own. And the complexity is enhanced by the fact that of the hundreds or thousands or hundreds of thousands of investors in a single fund, they don't all want the same thing. So you might have some socially engaged investors. People say millennials are more concerned with things like climate change. And you might have some retirees who are depending on that fund for their daily living expenses. And if the fund takes a hit, they're going to eat pet food or something. So how is a fund supposed to take into account, well, half of my investors want something and half want something else? And people have talked about, well, you can solve this through pass-through voting. But at the end of the day, it's a little unsatisfying to think of a fund splitting its vote, right? So, one possibility is pass-through voting. Another possibility is either communicating from the fund to the investor, this is what we intend to do, right? If you don't like it, don't buy our fund. Communicating from the investors to the fund, these are our preferences, this is what we want you to do. I've got a paper, experimental paper that I'm working on with Sean Griffith and Abby Marcus, in which we're trying to figure out whether investors would like that kind of an option. And a final possibility is market segmentation through fund specialization. And I'll talk a little bit more about several of these, right? So pass-through voting, great. We can figure out what the investors want by just giving them their vote. But it's not entirely clear how manageable this process is. Certainly pass-through voting, the idea has been around for years. And with technology, with blockchain, it's a lot more feasible. But mutual fund investors in particular don't vote very often, right? Most of the things they just throw in the garbage. It's not clear how sophisticated they are. A lot of mutual funds are held by people in their 401k plans. And research shows that 401k only investors are particularly weak in things like financial literacy. Again, it doesn't solve the problem of heterogeneous investor preferences. And it reduces the power of the fund or the fund complex to advocate for change, because it can't say to the company, if you do what we want, we'll vote your way. The voting is up to the individual shareholders, right? So other possibilities are communication and delegation, but this raises the issue of trade-offs and how the fund manager is supposed to navigate those trade-offs. The advantages of going through a centralized system is you take advantage of the fund manager's sophistication and expertise, and you use the heft of the index fund to support not just its own initiatives, but initiatives that may have been identified by activist hedge funds, actively managed funds within the fund complex, or fund managers. So those are advantages, right? Now, the final possibility that I want to flag for today is, can we do this through greater specialization, right? And in particular, if you look at ESG mutual funds, the market is exploding, and this includes ESG index funds. But we have funds that employ exclusionary strategies. We have funds that provide engagement. We have impact funds. We have thematic funds, all these different possibilities. The range of options is increasing, and the disclosure about these differences is increasing. So this provides a potential, we're not there yet, but a potential solution that I think we could work a lot harder to move along. And it's a way of meeting the fiduciary obligations of fund managers by essentially having them explain what they intend to deliver and then holding them accountable for what they've promised, not for saving all of society's myriad problems, right? The keys are greater transparency, what the funds are doing, and greater accountability. So brokers, employers who select the funds in a 401k plan, rating organizations, and the financial media are all tools that we can use to hold the funds accountable. Is the fund really doing what it claims to be doing? And with those kinds of vehicles, I think we have a market mechanism that's a very promising substitute for more aggressive regulation along the lines of, for example, what the Department of Labor is doing in the area of pension funds, right? So what does this market segmentation have to do with a classic index fund, right? What I'm identifying is alternatives, not necessarily saying, well, gee, yeah, you can have an index fund that actively engaged and is thematic and all of that stuff. That might be pretty hard. But I think this still leaves room and narrower space for traditional index funds to be effective, consistent with their fiduciary obligations. So one thing that they can do is promote increased disclosure. Jeff Gordon, as I said, has a new paper in which he's talking about this. I worry a little bit about index funds mobilizing beyond disclosure. I will grant you it's a low-cost strategy. In general, right, subject to some qualifications, we think, well, disclosures, pretty good thing, right? Firm specific, company level disclosure, disclose your plans to address climate change or something like that. But I'm not sure that disclosure at the fund level is a viable solution to societal problems. If something really is economically significant, it seems to me it should be mandated disclosure for all firms, or at least all publicly traded firms, and it shouldn't be left to the shareholder proposal process. Second option, strengthening the economic claim for particular initiatives. So if index funds, drawing on their research, drawing on the research of their sponsor and the actively managed funds in their complex, say, climate change isn't just a feel-good thing, it's something that matters for portfolio companies, it's something that's going to affect your bottom line. Making that case and putting the voting power behind that can be quite compelling, can sort of nudge intransigent management to take issues that they perhaps hadn't realized had become economically and societally important, taking those issues more seriously, right? But this only works if index funds limit themselves to issues that are economically significant, right? Third possibility, support for creative activism. So Ron Gilson and Jeff Gordon have this article in the Columbia Law Review about institutional investors, index funds kind of mediating traditional hedge fund activism. Hedge funds come up with an operational change. Index funds support them if they think it's a good idea. This is a way of kind of vetting the proposal. Passive funds can do the same thing with respect to so-called sustainability activism. So there are a handful of hedge funds today that are saying, there is economic value that can be achieved through funds, through portfolio companies behaving better, through portfolio companies dealing with environmental, social, governance questions. When a hedge fund brings that kind of initiative, I think there's real value in the index fund saying, look, do we believe it? Does this matter? And if we do, and we support you, the hedge fund's more likely to succeed. So all of these, I think, are within the mainstream of index fund engagement, are low-cost strategies, don't require the firm-specific knowledge that index funds are ill-equipped to obtain, and nonetheless promote firm economic value and firm social value at the same time. So that's my introduction, and let me pass the baton and stop sharing my screen.
Well, thank you so much. Thank you so much, Professor Fish. What we will do now is I would like to take some questions from the audience and from the panelists. And I'll I'm checking out the Q&A. So if that's okay, I'll take the liberty of asking the first question. So what do you think about, this movement that we're seeing around the world, right? There's this 21st movement towards extension of fiduciary duties in countries outside the United States. What they're doing is that they're extending fiduciary duties, and especially with regards to institutional investors, they're asking them to take ESG into account and other things. What do you think about that? Do you think it might happen in the United States, or we're still, very far from that? And I'm just going to say one more thing. I'm going to remind the attendees, please ask me questions in the Q&A function, okay? For me to be able to read them, it has to be in the Q&A function. Thank you.
Well, Anat, it's a great question. I think we want to be careful about calling this fiduciary duties. So that's why I framed my talk in terms of stewardship, right? US style fiduciary duties are an anomaly, right? And they're an anomaly because there's a level of liability exposure, litigation exposure that really isn't present in the rest of the world. And so when we talk about these stewardship obligations, right, the language in these stewardship codes, you're right, it's pretty aggressive. But by and large, what the codes are requiring institutional investors to do is disclose, to comply or explain. They're free to explain, why they're not doing it. They don't face lawsuits by regulators or by their beneficiaries if they don't do it, or even if they don't comply or explain. So, it's a pretty light touch. And at the end of the day, I think the jury is still out on how effective these stewardship codes are. I mean, yes, there's a whole movement to do this all around the world. And, sometimes they have a little teeth. Sometimes it's at the level of a stock exchange as part of its listing requirements. But I don't think they are nearly as dramatic as the kind of obligations that we tend to talk about in the United States.
That's great. Thank you so much. And I know that we have actually one of the panelists is with us, Josh Mitz. Josh, I know that you have a question.
Hey, Jill. I wanted to follow up kind of on the direction that Anat was going, which in really towards the tail end of your answer, which is the distinction between ex post liability and a regulatory burden of some sort. I guess it's really what's the right institutional mechanism for stewardship? Is it liability? Do we think the courts are good at some parts of this, but not others? Do we think that this is really a division of investment management problem? Where do we situate it? Which institution is best suited to impose these duties or to make these judgments?
Muting and unmuting myself. So a good question. And I'm going to push back because it's not really clear to me that it should be courts or the SEC or the Department of Labor. I don't really, I guess I'm too much of a fan of markets as at least being the sort of first order solution to this problem. And if it's a problem. And I think that what we see going on in the mutual fund market right now is a tremendous amount of change and a tremendous amount of innovation. I mean, if you look at the number of funds that are devoted to stewardship in one form or another, and it could be, as I said, it could be through stock selection, it could be through engagement, it could be traditional funds increasing the type or the level of engagement. It could be impact funds, right? There's a whole universe of stuff going on. And even at the same fund complex, what they're offering and what they're disclosing about what they're doing is changing dramatically. Vanguard just changed the type of disclosures that it's making about its funds' voting records and created a whole system in which all of a sudden It's accessible. You don't have to go download all the NPXs and sort through all of the different votes. You can get the information. I own this fund. I care about this annual meeting. How did my fund vote? Right? So, what that is a market enhancing tool. And I would see how that plays out before I asked regulators to step in and kind of freeze the frame, because regulators don't always get it right.
Thank you so much, Josh and Jill. And I have two more questions from the audience. I'll just read those two questions to you. One is from Christopher Switzer. Is there a current mechanism in US law to regulate this? Maybe something like best practices in the FTC, or would a whole new law be required? And we have another question from Catherine Williams. Given that these are highly used by mutual funds and casual investors, do you think that this level of regulation is sufficient, particularly given that the least sophisticated investors are the most vulnerable?
Well, so I guess it's not entirely clear to me what both of the questioners means by regulation. I mean, under existing, under the Investment Advisors Act, under the Investment Company Act, fund managers are fiduciaries to their funds. We're not, I think, entirely clear on what that means. So a lot of the debate right now is whether, as a fiduciary, you are required to focus solely on economic value. Is it short-term economic value? Is it economic value that you can prove with some sort of, empirical research? Can you take non-pecuniary considerations into account? And what's the relationship between economic and so-called non-pecuniary? And those are all spaces on which commentators, debate. I don't think we know as academics or as a society entirely what the right answer is. So I don't think the sort of body of existing regulation has even developed to try to answer those questions, and I'm not sure it should, right? So, the Department of Labor just released something for pension funds, essentially warning them about the risks and the need to justify any kind of investment on so-called ESG considerations in economic terms. The status of the research in this area is very mixed. I mean, there's research out there suggesting that taking ESG into account is correlated with better economic performance. And there's research suggesting the contrary. So I'm not sure, as a fiduciary, what a pension fund manager is supposed to do. And that's why I'm hesitant to try to freeze the frame and say, okay, now I want the SEC through this notice and comment process, or Congress or somebody else, to weigh in. I would, I think this is a space in which we have tools. The market is a pretty powerful force in the investment area. If investment managers get it dramatically wrong, we don't really need fiduciary duty litigation, right? Money has power.
With that, thank you so much, Professor Fish. This was amazing. Thank you. And we're going to move on to the next presentation, Professor Lipton. So as I noted before, Professor Lipton is joining us from Tulane Law School. And again, as I noted, follow her blog and her Twitter account. It's very, very interesting. I'm a big fan. Thank you.
Thank you. And thanks so much for letting me take part in this symposium. I'm really excited to have this discussion, and I'm grateful for the invitation. So in my presentation, I'm going to focus on the choice between competition and cooperation in mutual funds and mutual fund families. The title of this panel is Fiduciary Obligations of Index Funds Managers. So I'll start by unpacking the concept of index funds and the concept of fiduciary duties. And some of this was actually already flagged by Jill. So I'll be going over a bit of the same territory, but I think I have a slightly different take on it. So when we say index funds, we usually think about the S&P 500 and other broad indexes. And the reason we treat index funds as a category, the reason we talk about them as a thing, is because we tend to assume they're broadly diversified, they're stuck following the index, which means they have to make long-term investments in their companies. And there are certain implications of that. We expect they might be more interested in stewardship than active funds because they can't sell. We expect that because they are broadly diversified, they want to see the economy as a whole perform well rather than focus on specific corporate interests. The problem is index funds are actually a much broader category than that. So yeah, there's a terrific amount of money that's chasing general market indexes like the S&P 500 and Russell 2000 and so forth. But at the same time, and I'm sure at least some of you are familiar with Adriana Robertson's work on this, a lot of indexes are very idiosyncratic, often commissioned by a particular fund sponsor and followed by only one fund. These are called index funds, but they really represent a type of active management with a sort of limited churn. So there are energy index funds that have oil and gas. There are clean energy index funds that focus on solar. There are sustainability index funds. There's the State Street Gender Diversity Index Fund. And that's actually what my Zoom background is referring to. What you're looking at are the performances of comparative performances of 4 different ETFs, all of which focus on gender diversity, and 3 of which call themselves index funds. And like all indexes, including the broader indexes, these indexes are amended sometimes multiple times in a year, which means the fund has to buy and sell to match the reconstituted index. And the modifications may be at the request of the funds that follow the index. So they have input into index selection. The big 3 fund families, BlackRock, Vanguard, and State Street, they dominate the mutual fund space. My numbers are probably a little bit out of date, but the last statistics I have are that BlackRock owns at least 5% of half of publicly listed companies. Vanguard has at least 5% and 40% of publicly listed companies. And if you take the holdings of the big 3 together, those 3 have the largest single block of stock and something like 88% of the S&P 500 and so forth. And these giant mutual fund complexes are mostly known for their index funds. And it's assumed that due to their large stakes and broad diversification, they should be good corporate stewards. But they, along with the smaller complexes, also sell a lot of these niche funds, which means a lot of the funds offered by our classic passive giants actually have very specific types of investment strategies. So when the indexers are creating these specialized index funds that have an obvious investment theory behind them, it's hard to say that the funds own the economy. The family as a whole owns the economy, not the individual funds. Meanwhile, we know that an awful lot of nominally active funds basically just track an index with some minor modifications. And that means we may not want to draw really sharp distinctions between the big 3 and the other large complexes like Fidelity or T. Rowe Price that focus mainly on active funds. The big 3 may be broadly diversified across the entire family, but many of the funds have really idiosyncratic investment strategies, and they aren't necessarily all that tied to a single set of stocks. Okay, so that's the index funds part of this panel. What about the fiduciary duties? Fiduciary duties are state-imposed obligations. They're imposed on certain relationships. When people form a relationship, an agency relationship, whatever it is, the law imposes obligations on the parties to act in their best interest, to act solely to advance their interests, whatever it is. And the state imposes these obligations as a matter of policy because they think the world is better that way. But we also know in real life, fiduciary obligations aren't really self-executing. You need to create a set of incentives that induce the fiduciary to act in that way. So at bottom, this is about the government determining what kind of policies it wants to advance, and then designing a regulatory ecosystem that will create the right incentives. So when it comes to corporations, for example, managers have fiduciary duties to shareholders, and there are a lot of arguments about why that's good as a policy matter, why we want that. But to make sure that managers actually live up to their fiduciary duties to shareholders, we have a mix of regulatory incentives coupled with governance powers. We give shareholders various types of governance rights, and then we make it easier or harder for them to exercise those rights with market regulation, disclosure obligations, and so forth. I think in the mutual fund space, the fiduciary duties we have and the regulatory systems surrounding it are suboptimal from the point of view of the actual fund investor, especially the retail fund investor. And the reason for that, it's partially all the reasons regulatory choices may be suboptimal. Maybe there's regulatory capture, you have powerful business interests that lobby one way or another, but I think it's also because there are conflicting policy interests at stake. First problem, I think we have too many funds. For retail investors in particular, there shouldn't be that much variation. This is well understood. Sure, we can say everyone's a special snowflake and there are different risk tolerances and different goals, but for most retail investors, they're saving for retirement and they should be invested in a broad, safe, cheap, passive index fund of some kind. They do not need all of these options. But retail investors end up buying expensive index funds, even when virtually identical ones exist elsewhere, or they buy a fund that's cheaper, or they buy a fund that's got some kind of strategy, whether it's an active fund or a niche index that underperforms. We have a lot of competing ETFs that are literally identical, except for the fees. And the more of them they are, the worse the liquidity gets for all of them, making it more expensive to trade. There should be market pressure to cure some of these pathologies, but there isn't, and we know why. The ETFs thing is its own particular problem, but with a lot of the problem here is that retail investors are relatively unsophisticated. They don't understand fees or returns or how to evaluate funds, even when they're instructed about it, and so they make a lot of bad choices. This is fixable. We could have stronger fiduciary duties for the funds themselves, backed by incentives, of course, but we could have regulatory interventions or private rights of actions or whatever that require funds to offer better fee structures regarding the value add of introducing a new fund that's identical to an old fund, regarding disclosure of the fact that there's an identical fund somewhere else. We don't do that. Instead, the fiduciary obligations have, as a practical matter, been pushed down from the fund to the sales channels, to the brokers, to the registered investment advisor, to the ERISA plans. And of course, those obligations are very, very weak. And there's a lot that's allowed in terms of compensating brokers to sell certain funds to retail investors, even when those are not the optimal choices. Point being, there's less market discipline in this space than there should be. If the funds really had markets to discipline them or regulatory obligations to discipline them, there would be a lot less competition than there actually is. So not long ago, the Obama administration, and I will take a pause for fond remembrances, the Obama administration proposed stronger fiduciary obligations for brokers, and all the brokers objected because they said it would force them to sell only passive index funds, to which I say, yes, good. What else would you do? That's what a retail investor needs. If we had real market competition, a lot of funds and a lot of fund complexes wouldn't exist anymore. I mean, to some extent, that's obviously happening. It's why we're talking about the big 3 and not the big 15. But there's been consolidation in a lot of industries. And the fact that the big 3 are branching out into these niche little index funds tells you it's not just about investors getting smart about passive versus active. So William Birdthistle, he's a big mutual fund theorist. He literally wants all 401k money to be pushed into a very small set of funds administered by one asset manager, BlackRock. Quinn Curtis, also a big fund guy. He wants everyone to be in a passive target date fund because, of course, that's where the vast majority of the market should be. We could make that happen. We could design a regulatory system that encourages putting retail investors in those kinds of funds. But that is scary. It's great for mutual fund investors, but it has problematic macro effects. One of those effects is the concern about passive index funds taking over the markets to the point where markets become less informationally efficient. People have been sounding the alarm about that for years. Another concern is about the actual power and influence of mutual fund complexes. We have a lot of suspicion about concentrated economic power, and particularly the governance implications if one asset manager controls all the corporations. We also might have concerns about the power of index providers. When we're talking about broad market indexes, there are really only a couple of operators in this space, and they have tremendous regulatory power. They control how governments regulate their securities markets because they want to make sure that their home companies can be included in indexes. So giving them even more control of the market is a little scary. So we have serious tension between what is optimal for fund investors and what's optimal for markets and the economy as a whole. Okay. So we have too many funds problem, which I think is at least partially traceable to a lack of fiduciary obligations and corresponding regulatory regime, which itself is due to a set of confused policy goals. We also have a parallel set of problems when we look specifically at fund stewardship and how mutual fund companies conduct oversight of their portfolio companies. So the problem in corporate governance has always been, if managers are supposed to advance shareholder interests, how do we make that happen? It's hard to do by increasing shareholder power and giving them more governance tools if the shareholder base is fragmented. Shareholders with a very small stake can't influence the corporation much, and it's not worth it for them to try. In recent years, we've had the rise of institutional investors, especially mutual funds. More and more shares are held by institutions rather than natural persons, and that seems to present a solution to our rationally passive investor problem. Institutional investors have vast holdings under professional management, and so it's been assumed they really have the skills and incentives to oversee corporate behavior and control corporate managers. But that's, of course, only part of the truth because the marketplace is fragmented. It's not all one fund. When you go fund by fund, they each hold a tiny sliver of the market, more than what a human would own, but not enough to put in the kind of oversight that a lot of theorists seem to want. So now the argument is funds should cooperate rather than compete. Well, how do we make that happen? On the most basic level, we have proxy advisors, ISS, Glass Lewis. These companies are in the business of analyzing matters that are coming up for a shareholder vote, and they make recommendations to institutional clients about how to vote their shares. And they can tailor recommendations to the clients. So the clients have particular prices, if the clients have particular types of preferences. And that's one way we can coordinate among institutions, including, but not limited to, mutual funds. The other way we get coordination has to do with how fund families operate. So the reality is that fund families tend to centralize their votes across all the funds they have. They might give the individual portfolio managers more or less freedom to depart from the house view, but some families are very strict about requiring everyone to vote the same way. And I should also say that complexes like Vanguard and Fidelity, which offer both active and passive funds, have developed separate voting systems for the passive and the actives, which is essentially for regulatory reasons. They're afraid they'll be regulated like activists if the active side votes with the passive. But they're still treating things as a group. The passives separately from the actives. And for me, this is an issue because I think when you go fund by fund, the interests of each fund are not always identical. And if the fund families centralize their governance and treat all funds as a collective, they may be harming the interests of individual funds. And I've been on this jag before. Many of you I know have heard me talk about this, but like if the fund family has bond funds and stock funds, the family as a whole might find it profitable to minimize risk across the family, which maximizes the fees to the family, even though the stock funds might prefer more risk that ends up damaging the bond funds. We might have the common ownership problem. That's going to be addressed in another panel, but there are a lot of concerns about mutual fund families that own stock in different competing firms like airlines. And they may cause their portfolio companies to collude to raise rates, to lower customer service, because they're broadly invested in the industry and not any one airline company. Now, that might very well present antitrust problems. So I'm not saying it's a good thing for society, but as a theoretical matter, it's at least good for fund shareholders because it maximizes the value of the sector. The problem is fund families don't all have the same stock in all their funds. It's distributed differently. So the transportation fund might feel very differently about competition in the airline industry than the clean energy fund or the regular energy fund or the broad index fund. And the more you see these niche index funds, I think the more the differences are exacerbated. So that's why the big three have all these sustainability funds with really bad sustainability voting records, because they centralize their votes instead of considering the needs of each fund individually. Now, there may be reasons funds would want to cooperate with each other and not advance their interests individually for the same reasons you ever want to cooperate with someone. Votes are only valuable as a collective. The funds might, in some circumstances, think that cooperation is worth it, even if a particular vote or engagement is suboptimal for a particular fund at a particular time, but it's not obvious that's always true or when it's going to be true. So now we have to decide what are going to be the fiduciary obligations that mutual fund companies owe to fund investors when they engage in stewardship activities. And the regulatory framework should follow that sense of what the obligation should look like. This is a policy choice, and there are different options. Here's one set of arguments. We want families to treat their holdings as a single portfolio because that's the only way their holdings and their profits are large enough to incentivize them to engage in stewardship at all. We want families to concentrate their economic power because it's the only way we solve this shareholder collective action problem. We might even say we want families to make the decisions across the portfolio because now we really are looking at them owning the economy. They won't just be better corporate stewards, they'll be better economic stewards because they'll care about the externalities of individual companies. We want them to play that role. So in that iteration, we don't want stewardship of the energy fund to be different from stewardship of the real estate fund, because the energy fund will externalize the cost of global warming onto the real estate fund, and that hurts society. So please, fund family, treat them all as one big portfolio, because that'll balance the economic interest that you have across the portfolio of all of society. And there's an argument, which I saw in another context, and I'll explain that context in a minute. We maybe want families to smooth out results results across their funds to maximize wealth across the family, precisely because retail investors kind of suck at choosing funds. And if the funds practice general stewardship, then retail investors can't go all that wrong when they pick a fund within a family, which is ironic because if we want to protect retail investors, maybe we shouldn't have all the different funds in the first place. But okay, so now I have to add one odd little point on this, which is Vanguard. Vanguard is actually owned not by some set of profit-oriented shareholders, but by its own funds. The funds in the Vanguard complex actually own Vanguard. So you could say theoretically that all the Vanguard funds actually have an interest in Vanguard's performance overall, including the fees that Vanguard collects from each individual fund. So it really is one big portfolio. Every fund is interested in the performance of every other fund, and that's why they should coordinate. Except that's not exactly the case because Vanguard doesn't actually give the funds any rights to its earnings. So they're like shareholders, but name only, but it does present an interesting theoretical question. So these are arguments in favor of families centralizing their votes, but there are counter arguments. Most obviously, different investors are invested in different funds. And if we want to protect the actual for real human being investors, we have to take those differences seriously. You should get the benefit of the fund you're invested in. Another argument, fear of concentrated economic power. If we don't like concentrated economic power, if that's part of the reason we don't force all retail investors into one big target date fund, if we're afraid of antitrust problems from common ownership, the absolute simplest thing in the world is to emphasize that fiduciary obligations run to the funds individually and then regulate to force the families to operate that way. And there are a lot of nuanced choices here. If we just want to essentially hobble the economic power of the largest complexes without entirely undermining them, we can just throw up regulatory barriers in the way of fund coordination, like a documentation or compliance requirement, something like that, to show that the consideration was given to whether the fund should cooperate or defect. That might induce enough friction to mute their power without entirely eliminating it. One of the really interesting developments here has been the regulatory attacks on proxy advisors and on the 14A8 proposal process. That's a subject with a lot of angles, but I think the very short version is these attacks are meant to undermine shareholders' ability to coordinate with each other. If proxy advisors can't operate freely, it makes it much harder for shareholders to reach a coherent set of preferences that can actually have an impact on corporate behavior. 14A8 as well, it's another mechanism for shareholders to coordinate with each other and express a set of preferences about how corporations should be run. So Rule 14A8 allows shareholders at particular companies to put a proposal on the corporate proxy for other shareholders to vote on. They're used to express preferences about governance arrangements like staggered boards or proxy access, and to express preferences about social and environmental issues like climate change or diversity reporting. 14A8 proposals are influential, not just at the targeted corporation, but also at a wide swath of companies because shareholder support for a proposal can help establish industry standards. But the SEC just dramatically restricted 14A8 and pulled back from major reform of proxy advisor regulation in favor of more minor reform. But the point of all this is they want to fragment the shareholder base, make it harder for shareholders to cooperate. But there are unintended consequences there. The big three have very concentrated economic power. They don't need a proposal to make companies do what they want. They just need to make a phone call. They don't follow ISS lockstep. They reach their own conclusions. So if you make 14A8 proposals rarer, that just means the big three can operate free of public oversight. We have no idea what they're advocating for in terms of governance or sustainability or any other issue because we won't see their stewardship out in the open. They don't have to disclose voting policies on matters that never come up for a vote. And if you make it harder and more expensive for the proxy advisors to operate, it's not the big three that are going to lose power because they don't need the proxy advisors. The ones who will have trouble coordinating are the smaller shareholders, which just amplifies the voices of the big three. Upshot being, they will have more influence in the corporation, not less. And that matters if we're concerned about concentration of economic power, and it matters if we're concerned about how the big three are exercising their stewardship. With that said, I'm sorry, I'm running over time, but with that said, I don't have a great answer because I think this is really a question about policy, but I do have one thought, which is probably wrong, and I'm looking forward to somebody telling me why it's wrong. Okay, so one of the interesting things here is that mutual funds their advisors can only collect fees based on assets under management. They collect a percentage of assets under management, not performance fees. But the individual portfolio manager who actually runs a particular fund, they can get performance fees. And for active funds, they absolutely do. I don't know about index funds, but they're definitely get them for active funds. And what studies have found is that the performance-based fees that go to the human portfolio managers who run the active funds either compensate them for outperformance of their fund alone or compensate them for performance based on the fund family entirely. They can do one or the other. And you will be shocked to learn, I am sure, that when compensation is based on fund alone, you have a great divergence in fund performance. Some performance are great, some funds are great, and some funds are poor. But when they are compensated based on the fund family as a whole, you have a really smooth performance across the family. And some have argued this is good for retail shareholders, again, because they can choose, that way they can't go very wrong if they pick a fund. Anyway, so the point is, can we import that into the index fund space? Can we say something like, index fund, the individual portfolio manager should have the freedom to vote their shares as they want, with all the resources and research departments of the centralized governance departments of their family, and they're compensated based on the performance of their fund. So then they'll have a real incentives to decide what kind of stewardship is best for the fund and whether cooperating with other funds in the family is really the best way to go. Anyway, that's all I got, and I look forward to your questions.
Thank you so much. Thank you so much, Professor Lipton. This was amazing. And I actually have a question, but also first there's some questions from the panelists. I just want to quickly remind people, if you have questions, please put them in the Q&A. And Professor Rosenblum here, Darren Rosenblum, thank you so much. He's got a question here.
So thank you so much, Anne, for that really interesting presentation. I learned so much. And I really like the way in which you underscore the complex situation in which we sit, which is that there's clearly market failure going on because there's so many funds that overlap and there's so much sort of less than optimal governance going on. I guess the question that I had for you is whether you've read about other regulatory systems. I know you mentioned a few scholars who've suggested things, but outside the United States, in which there are ways to resolve some of these concerns through the state, because I do suspect that within the US, there's such a reticence to having the state press its thumb on the scale that there's perhaps too little regulation as opposed to the sort of Goldilocks level. And I was just wondering whether you encountered anything along those lines in what you've read. Thank you.
Yeah, I mean, the fact is that I'm just not like, I tend, like, the United States is overwhelming enough. I don't focus too much on, not because it's just, there's only too much, but I know a little bit. I mean, because, generally with retirement, the idea is, 3 pillars. There's the state pension, there's personal investments, and there's employer pensions. And different countries have, systems that balance it more. And like part of maybe what's throwing this out of whack is when I say everyone should be in a target date fund, or maybe we should just have stronger Social Security and pension benefits, and then it's fine to give more freedom to go play in the other spaces. And that may ultimately be the cause of the regulatory failure here.
I think that's the right answer, is that part of the reason this matters so much is because the state pension sector has shrunk so significantly. But thank you.
Professor Fish is also here with us. Do you have a question for Anne?
Yes, Anne. So good morning, and wow, that was like warp speed, and I have about 6 million questions. But I want to take you back to something very simple, because I made the world kind of complex when I started talking about ESG and engagement and voting. And of course, you've got your great background with thematic funds and so forth. And it's a complicated world out there. But you took us back to the kind of straightforward issue of returns and risk and fees. And obviously a lot of the debate about fiduciary duties is about those very straightforward questions. But I'm curious about your sort of confidence that in the current environment, the best thing for every investor or the vast majority of investors is a low-cost target date fund. Because, I see the market responding to investors saying, no, that's not the best thing. I mean, number one, right, there's this whole debate about fees. I'm not sure that the race to zero is ideal. I mean, you get a certain package that you talked about a lot with the race to zero. I'm not sure if that's best for investors or for the state of the world. Number two, there are a lot of not just funds, but fund complexes out there that are promoting what looks to me like a really different product, like Calvert, right? Calvert's not the big three. And you buy a Calvert fund and you pay somewhat more, right? What you get is not just a socially responsible fund, but a whole fund complex that has a different view of what investing should be about. Why can't an investor buy into that? And then if Calvert does that, why can't BlackRock or Vanguard say, Calvert's got something here that people want. We're going to create some funds other than our target date fund or our S&P 500 index fund to try to tap into what people want. And yes, I agree, we have too many funds, but I'm not sure that we should be driving to zero. And right now, given sort of the diversity of viewpoints about what funds should do, I kind of think more might be better than it was, 10 or 20 years ago.
I guess my view is there's like the happy medium sort of thing. Like, I think there are too many funds, but that doesn't mean I want to get rid of Calvert. I think Calvert is a luxury product. I think that you can't trust, well, this is what the market demands if you can't trust the market demand. And I don't think you can trust the market demand for a good chunk of it, not all of it, but a good chunk of it. And the reason you can't is because we can't trust that retail investors know what they're doing, which is a big chunk of it. That doesn't mean like there's no room for sustainability funds or ESG funds. And I am all in favor of ESG funds that are openly saying, you know what, we're not going to invest in oil, and I don't care if oil's profitable. We're just not going to do it because we think that's bad, or something along those lines. As long as that's clear to, if one of the interesting things here is that I think when you talk to like retail investors and what they can and can't understand, the thing that they can understand probably the most readily is you will not have the highest returns, but you will not be invested in oil or private prisons or whatever it is. Like, if there's any one thing I actually trust that retail investors can understand, it's that one thing. But that's not the only space here where there's like too much variation. And then, so one problem we have is no, this is the best for you financially, and it really, really isn't kind of situations. And also the issue of funds that say they're ESG funds or sustainability funds, but they're very unclear. And as you said before, they're very unclear on exactly what that means, and sustainability, but like in name only, and it's just a sort of greenwashing thing. So I think that, there are too many funds because the channels by which they're sold, partially because of retail investor lack of understanding and a lack of supportive channels that will help them sort of narrow it down. Doesn't mean get rid of Calvert, but we can do with less than 4 gender diversity index funds, which I don't even know what that even means.
Thank you so much. And I actually have one more question from the audience. And they're stating that both panelists have talked about investment complexity and the lack of financial literacy. Is there any role for increasing financial literacy in fixing these issues? Would it help your average mom and pop investor to care about these issues? Is increased literacy even achievable?
Everybody has different takes on this. My view is absolutely not, because I remember back when, so like the story that I like to tell, I can tell this story, I know a bazillion people, is that I am a business law professor. I teach business law for a living. I started at Tulane, and I knew that after like a year or however long it is, my retirement plan would kick in. And I put a note to myself, investigate your retirement plan. And then every time it popped up on the calendar, I pushed it ahead 3 months because I'm busy. I am not in the business of financial planning. I'm in the business of teaching about business law. And then finally, my salary starts going down. And I'm like, what the the hell happened? Oh, my retirement plan kicked in. And then I moved everything into the cheapest bond fund I could find because I don't like risk, which is absolutely not what you're supposed to do. And I know that. But the fact is that a professional financial planner spends time on that, and ordinary people don't. They once did like a survey of economists at like, I don't even know what like fancy school it was, and like 90% of them had their retirement plan in the default index, in the default fund for their plan, for their 401k or their 403b or whatever. So like, no, I don't think, and that's the people who are supposed to know. So no, I don't think education is worth it. What you need is actual guidance by an actual person who has actual fiduciary obligations and an actual more limited menu of choices, at least for the basics.
Yeah, I mean, I've done a lot of experimental work on financial literacy, and I'm not convinced that it's as gloomy as Anne suggests, in part because Anne's answer told you, look, there are things that she actually knows, and the fact that she chooses not to do them isn't because she doesn't know what they are, right? So two different things going on. You know, I mean, there are lots of people who know they're not supposed to eat sugary donuts and still eat sugary donuts, right? That's not a lack of nutritional literacy. But I think that, you know, I think there's a large population that doesn't know these things. I think there are ways to convey that information. And I think there are ways to make people better investors. And I think at the same time, Anne's right. There's a huge role for intermediaries to help. And those, you know, it's not just, Anne painted a sort of bad story about these incentivized brokers, but the most important intermediary for most of us in investing is our employer. Because our employer, number one, selects the funds that we have as options in our 401k plan. And that's true for us, and that's true for the cashier at Walmart. And that employer choice matters. The default option that the employer chooses matters tremendously, because that's what most people pick. And if you ask them why, part of it is, well, I'm kind of lazy. And part of it is, well, I think my employer's looking out for my best interests. I think they know more than I do. I think they're doing a reasonably good job. I trust my employer, right? And we have, from a regulatory perspective, we've paid absolutely no attention to employers and their role in mediating in this space. So I think that's tremendously important. And you talked about ESG funds not doing what they're supposed to do. That flags another intermediary, right? That flags the media. And you know what? The media isn't always reporting that information correctly. A lot of what people think about where to invest is based on what they read in the paper. And the media doesn't always get it right either. And the media has incentives for creating scandals and identifying greenwashing that, you know, are also a little bit suspect. So I think, you know, I think the story is a little bit more complicated than you suggest.
Thank you. Thank you. And we're going to move now to Professor Darren Rosenblum. Professor Rosenblum joined the Pace Law faculty in 2004, where he teaches contracts, corporations, and international business transactions. He serves as the faculty director of the Institute for International and Commercial Law. His scholarship focuses on corporate governance, in particular on diversity initiatives and remedies for sex inequality. Previously, Professor Rosenblum clerked for the U.S. District Court of Puerto Rico and practiced international arbitration at Clifford Chance and Skadden, Slate, and Flom. Professor Rosenblum has served as a visiting professor at Sciences Po Law School in Paris, Brooklyn Law School, American University, and Seattle University. He presented his pioneering work on corporate board quotas in English, French, Spanish, and Portuguese. He also served as the Wainwright Fellow at the Faculty of Law at McGill University. He's actually joining McGill this next year. And in 2011, he was also a Fulbright Research Scholar in France and performed a qualitative study on French quota for women on corporate boards, which he presented at the French National Assembly. And I have to say, it's a huge honor. He's a mentor, and we're working on a project together that you're going to hear about, and also with the Honorable Judge Michal Mongonem, who's going to be joining us later on a panel of presenting that project. So without further ado, Darren, the stage is yours.
Thank you so much, Anat. And Unfortunately, I was here for that intro, so I'm completely blushing. Um, and I'm very excited to share this work with you. Hopefully you all see my screen, my PowerPoint. Is that visible to you?
Yes.
Okay, good. As you mentioned, Anat, the three of us, you and Michala Gonen and I, are working on a piece directly about fiduciary duties, which Michal is going to present later today. What I'm presenting now is more about a direction I'm going, which incorporates the fiduciary duty issue. And so this piece called Legislating Corporate Diversity, New Directions, really tries to get at some of the core questions that are coming up with regard to diversity. So how are we regulating diversity? How might we start to regulate diversity differently now that it's becoming more commonplace? And then what are some of the problems with this? So let me so my argument here is that as legislating diversity matures, variations on how much and which identities matter will drive legislative innovation. The way I'll present my talk is first starting with a quick description of the quota revolution. Second, I'll talk about some modifications to the quotas or more of these same quotas and some of the critiques of these quotas. And then I'll move into the new directions, first exploring directions that focus on more identity, such as the California statute that was recently put into place for people of color and LGBT quota. And then I'll explore an opposite direction, which is less identity, including fiduciary duty and term limits. So the quota revolution, just to quickly summarize, and I think everybody is on the same page here, so I'm going to be very brief. But historically, initially, there were quotas for political contexts, eventually leading to over 100 political quotas around the world. And that development gave the idea to Norwegian regulators to come up with a corporate board quota to integrate the private sector, which had still reflected vast sex inequality, even though equality had been reflected in the public sector. And so Norway's quota was passed in 2003. It came into force in 2008. And since 2008, that means to say, in less than 12 years, we've seen a huge shift in global regulation of diversity, specifically sex diversity, in that a majority of the world's top 10 economies now have some sort of quota for women on boards. Of course, while these quotas have succeeded in integrating boardrooms, there are still some important questions. Does this diversity help C-suite diversity, which is where diversity really matters? Afraf Sharipur is doing some interesting work here. Does it advance other kinds of diversity, such as that of people of color, LGBT, class, etc.? And most of all, at what cost? What are the costs of these quotas? Some of the critiques of quotas that have been floating out there look at constitutional concerns. Joe Grunfest's critique of the California women's quota goes there. A lot of arguments focus on, particularly here in the United States, the point that the state should really stay out of these business decisions as to who should do what within the corporate governance structure. There are arguments that are interesting on tokenism, that, and this often comes from the right, that basically it's insulting to women or people of color to say that they can only advance if they're the beneficiary of a quota. The flip side of that argument is coming more frequently from the left is the creamy layer critique, which basically says that the beneficiaries of identity quotas tend to be the most privileged people within a specific group. So we've seen this happen particularly with regard to affirmative action. There's been a lot of literature on how Caribbean Blacks get more advantages than African Americans, for example. And we see this in other quota contexts as well. There are other questions like why privilege this identity over that identity? And this has started to come up as California starts to regulate beyond gender. And then most importantly, I think, is the unspoken resistance. And this is unspoken because I think diversity has become a sort of civic religion among educated people within the United States in particular, but really more broadly. And so it's anathema to say, well, what are the costs that are posed by some of these remedies to people who have privilege? But I do think it's worthwhile to pose these questions. What are the costs to men? What are the costs to white people of these quotas? And to think about those costs as a rational effect that we see happen through this kind of regulation. There are adaptations to quotas that have been adopted. And I'm not including this in the new ideas because they're things that are already in place. Quotas with sunset provisions such as Italy, quotas for one, the idea being that even just one person will bring substantial change, such as India's quota, again, AFRA, Offshore Report has written about that. Comply or explain regulation, which is the common law's answer typically to state regulation. And then especially, and of most interest to us here in this conference, private solutions, private equity, and in particular the ESG movement has really led a lot of efforts to integrate thinking about diversity, having diverse leadership. Funds have insisted on diverse leadership and made pushes in a variety of different ways. This is work that David Weber has pioneered and others have been looking into in very interesting ways. But I think it's worth noting that a lot of those efforts are in part at least to forego or forestall state intervention. And it's worth noting that purpose. Let's move on to the new directions. And this is where I'm adding some, hopefully adding some interesting ideas. So one direction is to think about more identity. And so here, while sex quotas do tackle significant inequality, women are half the population and yet hold less than 1% of the world's private property. We can think about, while there is a significant inequality tackled by these quotas, there is also the fact that a lot of women who benefit from these quotas are already quite privileged. And that's the resistance I often get to talking about quotas in feminist circles, that really you're talking about women of privilege. Let's focus on people who are underprivileged. And so, in fact, California focused now with its new quota on underrepresented populations. And by that, they mean people of color, which they define with a discrete but long list of different racial and ethnic minorities, and LGBT folks who are also underrepresented according to the statute. There's also, and there's really not regulation on this, but it's an important one to note, extraordinarily high levels of class exclusion going on. And that might be an interesting avenue to explore. One example of that would be education. So for example, elites typically do provide their children with elite educations. And so one way around that might be to insist on diversity of educational backgrounds. But there are problems with more identity regulation, and some of these critiques are things that I explored in a Forbes column I wrote about California's new quota. including unintended consequences, such as costs for men, such as questions of self-identification. There are also limits to the intersectionality theory, which is driving a lot of this change. So in the decades since Kim Crenshaw published her groundbreaking work in the early 90s on intersectionality, people have thought a lot about how discrimination does affect people with multiple oppressions differently and more significantly. But you also sometimes come up with what's called by Nancy Ehrenreich at Denver, the infinite regress problem, the problem that you can keep going with different kinds of oppressions and how they affect different people. And it creates problems in terms of really coming up with coherent solutions for inequality. Self-identification issues come up with regard to race. We saw the recent controversy around the GW professor or the Rachel Dolezal situation, but we could easily imagine this as well in the LGBT context, where people can come out even though they might not be queer, or people could be pushed to come out when otherwise they might not want to come out because of the incentive created by the California quota. There's also the reality that certain identities are fluid. And last, I'll note that the fact that diversity is agreed upon as a public value by so many of us does create some more doublespeak and reticence around frank conversation. Let's move on to the other avenue, which I personally think is more interesting and promising, which is to think about less identity. Why do I think it's more promising? Because I think that the reservoir of resistance to quotas runs very deep, and particularly among people who have privilege. But also the resistance to tokenism is broader than we might think among groups that might benefit from quotas. So what are the ways we can use less identity to get more diversity? One way is to impose a fiduciary duty on decision makers within the corporate sector, notably the board, to think about diversity in terms of their processes and both in terms of leadership promotion for the CEO level, but also in terms of instituting structures within the firm that advance diversity throughout the firm. The purpose of this, I think, in terms of the business goal, is to avoid groupthink, which creates a plethora of bad decision making. And we can think of many, many examples, including the VW admissions scandal, for example, in which companies that are run by a small group of like-minded and like-experienced people, typically white men, but they often also share a lot of other traits, including educational background and nationality, that the groupthink in which they engage is fundamentally harmful to good governance of firms. And so that the goal of good governance should be to use diversity as a tool to achieve better governance. One way to do this would be to adopt versions of the Rooney Rule. That is to say that every pool for every leader should include a diverse group of people. This would be a very soft way of diversification, but it would be nonetheless a step in the right direction. The idea here is for the board to think proactively about the value of diversity in order to advance good governance. Another direction, and this is something that I wrote about with Yaron Neely last year, is to use term limits to advance diversity. And so like with fiduciary duty, the goal is to improve governance. It recognizes that while empirics leaders might bring value, their presence also closes off new ways of thinking. To the extent that experienced former CEOs populate a board, that means that new understandings will not be present in the room as discussions take place. Our research showed that incumbency correlates obviously with men because men are dominant in the corporate sector, but we also found that firms with lower average tenure also tended to have more women on the board. What that meant is that higher turnover created higher sex diversity. And so that you could use term limits to get higher levels of diversity simply by forcing repeat games of hiring so that the increase in diversity in the pool actually filters up to the leadership level of the board and hopefully to the CEO. I will note that term limits are already in place in many other countries, and so this would not be a novel sort of regulation for the US to adopt. Next, I'll move to another idea, which is hybrid quotas. And this is something I've not shared yet anywhere. And so I would very much welcome your feedback here. The idea behind a hybrid quota is not to have a direct quota for a particular identity, such as women or people of color, et cetera, but rather to use term limits strategically to diversify the board. How could you do this? And this is really targeted at getting senior men or senior white people or senior white men off the board to create space for more diverse people. So the goal is not here to create a quota for the excluded individuals, putting the onus on those excluded individuals to join the power structure, but rather to say that people who already have too much presence on the board should face certain term limits. The reason that I thought of this is in conversation with corporate counsel at large companies, a lot of the concern that they voiced to me is that quotas, with regard to my term limits work with your own, was that these term limits ultimately sometimes force them or would force them to kick off some of the most experienced women who are leaders in their field. And that was a real cost to the firm's effective governance. And so the idea behind this hybrid quota or hybrid term limit, which might be a more artful term, is to get at that particular phenomenon. All right, let me wrap up here. The successive quotas underscores how this tool, sorry for the typo, how this tool can prove useful for broader issues. Indeed, California's laboratory quota that it passed this year for POC and LGBT is a good example of that kind of experimentation with quotas. But there's still a lot of resistance to quotas coming both from the right and the left, and a lot of undiscussed resistance to these quotas, which is worth taking into account to come up with new directions for regulating diversity. I've given you a few ideas for where that regulation might go, but I do want to underscore the role that private equity can and already does play, which is to think about state action and to proactively forestall that action by being more effective in their private sector governance efforts to foster diversity voluntarily. I'll stop there, and I look forward to your questions and hopefully hard critiques. Thank you.
Thank you so much, Professor Rosenblum. I just want to quickly give people an opportunity to ask you a question. I also have a question for you. I'm just reminding everybody, if you're one of the attendees, please send me a question in the Q&A. And if you are panelists, please raise your hand or send me a message on the chat. So I love your new idea. And I have just like a few questions for you, and that is with regards to the term limit. So I think it's great. I think it's new. I've never heard that before. So that's definitely a great initiative. Um, so is there like are you thinking more of like a sunset provision, and what's that term going to look like, and how are they going to um, decide, are there other things that should go, other factors that are going to take into effect here?
Well, so I think that the basic idea behind um, so first of all, I am an advocate of term limits generally without any identity component.
Okay.
Your own and my work both that work I think is pretty solid, and it and it comes from substantial literature, particularly coming out of political science, that focuses on the ways in which incumbency is fundamentally linked to privileged populations. And who are those populations here? It tends to be white men. So while our research doesn't at all look at race, partly because we couldn't get the data even with your own research budget, the data just isn't out there. But I do suspect fundamentally that term limits would create more racial and ethnic diversity, because I believe in this idea that that incumbency is fundamentally linked to a lack of diversity. Okay, so that's the first answer. I really believe in a non-identitarian term limit. That said, what I'm putting forth here as well, not instead of, but as well as, is a term limit that is focused on identity in specific contexts. The idea would be to put in term limits for example, men, so that effective organizations can keep their experienced diverse people and only push term limits on people who are in the majority, such as men or white people.
Great, thank you. Thank you so much. This is great. So I'd like to move on quickly to our next speaker, Bernard Scharfman. Mr. Scharfman is a senior corporate governance fellow at the Real Clear Foundation. He's a member of the Journal of Corporate Law's editorial advisory board. He's the former chairman of Main Street Investors Coalition Advisory Council and a former visiting assistant professor of law at the University of Maryland, and also here at Case Western Reserve University School of Law. He's also a former associate fellow at R Street Institute. He's written extensively on corporate law and governance. His most recent writing has included Liberating the Market for Corporate Control with actually one of my friend, Mark Moore. I think it's great. The risks and rewards of shareholder voting. And now is the time to designate proxy advisors as fiduciaries under ERISA. The undesirability of mandatory time-based sunsets and dual-class share structure. A reply to also two friends of mine, Bebchuk and Castiel. Enhancing the value of shareholder voting recommendations, how the SEC can help mitigate proactive agency costs. And honestly, the list just goes on and on. He's a very prolific writer. He's also written a number of comment letters to the SEC, the Department of Labor, NASDAQ, and the New York Stock Exchange. And he has blogs that can be found on the Harvard Law School's Forum on Corporate Governance and Columbia's Blue Sky blog, and Oxford and Duke's. I just want to also quickly tell the audience, this is a great opportunity to learn more about ERISA. So I'm very, very interested to hear what you have to say. So
thank you very much, Anat. Very nice introduction. Let me see if I can get this up here. Okay, here's my PowerPoints. Can you hear me? Annette, can you hear me?
Yes, sorry, I muted myself.
No problem. Okay, great. Okay, the title of my presentation is The Conflict Between BlackRock's Shareholder Activism and ERISA's Fiduciary Duties. There is already a white paper out there on my SSRN webpage. author page. So if you want to take a look at that, you can. But I think it's going to be extensively revised for purposes of the symposium edition of the case law review. Okay. Well, I think we all know that the big three, BlackRock, Vanguard, and State Street, investment advisors to index funds, have an enormous amount of voting power and influence. Okay. They also have investment stewardship teams, the big three. This allows them to not just aggregate their voting power and influence across funds for purposes of economies of scale and cost minimization, but also for purposes of coordinating their shareholder activism. And I'll define that in a couple slides. Late night commercials are great, but wait, there's more. I love that when I'm watching TV late at night. There's also this potential for uncoordinated wolf packs to be created. And that's if the big two or more of the big three have matching marketing objectives and engagement strategies. I won't be talking about that further, but it is something to think about. Okay, so how is this voting power created? Well, basically, it's beneficial investors like you and me who are delegating their voting authority to the mutual funds and exchange traded funds that we invest in, who are then turning around and delegating this voting authority to their respective investment advisors. This is just standard industry practice, which has resulted, of course, in concentrated voting power. Okay. One thing to note is that these investment advisors, even though they control all this voting power, don't have any economic interest in the underlying securities. So to me, this is just another form of empty voting. And this empty voting can create agency costs, as Gilson and Gordon would call them, the agency cost of agency capitalism. Okay. So in my paper, I focus on BlackRock's shareholder activism. Why do I focus on BlackRock? Well, they've definitely taken a leadership position in leveraging their delegated voting authority. How do they do that? Well, they do that through their shareholder activism. And I see shareholder activism as having three components. Rhetoric, primarily through the Larry Fink letters to CEO and clients, where he discloses BlackRock's marketing objective and engagement strategy, BlackRock's shareholder voting, and their engagement with our portfolio companies. Okay. BlackRock's marketing objective. Well, what is it? Well, it's the marketing of its investment products to millennials. And I didn't realize that until I read this very fine article by Barzuza, Curtis, and Weber. I think David Weber, who I think may even be presenting this article today, I'm not sure. And their focus is to market to millennials because they understand that over the coming years, there's going to be a huge wealth transfer, probably $24 to $30 trillion, give or take, from baby boomers and the silent generation to millennials. Okay, it makes sense to start focusing on them now so that they can have them lined up when they actually hold the wealth. BlackRock also understands that millennials are a different type of investor group. According to BlackRock, millennials see the primary objective of business to be the improvement of society, not just generating profits. Okay. So how is BlackRock going to market to millennials? Well, basically, they're going to demonstrate that they have shared values. How are they going to do that? Well, they're going to do that through their shareholder activism, which in my mind might sound cynical, is purely a marketing tool. Shareholder activism is going to help them maintain or expand their market share of the assets they have under management. They're also going to enhance their profitability by selling millennials ESG index funds that have relatively higher profit margins versus the standard like S&P 500 index. Okay. They also, I think, believe that millennials buy into the idea that they can do good, and that's BlackRock. They buy into the idea that that millennials buy into the idea that they can do good by stock picking. I personally think this is kind of an absurd idea, but that is a topic for another discussion. Okay. Well, we're all lawyers here, right? So we're actually interested in the law and how the law sees this shareholder activism. And my interest is the law of ERISA, Employee Retirement Income Security Act of 1974. And my initial question regarding ERISA is there a fact pattern where the fiduciary duties of an ERISA plan manager require it to investigate BlackRock's shareholder activism? Now, I'm not talking about BlackRock's fiduciary duties under ERISA, because in general, there are none. Okay. Unless BlackRock actually is managing a whole plan or part of a plan, it does not have fiduciary duties under ERISA, and so it gets a free pass on that. Okay. So what I'm interested in is how plan managers' fiduciary duties interacts with BlackRock's shareholder activism and how it must relate to it. Okay, so let's talk about ERISA's fiduciary duties. And it's very possible that most of you don't really know that much about it. I didn't know much about it until about a year ago or so. And I pretty much learned everything I know about ERISA's fiduciary duties from a wonderful article by Schanzenbach and Sitkoff that appeared recently in the Stanford Law Review. Okay. First off, about the fiduciary duties under ERISA. Well, these fiduciary duties are actually written in the statute, unlike corporate law, and they're very explicit. They're also very strict. Okay. For example, the duty of loyalty, the primary one. A fiduciary shall discharge his duties solely in the interest of the participants and beneficiaries and for the exclusive purpose of providing financial benefits, such as retirement income. Okay. And let me be clear, the exclusive purpose does not allow for non-financial benefits. That's just the way the law is written in the statute. Okay. Why are these fiduciary duties in the statute so strict and so narrowly focused? Well, basically it's congressional intent. If you're a textualist, you can ignore this, but I don't. Congress was obsessed with protecting plans from the financial harm that could happen from the opportunism that plan managers could apply to the plan. Okay, and this was generated, this congressional intent, by corruption of plan management that occurred back in the 50s and 60s. Okay. There is also a duty of prudence. The plan manager's principal responsibility in selecting investments is to act with the care, skill, prudence, and diligence. So what you get here, of course, is the prudent person standard. It also requires an independent and adequate investigation when selecting investments. And the implication here is very nicely stated in a quote from the recent final DOL, Department of Labor final rule on ESG investing under ERISA, where it says the duty of prudence prevents a fiduciary from choosing an investment alternative that is financially less beneficial than reasonably available alternatives. Okay. Okay, so what is the fiduciary duties that a plan manager must apply when it goes about its shareholder voting and engaging? Well, one thing is that plans directly hold equities, stock, voting stock totaling around $2.1 trillion. If anyone has better numbers than that, that'd be great. That comes from a recent DOL proposed rule. I'd like to see a breakdown on it, but I just haven't found anything. So how are plan managers going to approach this voting and engagement? Well, again, ERISA strict fiduciary duties apply. And so basically it means that a plan manager's voting and engagement must be viewed purely through the lens of enhancing the financial retirement benefits of participants and beneficiaries. Okay. Now, finally, I come to the fact pattern that I really want to focus on. Okay. Well, okay, plan managers can hold stock directly, but it also has the option of investing in or making available to self-directed accounts, mutual funds, and exchange-traded funds. How much plan managers hold now, I really don't know. If anyone has data on that, that'd be great, especially equities. But in any event, if they do invest in mutual funds and exchange-traded funds, the voting and engagement are now in the hands of investment advisors. They've delegated this away through this investment, okay? Now, it's interesting to note that this fact pattern was not covered in the Department of Labor's proposed rule on proxy voting. I thought this was a glaring omission. And so when I sent in my comment letter, I told them you really should focus on this fact pattern. Given that they're going to have to turn things around really fast, I doubt they're going to do it, but well, who knows, we'll see, okay? So the issue, under this critical fact pattern of plan managers investing in mutual funds and ETFs, does a plan manager, let's say it's BlackRock's, does a plan manager have a fiduciary duty to investigate BlackRock's shareholder activism? Okay. Well, I say yes. Okay, and I've come up with a rule, call it Bernie's rule if you like. A plan manager, as part of its investment selection process, now we're talking about mutual funds and ETFs, and general oversight function, has a fiduciary duty to investigate an investment advisor's shareholder activism. Okay, and I have two rationales for that. One is a duty of prudence rationale, basically for completeness of analysis. The activism is now part of the investment, and a plan manager in its investment selection process really needs to assess that activism for its potential to harm or benefit the plan, okay? And there's also a duty of loyalty rationale, and I'm still working on this one, but I would think a plan manager would want BlackRock's activism to be consistent with how a plan manager would have engaged, would have voted and engaged if it had retained its voting authority and had not delegated it away. Okay. So let's take an example here. Let's investigate BlackRock's engagement strategy. And this is very, very interesting, but they've been very public about it. Their strategy is one of benefiting various stakeholders who most appeal to millennials. Okay. Stakeholders impacted who are going to be favored are going to be impacted by climate change, gender equality, global supply chain and operations impacted by COVID-19, and racial equity. Okay. How are they going to enhance this make sure their influence is actually heard? Well, they're going to threaten to vote against management if they don't comply with their strategy. Okay. This is basically all what I found just reading, Larry Fink's 2020 letter to CEOs. He pretty much laid it out. Okay. So when you look at this activism, it's not being done solely in the interest of participants and beneficiaries and for the exclusive purpose of providing financial benefits. Okay, that's pretty clear. Okay. So it does violate duty of loyalty. Okay. Now, besides that, I think you should expect BlackRock's engagement strategy to actually reduce financial benefits to participants and beneficiaries of an ERISA plan. Why is that? Well, BlackRock is extremely resource constrained. Okay, and I've been yelling and screaming about this for about the last year or two. No one's listened, but I'll say it again. This resource constraint creates, in my mind anyways, a strong presumption of BlackRock being uninformed when it votes and engages. Okay, look at their investment stewardship team. It's actually, I think, still the largest of the big three. It's composed of approximately 45 professionals globally. Well, only 22 are based in the US. 12 of those have a global focus and 10 have a local focus. Of those 10 with a local focus, I'm pretty sure that includes not just the United States, but also Canada, which has pretty close to the same number of public companies as we do, I believe. In any event, I saw this quote recently. It sort of backs us all up about not being informed, where a BlackRock analyst was quoted as saying, I cover industrials and materials in the US and Canada. I cover approximately 800 companies in those sectors, and I'm responsible for the engagement of proxy voting with those firms. Wow, that's really amazing. You know, a good, I guess, security analyst will be covering 10 to 15 companies per year, maybe 20, I don't know. But, you know, compared to 800, wow. I mean, this 800 means, let's face it, this analyst is going to be uninformed about any of the portfolio companies that it covers. It just has to be, okay? All right. Moreover, BlackRock is really in the worst, you know, possible position to interfere with stakeholder relationships. Well, why is that? Well, a couple reasons, but primary one is actually a quote from Charlie Korsman. The whole philosophy of index investing is that it is unnecessary to know anything about the firms you invest in. And this is the same Charlie Korsmo, who I believe is sitting to my west 360 miles away in Cleveland, attending this conference. That's a great quote. And it's very, very true.
Thanks for the plug, Bernie. I appreciate it.
You're welcome. There's also been empirical confirmation of that as well. According to Bebchuk and Hurst, we reviewed all of the examples of behind-the-scenes engagements described in the Big Three stewardship reports. We found 0 cases where engagement was described as being motivated by financial underperformance. This should not surprise anybody because they really are truly uninformed about their portfolio companies. Okay. Here's an example. Okay. BlackRock's focus on global supply chains. Okay. I think originally this focus on global supply chains by BlackRock, which preceded the pandemic, was really just signaling ethical values, and nothing wrong with that. They wanted to signal their values that in regard to deforestation and inhumane working conditions, and perhaps the engagement went like this. We don't know what's specifically happening at your company, but please consider, you know, these type of things. And that's fine, okay. But since the pandemic has occurred, there's been increased focus by BlackRock on global supply chains. And I think it's basically simply, it's because it provides an opportunity to advocate for millennials. Well, why is that? Well, the global supply chains, if the pandemic has exposed weaknesses, well, a good way to deal with that is to make your supply chain less global and more domestic, okay. What would that do? Well, that's going to enhance employment opportunities for millennials. The group, the investor group that's so far, or the demographic group that's so far, is really taking it on the chin financially versus everyone else. Okay. In any event, whether that's true or not, I think it is though, where does BlackRock's expertise come from in weighing in on a company's global supply chains? It really has no expertise. So I think that's pretty scary. Okay. So what's a plan manager to do? I would think after investigating this engagement strategy, it simply may decide to exclude BlackRock's index funds and seek out readily available alternatives, okay, but without the engagement strategy. Okay, final slide. So under ERISA, what kind of shareholder activism would actually meet a plan manager's fiduciary duties? What kind would actually enhance financial benefits? Well, I think it's when BlackRock's activism would mimics the activities of hedge fund activists. I love hedge fund activists. I love the market for corporate control. Read my recent article, Liberating the Market for Corporate Control of Mark Moore. But you know, what a hedge fund activism does is that it invests a huge amount of resources into financial analysis to become informed about a portfolio company. Then it invests in more resources in coming up with a corporate strategy that would try to enhance shareholder value, that they think would enhance shareholder value, And then they go to the company and to their other shareholders and advocate for that change in corporate strategy. Okay. So that would, I think, is consistent with ERISA. Okay. And I think this approach would make Bebchuk and Hearst happy. Their recent article, which I actually quoted on the previous slide, that appeared in the Columbia Law Review, I think it's 2019, that's what that article really was all about in regard to investment advisors to index funds becoming super huge hedge fund activists. I still think it's a wild idea, it would take a major change in the business model of BlackRock or State Street or whoever to actually, become that. But it is consistent with ERISA. So that ends my presentation. Thank you.
Thank you so much. That was amazing. I learned a lot. And I just want to say a few quick things for the audience. First, in 5 minutes, my amazing colleague, Professor Courtmore, is going to continue with another panel. But if you'd like to stick around, please, I know we have some questions for the panelists. Bernie, I have some questions for you. We also have some questions for Darren. But I actually wanted to start with Professor Weber. David Weber, I know you had a question for Bernie. Yes, hi.
I did. Hello.
How are you?
Good. How are you?
Good.
Hey, Bernie.
Hi, David.
I feel so, Bernie. It's nice to finally meet you. We've been exchanging on LinkedIn and email for years, and I didn't make a slideshow. I am going to present that millennial paper. I didn't make slides, but I see I could just borrow yours if I need them. For today's talk, even though I appreciate the, I know you're using them, you use the paper for nefarious purposes.
Yeah, of course.
but in any event, so really interesting, really provocative paper. I actually did just want to push back a little bit on some of your claims, or really actually on some of the Sanzenbach and Sitkoff claims about the exclusive benefit rule under the U.S. Department under ERISA. It feels churlish to say something like this, given that you've already put a few slides in about one paper, but I did want to direct you to another paper that I published a few years ago called The Use and Abuse of Labor's Capital, which was published in the NYU Law Review. And the reason that I mention it is not to say that this paper provides definitive proof that Sitkoff and Sanzenbach are wrong. It doesn't. But what I point to in that paper is a few cases that have a more capacious view of the exclusive benefit rule than the one that they present. So I'll just give you a couple of quick examples. There's an 11th Circuit opinion that I cite. I actually had the briefs from DOL dug out of the warehouse down in the 11th Circuit, but there was an 11th Circuit case, I believe it's called Donovan. I can
Oh,
say
yes. I'm familiar with that, sure.
So in that case, what happened is a pension fund offered below market rate home loans to their contributors, to their participants. And DOL sued, saying you're not maximizing returns by definition in offering below market home loans. And they said that violates the exclusive purpose rule. And they lost. The 11th Circuit found that was okay. And there's another case in California where the trustees agreed to lower contributions to the fund by the employer in exchange for the employer not firing workers. So there was a situation where trustees took into account jobs in a way that hurt the fund, and that too was blessed. So my point is, I think that it's a narrow point, but I think it's an important one that the exclusive purpose rule, and there are cases that come out in favor of the Sanzenbach-Sitkoff interpretation. But the point is, I think it's still debatable about whether exclusive purpose requires that narrow focus on returns that Stanford Law Review piece argues for. So in any event, it's a small point, but I think it does affect a little bit the analysis in terms of what kinds of things can be taken into account when thinking about these fiduciary duties.
Yeah, thank you.
Okay, that's great. That was great. So thank you so much. Bernie, and I have just another question actually from the audience, but that was for Darren. I don't know if Darren's with us, and I believe that Professor Korsmo's, oh, Darren, you're here. Hey, how are you?
Right.
I just have one question for you. And that is, just a second, I'm just opening it up. Sorry. Here, sorry. And that is, can any of these methods be discussed without allowing for decision-making best practices? Otherwise, new ideas from diverse people.
Otherwise, new ideas from diverse people. What? Sorry.
Can be ignored, or they
Oh,
can be pressured to behave like everybody else.
Yeah. So this is it's a real challenge. So I don't know if you remember, there was the slide in which I mentioned that some of the quotas are for one person, like India put in a quota for one woman on each board. And that quota did do some work, which is that essentially it makes the board no longer an all-male space. But it doesn't necessarily create a space for a voice coming from an excluded group. And so the notion of critical mass here is really essential, coming from Rosabeth Moss-Kanner. The idea is basically that in any organization or decision-making body, there's going to be a group of people who are more of the insiders, and for any of the outsiders to have a voice, they need to have about a third presence on the board. And so that notion of critical mass is what underlies the reason that Norway went with a 40% quota, and that all of the quotas, or many of the quotas for women in particular, have focused on the 40% number, or Germany put it at 30%. The idea of critical mass is that without enough people who are outsiders, their voice will be excluded. Now, the other question that's embedded in that question is not just the critical mass question, but also the question of co-optation. So if, for example, we think that an outsider joins the board and then they become part of the way the board operates, including its groupthink, then it does create the possibility that the new identities or the new diversity doesn't actually raise a new perspective in terms of the thinking. And that is a genuine challenge. I will say, I think that's also likely an advantage of some quotas, is that they create a rush of a rapid increase of new members, during which those people can develop their own voice that's independent from the established one on the board.
Thank you so much. Thank you. This is great.
Thank you.
Thank you. So I wanted to again thank my amazing panelists, Darren and Bernie and Jill and Anne. Thank you for joining us today. We will have a 5-minute break, and then Professor Korsmo is going to take on the next panel. Thank you, everybody. We'll see you soon. With regards to some administrative matters, again, there's one CLE form. The number of the CLE hours that are offered is 5.5, not 6. Okay. And if you have any additional questions with regards to CLE, I will give you an email. academiccenters@case.edu. Okay. So please feel free to email them with any questions. Thank you. We'll see you soon.
But we're going to get started on panel 2. For those of you who don't know me, I'm Charlie Korsmo. I'm your friendly neighborhood moderator for this session. I teach and research corporate law and securities law here at Case Western. And because we are a little bit behind, I'm going to change up the structure a little bit from the first panel, and that I'll introduce all of our four speakers up front here, and then each one will have 15 to 18 minutes or so to give their presentation, and then we'll do questions sort of all at once at the end. Now, in this session, we're going to be talking about, our speakers are going to be addressing the implications of the growth of index funds for corporate governance and for stockholder activism, which in my opinion is a fascinating topic. I mean, do index funds, and we saw a preview of this in the first panel, right? Do index funds offer a way for overcoming the collective action problems that typically have plagued stockholder oversight and offer a way to ameliorate the agency problems that are associated with corporations, or are they layering a new agency problem on top of the old one, right? So we have a terrific panel to discuss these issues. Kind of nice mix of government, private practice, and academic here. So first up on the government front, we have Cindy Alexander, and Alexander is a senior financial economist at the Office of Asset Management, the Division of Economic and Risk Analysis at the SEC. Prior to that, she was an economist in the Antitrust Division at the DOJ, and has also served on the Council of Economic Advisors. Earned her PhD in economics from UCLA. Has published widely on principal agent problems in economics and finance. So we're delighted to have her with us. After Cindy, we will have Suzanne Hanselman. Hanselman's a partner at Baker Hostetler, a member of the firm's corporate governance and securities practice team. She is an experienced counsel for major companies on a large array of corporate governance and securities law issues, and helps them deal with shareholder proposals as well. She is an adjunct professor at Cleveland Marshall here in Cleveland, and also guest lectures right here at Case Western Law School. So it's good to see her too. Third up will be Jennifer Lewis. Ms. Lewis is counsel at Jones Day and also advises major public companies on aspects of corporate governance, including advising boards on dealing with shareholder activism and related governance matters. And she is a graduate of our humble law school here, Case Western Law School. So welcome back to Jennifer, and thanks for being here. And then last but not least will be our academic, will be David Weber, who you saw a little bit of in the first panel. He is a professor at Boston University School of Law, also teaches occasionally at Harvard Law School, and has published widely on corporate law and corporate governance topics, and not only in academic journals, but also in major popular outlets as well. So thank you to all of our panelists for being here. Again, if you have questions as a non-panelist, as a panelist, feel free to just sort of jump in with questions or send me raise your hand. But if you are in the a non-panelist, just put it in the Q&A at any time during the session, and I'll be able to put them to the panel at the end. Okay, so let's start with Cindy Alexander, and I'll send you a little private chat when you've got 10 minutes done, and another after 15 minutes.
Thank you, Charlie. Can you hear me?
Yes.
Excellent. Thank you so much for inviting me to the organizers to this panel today, Juliet Martin, Anat, and in this panel. I learned actually quite a lot from the first panel from listening to Anat, Jill, and Darren and Bernie discuss fiduciary duty, and I think you'll see why I found that panel so interesting from this presentation. There is one difference between the perspective I'm going to bring here and what we heard in the first panel, and that's that I will be focusing on the perspective of how did we get to where we are? Have things changed over time from the past to now? And what that means is that I'm going to abstract away from the ideas of how to make things better. And one reason that we do that in analyzing regulation at the SEC is it's always very important for all of these rule ideas to start out with an understanding of what we call the baseline. what is the starting point? And then when we analyze the proposals that people are talking about, usually it's relative to the baseline. So I suggest this is a useful place to start out. I want to focus fairly narrowly on a question, which is, has the rise of passive investing changed corporate governance? Actually, that's one question. But when I started looking at how it's changed corporate governance over the past, I realized that there are so many things going on. Let's focus on this one thing I think is a little neglected and is worth considering for a moment. And that is the question of, has the rise of passive investing led to an improvement in corporate governance? And in particular, the more important part is the smaller font in my slide. How could this occur and what are the limitations? So of course, nobody needs to be reminded there's a difference between a natural person and an institution. I'm not the SEC. I'm an economist on the staff at the SEC. So my standard disclaimer applies. The SEC disclaims responsibility for any private publication or statement of any employee or commissioner. This presentation expresses the author's views, that would be me, and does not necessarily reflect the views of the commission, the commissioners, or other members of the staff. What am I going to do here? And this is a short presentation. Very simple objective. So the starting point for understanding any effect, when we're talking about, is there an effect of passive investing on corporate governance, is to understand, first of all, what do we mean by passive investing? Second, corporate governance. Here I will explain how I think of it. Then what are the channels for influence going from passive investing to corporate governance? And I'm going to focus on the channel for improvement. I want to understand, what would that look like? How does that operate? And then of course, what are the limitations, which gets us to the glass half empty versus half full type of debate that I think is going on in the literature. And then I will go to questions and research, and I will have some questions about fiduciary duty, and I'm hoping that people from the first panel will be able to join these issues, or else contact me offline afterwards. So when we think about the rise of passive investing, what do we mean, or what do I mean, and what do I think of? I think about how we've observed trends of increased retail investment into index funds over the past decade. That involves substitution out of actively managed mutual funds and into ETFs and index mutual funds primarily. Now, index funds are known as passive funds or passively managed funds, and that has to do with a greater reliance on automation in tracking an index than other funds. And this results in lower costs of asset management. It allows the asset manager to compete profitably for retail money by offering lower fees. So what I observe here when I start thinking about the rise of passive investing, are there two trends, not just one. One is the rise of passive investing, a shift of retail money into index funds. And I think about it, ETFs and index mutual funds primarily, in the United States at least. And I know there are variations of this in Europe and other places. The other thing I observe is the emergence of large asset management companies onto the landscape. And here I think about this as indicating the presence of scale economies in the management of index funds. So I'm mindful of that there's a change in the organization of these markets at the same time the retail money is moving. Now we get to the second point. What is corporate governance? What do you mean by that? This is review of what I could hear from the first panel. This is familiar to everyone, but I think it's always useful in thinking about these things to be mindful of the scope of the system of corporate governance, a fairly broad scope. So corporate governance, I remind ourselves that it's a system that guides the actions of managers and thus the behavior and performance of corporations. It provides a monitoring. We always think of it as monitoring. Monitoring could mean many things, and other solutions to the principal agent problem in the corporation that everyone studies in corporate law. It rests on a foundation with several parts. The part I will focus on right now is the internal governance structure, which includes share ownership and related rights to engage with the management of the company through voting or communications to exercise influence on things like board composition, compensation, and other things. Those things will be a discussion at the end of the day in the last panel, I think. There's also external market competition as another component of corporate governance, part of the system. The managers of the company are sensitive to the labor market pressures on them. There's product market competition that's important that will come up in the next panel on common ownership, we'll skip over that now. And there's also law and regulation that is a source of discipline. We have disclosure regulations, enforcement mechanisms. And then when corporate governance, there are concerns about corporate governance, you'll see major reforms to the law as opposed to waiting for external market competition to create a solution. So I'm going to focus on external governance structure, but also here I want to mention that there may be changes in law and regulation that have caused us to see the results we see today. And I'm looking for any comments that people might have on those that I might be missing that might be important. So when I go back, when I think about, sorry. So next I'm going to what is the connection? Passive investing and corporate governance, how are they linked? So we've talked about what is passive investing, what is corporate governance, what's the connection? Well, here I think that it's important to start by distinguishing between two different types of monitoring that outside investors provide. And this joins some of the issues from the first panel. So the rise of passive investing affects corporate governance through its effect on share ownership and related monitoring that they provide. And I distinguish between specific engagement, which involves selecting companies for targeted intervention, and here I call that activism, and general engagement, in which there's monitoring of companies for compliance with norms and standard practices. Here I call that stewardship, to add value. So now we look more closely at each of these in turn. Again, I put this in quotes. This is how I'm thinking of activism. It is a targeted, firm-specific sort of engagement through the exercise of voting rights, and it just takes distinct forms as seen through the lens of the prior literature. One is hedge fund activism that involves proxy contests, 13D filings by holders of 5% or more of stock that are expressly seeking influence. And in filing a 13D form, as we know, there must be an expression of interest in influencing the company. Versus shareholder activism. In that case, we have shareholder proposals that are advisory and submitted by shareholders who have less than 5% of the stock, or passive investors with more than 5% that file a Form 13G. So here I see two different types of activism. I'm looking at through what channel could passive investors exercise influence, or in particular, how could a change, what's the difference in difference? How could a change in passive investing lead to a change in activism? From looking at the literature, it seems that there's evidence of an effect of the hedge fund activism on corporations. It's well documented. That literature focuses on share value, and there's less evidence of an effect of other forms of shareholder activism on corporations, where I'm talking now about having an impact on the principal agent problem of the company that's targeted. And so here I'm going to reach a conclusion that there's limited evidence of an impact from targeted interventions by passive investors into portfolio companies. And so there's a limited potential for a change in passive investing to cause a change in governance through this particular channel as of today. And so because of that, I don't really see how a change over the past in the amount of passive and money in passive investing could have led to a change in governance impact through this channel. Now, here I want to note and flag that this may be changing. We are seeing an emerging literature on how voting is a form of communication among shareholders, so that the votes cast by holders of smaller amounts of stock can provide signals that get picked up by other hedge fund activist channel. And I can see that this is a subject of emerging research. At the same time, as of now, this doesn't seem to be a very fruitful channel to explore if I'm looking for how there could be an improvement or any change actually in the impact of the shareholder channel on governance through the rise of passive investing. So I turn to stewardship. By stewardship, I have in mind that asset managers monitor, generally engage with portfolio companies through their stewardship operations. Why would they do this? Well, there are benefits that accrue to fund shareholders in proportion to their share ownership, so that the fund managers may participate in the gains through fees and repeat dealing or other reputation mechanisms. I'm looking for the incentive here, you can see. And so I think the larger scale fund managers have greater potential gain, from monitoring effort. If I look at the cost to the larger scale fund managers may reflect scale economies in monitoring. The larger asset managers may face a lower cost of monitoring. An additional company or industry, as they add funds, add to their size of their portfolio than other managers or diffuse holders. So with these things in mind, we have the potential for economies of scale in fund stewardship at the management company level, leading to more intensive monitoring of portfolio companies than previously. And this is all reflecting the idea that the monitoring occurs at the management company level, not at the fund level. So the result. Passive investing, this is a proposition and a result coming from the observation that passive investing has led to a change in the structure of equity ownership. More share ownership is under management by large asset management companies and less by smaller managers or diffuse retail investors. That gives us increased scale of asset management companies. We have scale economies in fund stewardship operations, and this gets us greater intensity of monitoring of portfolio companies, with the result being potentially more effective corporate governance. Now for the limitations. Basically, this solution replaces one problem with another. We now have lesser concern about collective action problems of diffuse shareholders in portfolio companies. So we have an improvement from the rise of passive investing relative to where we were before that in the markets. At the same time, as evidenced by the literature that's come up around this phenomenon, we've increased concerns about the quality of the stewardship that asset managers provide as delegated holders of stock, along with questions about the other effects that are going to come up in the next panels. So with this, I'd like to end with some questions for discussion and further study, focusing on the gains that come from stewardship operations of asset managers. We end up with these questions of what's the source of the fund management company incentive to monitor and engage? In particular, fiduciary duty, how is it enforced? Fee-based incentives, how do they affect stewardship operations? And then repeat dealing and reputation, since we know that the management companies are branded, there's a plausible repeat dealing reputational channel here. What is the role and the effect of that channel in this setting? These are my main questions. I have additional questions from the prior panel that come to mind, and that has to do with what is the monitoring technology. I see Bebchuk and Hurst's findings. At the same time, I think that the attention to counting up the number of people assigned to different roles in the asset management company is a first step. And I would like to see a fuller explanation or exploration of how these asset management companies do engage in monitoring is a further exploration of this. And there are also some questions about There are also questions about how closely the monitoring objectives of the asset managers align with the shareholder preferences. And if there's a misalignment, how does the portfolio company adapt? And that goes straight to Bernie Scharfman's question. I agree with that question. I think it's a very important one. Thank you so much.
Thank you very much. I appreciate that. Again, we're going to hold questions till all four panelists have presented. But if you have questions, feel free to put them in the Q&A at any time. So next up is Suzanne Hanselman. So Suzanne, take it away.
Sure. And I guess, Cindy, are you still sharing your screen? Because it's saying I cannot yet.
She just stopped sharing.
I took it down.
There you go. And Cindy, you can turn off your microphone too. There you go.
Okay. Well, thanks everyone for being here. The opportunity to be here today. I've actually learned a lot too. I mean, as has been pointed out, I come from this from a different perspective as a practitioner, dealing with mostly with issuers and companies and how they sort of are focusing all this and how it's modeling their day-to-day behavior. And so I do think it's interesting. There's some different perspectives. Hopefully this won't be too repetitive. I know some of these issues and topics we have covered already this morning, but I kind of wanted to lay the foundation just on these concepts of shareholder activism, the impact on corporate governance, the role of institutional investors. Jennifer, after me, is going to go specifically a little bit more on the influence of the big three and the index funds. And we have talked a little bit already about proxy advisory firms, but also their role in all of this. So, and I like Cindy's concept of active shareholders versus stewardship. I think sometimes we use the term activist shareholders and maybe something a little bit softer, like highly engaged shareholders. So when we talk about activists, yes, we are usually referring to an individual or a group of individuals who are purchasing shares in the company with the intent of putting pressure on the board and management, basically generally to advance a specific agenda. You know, some of these will go into detail a little bit, but sometimes these range from transactional type financial demands to what most of the focus of today's program on, what I would say, you know, the non-financial demands, corporate governance changes, ESG issues. And so activist shareholders generally will engage with management, but oftentimes are using tactics to garner support from other shareholders. From our perspective, what we're usually monitoring, as you know, Cindy mentioned, filing of 13Ds, obviously, then a filing or an amendment to 13D puts everyone on warning that something in this. Generally, though, these outreaches are done typically initially from a letter to the board requesting the did it stop sharing? Can you see that it's sharing? Because it told me it stopped.
No, we can't see it right now. So if you've got slides.
Let me try to do that again. I'm not sure why. How about now? Is it back up?
Not seeing anything, no.
All right, well, I apologize. I do not know why, because it says it's here. It's right in front of me. So I don't know if we have a tech person on who can assist with that. I mean,
yeah, I'm Suzanne, I'm on here, but unfortunately I can't see what you're seeing.
Once you,
okay, well, I'm seeing my slide share.
once you pick your slides, click share. It's a blue button in the bottom right-hand side of that screen that should show all of the different slides.
Yeah, I'm on a different, sorry.
Go to share screen at the bottom, which is in green. Pick the slides that you want to share, highlight that. And then in that window, there should be a blue button at the bottom that says share.
Which is what I'm not seeing that. So
you clicked on the red or green share screen button.
Yes, I did that.
And what comes up?
When I do that, I can see my presentation.
Okay, there should be a step in between that where you choose that presentation.
No, I'm saying it gave me the opportunity to choose that presentation, and that's what I'm showing as being.
Okay, and then.
And so what I'm saying is I'm seeing.
Okay, we're seeing it now.
Now we're seeing it.
So if it flies off again, let me know. Sorry about that.
Will do.
anyway, so initially this does start with contact directly with the company, oftentimes requesting the opportunity to meet with management, more increasingly to meet with members of the board, specifically the independent members of the board. When we talk about, as Cindy said, more of the, what we'd say, highly engaged or the stewardship investors, that's really the use of Rule 14A8, which I'll talk about. There's also the opportunity to conduct vote no's or withhold campaigns, because obviously if you want to put, I can tell you from working with boards, if you want to put pressure on a board, you know, companies do publicly disclose the support that board members get as a result of elections, and board members are very sensitive to having, you know, a less than substantial support. Also rising, and this is interesting, I think, because the SEC, we're going to talk a little bit about Rule 14A8. It's already been discussed, but some of the changes. But the SEC even did in that comment on the other methods for shareholder communications these days with social media, other platforms. And so, you know, looking at the rules that are right now sort of regulating shareholder communications. On the more activist side, and this is when, you know, probably what we oftentimes, I mean, from a company's perspective, the sort of extreme is the actual engage of a proxy contest for representation on the board. You know, generally those oftentimes these days just, and a lot of these initiatives really do end up in a negotiation. And in fact, you know, this past proxy season of the 4 companies I was working with that all had a threatened proxy contest, all 4 ended up negotiating with the proponent to basically put representation on the board. And then, so I did want to talk, so shareholder proposals, because that's where a lot of these initiatives begin. And as has been discussed, shareholder proposals is the SEC rule that basically allows a shareholder to include a proposal or resolution in the company's proxy statement to then put it in front of all shareholders. And obviously that's an effective tool because it is the ability to influence management without significant cost to the proponent. The way 14AA works, I mean, there are a lot of potential challenges for including a proposal. The SEC limits the topics that are proper for a proposal. There's some procedural requirements that recently have been amended. We'll talk about that. Most importantly, the resolutions are always framed as precatory or non-binding. You know, for example, we recommend that the board adopt a policy on board diversity, et cetera. So not really necessarily making a binding action. And as you're probably all familiar, there is the possibility of a company to seek no action position from the SEC if they believe they have proper reasons for excluding a shareholder proposal. And I can tell you from the practitioner standpoint, dealing, and Jennifer probably spends a great amount of time on her dealing with this too, beginning about this time of year, because a lot of times this is when deadlines for shareholder proposals for the next proxy season start hitting. You know, this takes up a significant amount of time and the attention of companies and their management and counsel. There has been criticism in recent years that because some of the thresholds for putting shareholder proposals forward weren't amended for I think 20 years, that really the balance between you know, the balance of interests had kind of been shifted. The SEC, it's just discussed, and it will be, I think it will be interesting how this impacts the number of shareholder proposals that are received, because currently the requirement is that a shareholder have at least $2,000 or 1% of the company's securities for a 1-year period for eligibility. And as you can see, the SEC in the amended rule came back with a tiered approach that's based on the significance of the holdings balanced with the length of holding. So that 2,000 threshold is still the minimum threshold, but a shareholder would have to hold those shares for at least 3 years. And then as you can see, it just tiers. This also, I think, was alluded to. Shareholders can't aggregate their holdings with those of other shareholders to satisfy these new ownership thresholds. And there've also been some amendments to how frequently a proposal can be put on the proxy statement. For example, if it doesn't gain enough support in 1 year, that shareholder may have to back off by putting that proposal on in the next year until it satisfies, garners certain levels of support. So some have seen these as significantly restricting the voice of minority shareholders. I think, like I said, we'll see these. It'll be a while. The amended rules don't apply to this coming proxy season, and so. And then there is a phase in of the ownership rules. So we may not see the full impact for a couple years. These are the types of agenda items that are usually brought forward by activist shareholders to affect change. You know, as I said earlier, kind of the ones on, I would say, the merger, the transactional, the financial, strategy, operational. Those usually are dealt with by the activists that are really coming in and looking to try to make oftentimes like a short-term change. For example, trying to get the company to declare a dividend, look at what it's using its cash flow for, maybe trying to spin off a significant, an underperforming segment of the business. That's not really what we're focusing on here. It really is sort of this bottom quadrant, corporate governance issues. And, so this is just kind of some statistics. It's interesting, 2020 was a little bit down as far as shareholder proposals and activist targets. I don't really know, I don't really think, at least for shareholder proposals, we can blame the COVID on that, because most of those, as I said, most of those proposals are due, in the fall. We'll see what happens this year. I mean, I do know, like, for example, so the proxy season hit just as a lot of the government shutdowns hit. That did impact a lot of the work in this area. I think some shareholders were pretty understanding of management's having to sort of focus on different issues right now. And at least in my experience, we're willing to kind of back off on some initiatives. Some companies ended up having to postpone meetings. So this year was a little bit just sort of disrupted, and we're waiting to see what comes in. A lot of times these initiatives, as I've said, end up in kind of a negotiated settlement. So it does end up in the shareholder proponents usually getting what they set out to achieve. But, one of the downsides is that a lot of times that's done, without any sort of public disclosure of it, and without the ability of other shareholders to sort of weigh in on that. When we talk about how the proposals have impacted governance, I've been practicing 30 years now, and I think a lot of these initiatives, it is kind of interesting how they come into play. I mean, usually it starts with targeting large cap companies and S&P 500s. I think, these corporate watchdogs and some of the more, what we call the stewardship, have really pushed best practices for companies. And, eventually, I think one of the most significant things is clients that, and you can see this when they, clients that get selected to be in the S&P 500, and how that almost immediately, dramatically, certainly raises their profile and makes, I think some companies have been caught off guard on the significance that means and how much attention they now have to pay to these issues. Some of these proposals eventually become subject to regulation. I think there was a time that, say, on pay, where shareholders had a chance to weigh in on executive compensation. There were a lot of shareholder proposals that now is required SEC disclosure. On the opposite side of that, there was SEC regulation on proxy access, rules that it would allow, similar to being able to put a proposal in the company's proxy statement, the ability for shareholders to actually put their own director nominees in the company's proxy statement. That rule was vacated by court action, but proxy access is pretty much the standard now in the S&P 500, and that is as a result of shareholder proposals that oftentimes pretty much adopted just what the SEC had put forth. And then there's oftentimes, some of these governance issues, I think, become so widely accepted and adapted that companies they just are, at least the clients I work with, they're just adapting some of these before they even get any kind of proposal on it, just because they realize that it's going to eventually, they will get a proposal and they are more inclined to just adapt it. For example, majority vote for the election of directors. So this is from ISS, these, if you look at the last, 20 years, these are kind of the governance proposals. As I've said, for S&P 500 and large cap companies, most of these are in place now. And what we've really seen since then is sort of the move towards ESG issues, which I know is going to be a topic for a later panel. But just kind of initially what we're seeing, I think this is an area where at least from my perspective, companies aren't as willing to put this fight in front of the shareholder base and are much more inclined to work with investors on these issues. And we are seeing the result of that, a lot of increased disclosure, voluntary disclosure on some of these issues, looking at their board diversity. I do think this has clearly impacted, at least from my experience, how boards are operating. I think in the last several years have made more of an effort to be in front of these issues and not reacting, being a little bit more, having some idea of what they're doing before shareholders even approach. And I think there are a lot of the diversity. We talked about board diversity. From a corporate perspective, it is something that they are looking at. Most companies now do have some type, they haven't not necessarily adopted like a Rooney Rule, but they are looking. One thing is, and I know there's organizations that help with this, is just, it's interesting because the other things that institutional investors and proxy advisors are concerned with is board overboarding, where a board director serves on too many boards. And we're actually finding this to be an issue with diverse candidates because they're so high, they're in such high demand to serve on boards. This just sort of covers what we talked about, how a lot of these are not going really into, there might be, the shareholder proposals on these issues haven't gained a lot of support yet, but even without majority support, they still are having an influence because, as I said, companies, have been willing to try to implement policies, do some voluntary reporting, whether it's carbon gas emissions or their I think the areas where they're a little less willing right now and might need some push are on some of the sort of the internal pay ratio issues. For example, pay ratio among men and women or other diverse candidates. Institutional investors, which we've been talking about, they are willing to engage. This is when we talk, when we've been talking about fiduciary duties and really the sort of the sometimes maybe the disconnect on the economic performance of a fund, the corporate governance. Sometimes it's even difficult. Like I've seen this with clients who are trying to talk to institutional investors on their stance on positions. The fund managers are thrilled with the company's performance and really have no issues. But then the other side of the fund, kind of the voting side, the governance side, maybe. So, even when we're dealing with funds, we've got some issues just internally, which I know we've sort of spoken about a little bit. We talked about ISS, so I'm not going to spend a ton of time other than that they do influence, corporate governance because of their role providing research and reports to their clients on these issues. I think there has been new SEC rules that have tried to call for a little bit more transparency in how they develop their voting guidelines, the conflicts of interest that they may have. Some say it didn't go far enough. Some have said it's, we'll see how that plays out. The other advisory firms, Glass Lewis, Ian Jones, certainly don't have the same amount of influence as ISS, but are also involved. So I know that's my time, and I will let Jennifer take it over and talk a little bit more specifically about institutional investors and index funds.
Thank you very much, Suzanne. So yes, next up, Ms. Lewis. You've got, I'll give you a chat notification in 10 minutes, and then again in 15 minutes that you've got a few minutes left.
Okay, thank you. Can you see my screen?
We can see you've started sharing, but we can't yet see the slides.
Okay, I did share it.
There it is. We can see it now.
Okay. Okay, good. Now I've lost my screen to see anybody else, so I'm just going to talk. Thank you. Thank you, Suzanne, for leading into some of these topics I'd like to get into. I'd like to spend the next segment discussing the ways that the big three investors affect corporate governance, particularly through their engagement efforts, by developing their voting policies and by voting their proxies, particularly on director elections and on shareholder proposals. Okay, so let's start with a quick overview of some of these governance issues. I know several of these have been talked about, but they're critical in understanding some of the policies and voting results I want to talk about later. This slide gives a list of corporate governance hot topics focusing on board issues and on shareholder rights. These are a few of the board provisions. The first row talks about board classification, staggered boards. This has been mentioned. Basically, in a staggered board, only the directors serve staggered 3-year terms, so only a third of the directors are stand for election in any given year. This is basically a defense against proxy contests because an insurgent shareholder could not gain majority control of the board in a single election. If a board is not classified, that means every director is up for election annually. Next up, board leadership really focuses on the role of the board chair and whether the board chair is the CEO or an independent director. I should be mentioning trends as I go along here. The trend on board classification is a very strong movement toward annual elections. The trends on board leadership, that's moved a little more slowly. The trend is towards splitting the chair and CEO role, but currently 47% of S&P 500 companies, the CEO serves as the board chair, and only a third of S&P 500 companies have a truly independent board chair. Overboarding was already mentioned. That's whether directors serve on an excessive number of boards. Whether the number is excessive depends on whom you ask. This one I think is particularly interesting because looking at the policies of the proxy advisors and then the big three index funds, Vanguard's policy on overboarding is actually the most strict, stricter even than ISS, which came as a surprise to many of my clients when Vanguard created that policy, that they would actually be stricter than ISS in that regard. We've talked about director election standards. The traditional director election standard was a plurality vote, where basically the nominees with the greatest number of votes were elected. That has changed overwhelmingly in favor of majority voting standards, where a director candidate would need a majority of the votes cast in his or her election to be elected. The next two, obviously voting for directors is a fundamental right of shareholders. The next two talk also about shareholder rights, the right to call a special meeting, and the right to act by written consent. The traditional positions were to prohibit stockholders from acting in these manners. The trend has been to be more permissive with these rights, particularly with special meetings, less so with written consents. Last up, I have supermajority votes to amend the bylaws or charter. And the trend here has been moving away from supermajority voting provisions towards a majority vote. This slide gives a snapshot, the incidence of these governance provisions among various indices. You should note that I've framed the first column here on the left in terms of the traditional governance provisions. So I'm talking about classified boards rather than annual elections. That means for the data, the smaller the number, that means the smaller the number of companies that have retained the traditional position and the more companies that have moved towards the more shareholder-friendly options. So for classified boards, currently 10.7% of S&P 500 companies have retained a classified board. Back in 2005 or 2006, that number was 60%. So you can see how much that's fallen off, largely as a result of shareholder activism, particularly by institutional shareholders, and voting on those on shareholder proposals, including by the big three. As you can see, there's a disparity here with smaller companies. Nearly half of Russell 2000 companies have held on to their classified boards. And you'll see that disparity really throughout the slide as we look at these other rights. For example, the voting standards to elect directors, only 9.6% of the S&P 500 have held on to the plurality voting standard. That means more than 90% have moved to majority voting. But if you look at the Russell 2000, only about a third of them have moved to majority voting. You'll see here there's a movement for special meetings and written consents, less so again with written consents. And the smaller companies have been slower to move on that. Now let's touch on some of the influences on corporate governance. Obviously, state and federal law and regulations and stock exchange listing requirements have a big impact on corporate governance. The board of directors and management obviously have a direct hand in it, and as do shareholders, including institutional investors and the big three. The others I have on here are analysts, media, governance experts, proxy advisors, and peer companies. Clearly, there are other forces at work here. One I found interesting is that Goldman Sachs now has a policy that it won't take companies public unless they have a certain number of female directors on the board. I believe it's 1 for 2020 and 2 for 2021. So that's just kind of an interesting side note on who's getting involved with corporate governance. We've talked about proxy advisors and their role here. There are still many institutional investors that rely heavily on proxy advisors, voting policies, and their recommendations to vote their shares. However, institutional investors, particularly the larger ones, have mostly established their own in-house governance policies and voting policies and in-house stewardship teams to handle these items. Here's a description of State Street's stewardship team. And they note here that their voting and engagement activities are centralized within their stewardship team, irrespective of investment strategy or geographic region. Consolidating our voting decisions and engagement efforts in this way enables us to leverage the full power of our institutional discretionary holdings and exert greater influence with management and boards. So these stewardship teams are really at the core of each of the big three, and they wield an enormous amount of power. They're generally overseen by investment committees, but these stewardship teams in some cases really affect the voting decisions of a fund's portfolio companies across the globe. Here's a list of some ways that institutional investors can affect corporate governance. We've talked about most of these, I think: stewardship priorities and published reports, voting policies, engagement, letters to CEOs, particularly BlackRock CEO and Chair Larry Fink's January letter to corporate America that, to me, often serves as kind of a bellwether as what to expect during the proxy season. Proxy voting as well for the big three. The highlighted and bolded ones are really ones that the big three participate in. As you see here, they generally don't do the letter writing campaigns that some institutions do. They generally do not submit shareholder proposals, although they do, of course, vote on them. And they generally don't launch activist campaigns or proxy contests. Now, digging into the big three as influencers, this data I found very interesting. This gives a snapshot of the big three's ownership of S&P 250 companies as of early 2020. These first two columns are showing the percentage of outstanding shares owned. So the big three combined own an average percentage of about 20% in S&P 250 companies. Their voting power is somewhat higher. This is because the big three funds generally vote all of their shares at every meetings, while other stockholders do not. So the voting power of the big three is intensified. And this data is showing that Vanguard has 10.6% average vote, BlackRock with 9%, State Street with 5.4%, for a combined total of 25% as the mean percentage of votes cast at S&P 500 companies. And that's just an incredible number. That's an incredible amount of power. It's incredible even when you just look at the segments. But 25% of S&P 500 companies is an enormous amount of voting power. Now, I'd like to dive in a little bit to the evolution of shareholder engagement and how it's changed in recent years. Traditionally, shareholder engagement was a one-way and rather limited effort. Companies would generally reach out to their largest institutional shareholders when they needed them to vote on a particular issue on the annual meeting ballot or in special circumstances, such as a business transaction involving the company. And the engagement was generally focused just on the proposals on which they needed to vote. Often the engagement wasn't even made directly by the company. Instead, the company's proxy solicitor would reach out on its behalf to solicit support for the proposals, usually by mail or telephone. Current shareholder engagement practices are markedly different. It's really a completely different world. Now, investors often initiate the engagement with the companies in which they invest. This includes investors of all sizes, from retail investors to the big three. Engagement also now focuses on a wide variety of topics, including things like strategy and risk management, not just the limited topics on the shareholder ballot, and it's a year-round effort. Companies are more than ever directly involved in the engagement, including not only key management personnel, but also independent directors. And there have been many factors that have contributed to the shift in shareholder engagement practices, but the concentration of ownership in passive and index funds is a critical factor here. And in fact, in the past several years, many public companies have taken active to proactively engage with the big three and other index funds, sometimes even doing kind of a fall roadshow to go make presentations about not only the company's performance, but also long-term strategic initiatives and corporate governance and risk management. And again, shareholder engagement is no longer limited to topics on the annual meeting ballot. In fact, it can touch on a wide variety of issues. This is the list that State Street had in its latest stewardship report. And as you can see, they engage on topics ranging from board composition and effectiveness to strategic matters, environmental issues, and then a broad range of social issues. How do they choose their targets? This again is from State Street, saying that they identify companies based on various financial and ESG indicators, including size of their holdings. They say they target companies with poor long-term financial performance within their sector. And they also target companies that are identified as lagging standards, particularly on ESG matters. Also those with outstanding leftover concerns from a prior engagement. Now let's take a quick look at the engagement activities from 2020 of the big three more closely. I'm focused on the data on the left-hand side of these slides. Vanguard reported that it engaged with 793 companies worldwide in 2020. 517 of those were US companies, which represented about 61% of Vanguard's assets under management in the US. Vanguard stated it was focusing on climate-related proposals and diversity and issues, including both board and workforce diversity and political spending and lobbying proposals. BlackRock, with more than 3,000 engagements globally, about half of those in the US, again, representing 61% of its assets under management, highlights again, the climate theme was a theme for all three of the big three in 2020. And BlackRock also was focused on human capital management issues, including diversity, disclosure on human rights issues, and issues in the supply chain. State Street did not have its full 2020 results out yet. So these numbers in the margin that's the number of meetings on which State Street voted globally in 2020, with 3,500 in the US. Again, the themes of climate change and diversity were issues for State Street. I want to touch on some of the big three voting policies. And just to give some context, this slide shows the matters that typically would appear on a company's annual meeting ballot. The election of directors, the annual advisory vote on executive compensation, ratification of auditors, any management proposals, and then shareholder proposals. These first four are generally seen as routine matters, but shareholder proposals are really a different breed. Primarily, of course, because they are proposals brought by shareholders, where the rest of these are presented by the board and management. But shareholder proposals also touch on a variety of and wide variety of themes. I've broken them here into kind of ESG components, but a lot of these are very divisive issues, quasi-political issues. Many companies have been faced for many years with governance proposals, but E&S proposals are certainly on the rise. When we're talking about voting policies of the big three on shareholder proposals, first focusing on governance proposals, the big three, like the proxy advisors, often have specific voting policies on these governance items, talking about board composition, powers of the board, shareholder rights, proxy access, things like that. Whether a particular big three fund will support a governance shareholder proposal may hinge on steps that the company's already taken to address the matter. For example, if a company is faced with a proposal to permit shareholders to act by written consent, it's possible that an institutional investor may decide to vote against that if the company has already permitted shareholders to call special meetings and act outside the annual meeting process in that manner. Similarly, if there's a proposal to requesting that the company have an independent board chair, institutions may decide, to vote case by case and may vote against it if the company has a CEO serving as the board chair, but has also has an independent lead director who has sufficient responsibility and authority to satisfy the investor. So many of these policies are done on a case-by-case basis, which is a good thing. I don't feel that governance or these governance policies are a one-size-fits-all endeavor, and having investors vote case-by-case on shareholder proposals that may push them as such, I think is helpful to companies. So there are a few absolutes here. But I did manage to find some for you. ISS was kind enough to run the voting records of each of the big three funds for me on a global basis, all of their funds, all of the meetings at which they voted. And I discovered that each big three fund and each fund in the fund families voted all of its shares at every company, at every meeting across the globe in support of shareholder proposals to declassify the board. So that is a governance absolute. I can tell you that the big three do not like classified boards, and I'm sure that comes as a surprise to basically no one. I noticed that State Street also showed that it voted 100% of its shares on majority voting proposals and also proposals to eliminate supermajority voting provisions.
Jennifer, I hate to interrupt. We still have one more panelist left, so if you could try to wrap it up in the next minute or two, that would be terrific.
Absolutely. Let me jump to this slide here then. As it was mentioned, many of these shareholder proposals are precatory. They merely request that the board take action. So you may ask, why do these shareholder proposals, why are they so influential in changing corporate behavior? And the reason here is that many investors in the proxy advisory firms have linked those the successes of the shareholder proposals to their votes on directors. So if a shareholder proposal receives majority support and the board does not take responsive action, then many of these voting policies say that at the next annual meeting, the funds will vote against director nominees. And if you're thinking in terms of carrots and sticks, this is a very big stick. As noted, directors don't stand for election, so they can be voted down. Directors and companies hate to see a high number of against votes against directors. This turns into a little bit of a loop here. If the directors have a high withhold vote and the issues underlying that are not addressed, then at the next annual meeting, you'll again have votes against directors. So it's really a cycle that the company can fall into if they don't break it. Now, keeping in mind that the 25% voting strength of these three funds combined, I just want to talk about a couple proposals here that did not pass on an average basis in 2020. This is based on Georgeson data. You'll see that some of these are within 25 percentage points of a majority vote. And I'll just flip through these last slides to show you that the big three have voting power that they are not using to push these proposals. So it may be if the big three decide to back these proposals, or perhaps if the proposals change in a way that the big three finds that they would support these, more of these shareholder proposals would pass. These are independent board chair proposals. You can see that BlackRock voted against almost 98% of those proposals. Board diversity proposals, even though these funds have voting policies relating to this, they still have high votes against many of the proposals that go to a shareholder vote. Same for some of these governance issues. Same for these climate reports as well. These, while all of the funds voted 100% of their shares in favor of companies publishing sustainability reports, the votes are much smaller for climate change reporting. And we expect that to increase, and it's possible that it might be changes in the proposal to make them less prescriptive and give management more discretion. They may pass with more solid margins. And that's all I had.
Thank you very much. That's really great data. So I'm excited to see that. Thank you. All right, so we have one more panelist, and that's David Weber. So David, please take 15 to 18 minutes, and then we'll still have 10 minutes or so for some questions as well at the end.
Sure. Okay. Well, thank you all for having me. I'm delighted to be here. I'm going to talk about a paper you already heard a little bit about this morning in Bernie Scharfman's presentation. I'll get into it a little bit more detail. So this is co-authored work with Quinn Curtis and Michal Barzuza, both of the University of Virginia Law School. And our paper is called Shareholder Values, Index Fund, ESG Activism, and the New Millennial Corporate Governance. And what we set out to do in this paper was try to explain what increasingly was looking like, the puzzle of this kind of new activism that we're seeing by the big three and other funds in the ESG space. If you and to cut right to the chase here, we think that one possible explanation for a lot of the relatively new ESG activism that we are seeing by the big three is really about a war over being able to manage future and present, and particularly future millennial wealth. And we think that that effort to attract millennial wealth is at least partly what may explain some of this relatively new ESG activism that we have been seeing from the big three. So if you look at the literature on mutual funds as shareholders, for much of their history and even right up till the present, much of the literature describes them as basically passive, particularly index funds. And I'm not just talking about the passive active management distinction. I'm talking about the fact that they historically have not filed shareholder proposals. They historically have not been particularly confrontational with management. And there's a lot of reasons why the literature has identified that mutual funds have long been passive in that respect. For example, if one contrasts the large mutual funds with other diversified investors like public pension funds or labor union funds, these other funds have been very active filers of shareholder proposals. They pushed in Dodd-Frank for votes on CEO pay, CEO to worker pay ratio. They were at the forefront of shareholder proposals about majority voting and proxy access and so forth. And yes, while some of the mutual funds voted in support of that, they were not exactly on the front lines of those fights and have historically remained relatively passive on them. And part of the traditional explanation for that, there's a number of potential explanations, but part of the explanation has also been fear of managerial retaliation, right? So what do the big three do? A lot of their business is managing the 401ks or the retirement plans of people who often work at big publicly held companies. And so the traditional view, at least one traditional view, has been that mutual funds have been reluctant to really exercise their shareholder rights, their shareholder power, either as voters, certainly also in the litigation space. They have typically been much more passive in terms of litigation around, say, M&A issues or 10b5 securities fraud, et cetera. In part for fear that it's not a great business model to be aggressively going after CEO pay or challenging them with shareholder proposals or bringing lawsuits against them when you're simultaneously trying to win their 401k business. So that's been the usual story. And yet we have seen a departure from the usual story on some of these ESG fronts in recent years. We saw State Street very famously sponsoring the Fearless Girl statue on Wall Street to confront the traditional Wall Street bull, and coinciding with announcement of both the She Index Fund and their new shareholder voting proposal, where they were going to be targeting boards that did not have any women on them, right? And we have seen that they escalate. So after State Street announced that its policy that it would be targeting voting against nominating committee chairs of corporate boards that had no women on them, BlackRock came out and announced they were going to do the same for boards that didn't have 2 women on them, right? So we've seen this kind of escalation of this ESG behavior. And so ultimately, we were trying to kind of puzzle this out a little bit. And there are definitely alternative explanations out there as well. Maybe we'll be hearing, I know Ed Rock has written about this, Jeff Gordon, Madison Condon, my colleague, who's presenting later this afternoon, right, about explanations for this new rise in ESG activism. Also, I mentioned the diversity component. We've also seen it on environmental issues, voting in favor of environmental proposals, on global warming disclosure proposals, and actually making it a significant part of their marketing campaigns and so forth. So what's driving it? Well, here's what we don't think is driving it. Okay, we don't think, when you look at index funds, they're all invested in the same thing. So they can't outperform each other on returns. We know that their costs, competing on cost, has almost been whittled down to a number approaching 0, and in some cases is in fact 0. What's left to compete on is assets under management, and they can compete with each other via over assets under management by trying to win that next generation of investment. So why millennials? Why do we think it's really being driven by millennials? We took a close look at this and we noticed a couple of things that are going on here. First of all, a lot of the social science research in this space shows that millennials really are different from both Generation X and baby boomers on a number of dimensions. First of all, it turns out that on many political and social issues, they are significantly to the left of previous generations. Socialism is less of a bad word. We are not claiming that the millennials are socialist, although millennial voters did back Bernie Sanders pretty big time in the Democratic primaries. But it's not just a question of the substantive attitudes that differ about global warming, about diversity, but another significant difference in how millennials approach the world versus Gen X and the baby boomers is that they are much more likely to take their politics with them to work, to take it into the investment space, to have it affect their behavior as consumers. Both survey research and behavioral research seems to backs the claim that they are much more supportive of the idea that you take your politics into the workplace, you take it into where you shop and what you buy, and the same seems to be true for investments, right? And so we have attitudinal differences from previous generations. And we also observe that the funds themselves are aware of this, right? So Larry Fink, we've already heard multiple times about Larry Fink's letter. Fink has pointed out that the millennials stand to inherit $24 trillion. It's the largest intergenerational asset transfer in the history of the world. That memo after memo, that it is clear that these investment managers are seeing, it emphasizes time and again that millennials care about these issues, and we observe it in the world. We observe it in episode after episode, right? We saw it at Papa John's after the CEO uttered a slur publicly and made certain other controversial comments. that consumption of Papa John's pizza plummeted and market value followed along with it. We've seen it recently in episodes like at Equinox, where the company held a fundraiser for Trump, and we saw this campaign go viral on Instagram of people canceling their membership at Equinox and then posting a photo of their canceling that and putting it up on Instagram. We have seen this activism in the workplace with the Wayfair walkout, where after the company had sold some equipment to be used in one of the detention centers at the border, there was a significant worker walkout. We have seen it. So we've seen it in the employment space as well, in addition to the consumer space. And we think we're also seeing it in the investment space, right? Millennials are much more willing to say that they want to work for companies and invest in companies that have a social good, a social purpose, and aren't just about maximizing returns. So when we add all this up, what is it that we observe and what is it that we take away? First of all, in this space, as I started out saying, these funds are not docile, but have been active. For example, they voted hundreds of times against directors in uncontested elections on the question of gender diversity, over 400 times in the first year by State Street. And we saw significant uptick in women on corporate boards. We heard earlier today about Goldman Sachs's new policy. Even recently, and I know this strays beyond index funds, but just 2 weeks ago, the Business Roundtable came out with a statement about Black Lives Matter and systemic racism and what they planned to do to deal with that. We think that this also reflects this kind of new urgency and millennial pressure on the corporate side and not just on the investment side. So the four takeaways we have are, we are seeing activism in this particular space. They're not the usual passive role here. We see that they escalate on these ESG issues and not just, they're doing more, they're out ahead of, let's say, ISS, they're out ahead of what other investors are doing. And we think ultimately that while they still do fear managerial retaliation, it's still a factor. The reality is the managers are now under precisely the same pressures, and they really fear this loss of millennial dollars even more. Some of the examples that I brought up about, say Equinox and Papa John's and others, some of those examples show the real risk in this era of cancel culture, that if you make the wrong move and you come out the wrong way on these issues very quickly, there could be bottom line harm to the company, right? We saw something like this, by the way, this summer. Yet another example was what happened with Starbucks after the company, when employees started wearing Black Lives Matter pins to the store. And then the company announced that those pins were out of bounds and that nobody could wear pins with political messages on them. There was a huge outcry from their own employees about this, who are, by the way, younger workers are critical to Starbucks' business model. They've been offering, for example, college tuition benefits for years, right? And the company not only reversed itself, but bought 250,000 Black Lives Matter t-shirts and distributed them to workers, right? So these pressures are very real. And we think that that's what they're responding to and what the index funds are paying a lot of attention to in trying to recruit millennial investors. Finally, I think another important takeaway of our paper has to do with the increasingly prevalent idea that that shareholder preferences aren't just about returns necessarily, or that they take these other considerations into account. And in a way, so there's a couple different ways to think about this last piece of it. One is that some shareholders are willing to trade off returns in exchange for some other benefit. That's one way to look at it. But another way to look at it actually is that these are increasingly converging with each other. That is to say that because of the millennial feedback loop, because millennials will act on these issues as consumers, because they will act on them in the workplace as employees, it will have and does have feedback effects into the corporate bottom line, and therefore into share prices. So in a way, trying to put these things all into separate boxes and then analyze them and think of them as a series of trade-offs is at best complicated and maybe actively misleading because of these kind of feedback effects. I think I'll stop there. I know that we have the Q&A for all four of us at the end of this panel, but the short takeaway is we think that a lot of this activism that we have seen, this renewed activism, or really new activism, and more aggressive activism on the index side is a result of this battle for millennial investment dollars.
Thank you, David, for that presentation. Again, I wish we had longer here because I have a million questions about this this topic, but we don't have a ton of time. But we do have a question from Cindy Alexander, actually one of our panelists first. So Cindy, why don't you go ahead and ask?
You're muted, Cindy.
Unmute. Thank you for these interesting presentations. David, you answered my question in the last few minutes, and that I'll chat later because I'm really interested in your findings. And I want to know how this moves to the bottom line, because I'm trying to sort these forms of engagement into which ones join the issue of share value, and how do those channels work? As you could see from my presentation, it seems to be a puzzle, and I think it's an interesting one. For Jennifer, my question that I have that you might be able to answer is, you were pointing to the different forms of engagement by the big three, which I guess that's what you call it, big three. Anyway, so these large asset management companies. And my question is, I'm trying to reconcile what I heard in your presentation from what I'm seeing coming from Bebchek and Hurst and others. And so one question for you is, where do these guys get their information when they're choosing how to engage?
I'm sorry, where did they get their information on the targets?
Yeah, so for example, one might think that if you started thinking about engagement by an asset management company with a portfolio company, one might start out thinking, well, they just randomly choose the name of a company and then start talking to them through some communication. And through the communication, they form a view about how to try to influence the portfolio company. Now, I think that's not quite right. For example, you look like you got a lot of information without talking to the companies and collected it all by yourself. So I'd like to know if you have any thoughts on how these, like the BlackRock, State Street, where do they get the information that they use in deciding like how to vote and what policies to set?
Well, I think a lot of it increasingly depends on the disclosures that these companies are making around their governance practices and around their E&S initiatives. And that's why disclosure is becoming such a hot point on those topics. Certainly these funds have the influence to meet with these companies directly. But I do think a lot of it, they have kind of gleaned this information from a number of years and have seen where companies have, what they would consider progress on the issue and those that are lagging. There are certainly some of them that have sort of, worked in kind of governance rating systems within their own organizations to target the companies that are important for the priorities that they've set.
And I think in addition to that, in some instances, it's the company making the first reach out or engagement with the funds, because that's just now a part of kind of their regular communications looking at their top investors and trying to engage with them all year long.
So the information flow is going, the initiative is from the portfolio company, you think, in some
In
cases?
some case, I mean, Jennifer, yeah, in some cases it absolutely is.
Definitely, yes.
And Cindy, you also have to keep in mind, it's not bilateral, right? There are all sorts of institutional investor organizations. There are all sorts of groups that involve issuers and institutional investors. There are governance organizations. So there are lots of ways. And the big mutual fund companies have representatives, have participants in all those organizations.
So actually, some of us were looking at the recent literature, and it caught my eye that in the academic literature, we're still learning how to measure this stuff. And so, for example, I was wondering to what extent you could use information about the name of somebody who's filing a lawsuit or filed a comment as an indicator of whether that party, whether that, as a measure of whether that party is the only one doing the engagement, for example. And it sounds like from what you're saying, Jill, that may not be the case.
I think it's definitely not the case. And, Lucian and Scott are using a very limited set of variables to measure engagement that, are sort of at a distance from a lot of what's going on in the market.
Right, which begs the question of what additional variables could one look at? And I wonder if anyone has, Jill, maybe you have suggestions or others do. Because I do hear that there, in one of the presentations, there's a lot of hidden communication that goes on. So I think that came up in Suzanne, your presentation, that there's a lot of behind the scenes discussion. I know that there is behind the scenes discussion from my own research in proxy contests, but what I heard from you is that this also goes on in the shareholder proposal channel.
Oh, absolutely. I mean, the company might receive a shareholder proposal and, talk with an investor and have it withdrawn. Or even more commonly, might just receive a letter regarding a certain governance practice or policy with maybe the threat of, if not getting the company engaged, it'll follow up with a shareholder proposal. And other than perhaps saying when the company is adopting something that, they discussed it with their shareholders, it wouldn't necessarily ever be publicly disclosed.
Cindy, if I could just add something, one of the things we talk about in the paper is these withhold votes in uncontested director elections that we've seen the big three do. And there has been research on that shows that I could forward you the paper. There's been research
Please
on that shows that can affect what they do, let's say with compensation of that director next time. But I don't think there's anything, as one of my colleagues can tell me I'm wrong if I am, I don't think there's anything that looks at that issue in terms of shareholder returns and Tobin's Q and things, those, more, those types of
piece. Okay, so the truth is that when people, so I work with financial economists quite a lot. And so I come to this from that side. And I do see there's an echo going back and forth between the legal scholarship and the financial economics literature. And maybe the echoes on the financial economics side in any event. Usually if I'm trying to look at and understand whether there's an impact on share value, and I want something somewhat dispositive, I'll try to find something. I won't look for shareholder proposals because that's a really weak signal. And I'm not saying I think there's absolutely no effect.
Sir, I just have to jump in because there's a paper, it's unpublished, so I just don't know, I'm not in a position to evaluate it, but I think it's fascinating. It finds that when it's a close call vote, as in, it basically shows that the big three are, anyone can really tell what are the close call votes. The big three seem to devote more attention to the close call votes. When they vote in favor of the close call votes, it contributes to shareholder value. And it's really an effect that's coming just from the big three and not from the other index funds.
That's interesting.
And also because there's a lot of speculation, I know Joshua was going to talk about this. There's a lot of speculation the big three get their information from their active share, the active funds that they hold, that those do the real research and pass it on to the passive funds. She finds that this effect holds even when you take the votes where the big three don't have a presence, when there isn't an active channel.
These are shareholder proposals?
I think it's just votes generally.
Okay. And that's okay. Yeah,
We're-
thanks.
if
That's,
I've got a huge queue that we're not going to get to, but actually Ann Lipton was at the top of the queue. So Ann, if you've got a got a question, we probably have time for one more question.
Yeah, it was basically, I'm sorry, it's because it was your presentation where you were talking about, you weren't sure where passive ownership was contributing, I guess, to hedge fund activism, which I found that surprising because there's a lot of scholarship on passive, on hedge funds sort of relying on the passive votes to be able to get their votes across and like to get their, to essentially rely on the passives to vote in favor of them. And in particular, we just saw that the passives are really big on removing takeover protections, which presumably facilitates hedge funds activism. So like, you get rid of the staggered boards, you get that presumably makes it easier for an activist to target the company. So I think they're really, they interact.
I agree with that. And that's an emerging area of research. What I had in mind is that I don't see evidence of them taking the lead in providing the initial contact intervention. So that's what I was referring to. And the part that's the fascinating emerging area is that these the passives could be providing signals. And I think there was this feedback channel, I guess, that Jennifer, you mentioned, that I'm seeing showing up in the literature where the evidence we're getting is about the sequential interaction from one year to the next, as opposed to, we used to look at this as only a one-shot deal, and I don't think it's looking that way anymore.
I'm muted. Now I'm unmuted. I want to thank all the panelists. Our keynote is scheduled to start in 3 minutes, but that's obviously not going to happen. We're going to take just a 10-minute break here for people to have a few minutes, and then we'll be back with our keynote speaker, Ed Rock, at a little after 12:35.
Okay.
Thank you again to the panel.
Thank you.
Thank you.
So we're gonna start, okay? So thank you so much for joining us today. It's really an honor and a privilege to have an amazing keynote speaker with us. Professor Ed Rock from NYU is joining us today. And I just want to quickly share with you a few things about his background. It's really, again, a privilege and an honor to have him. He's the Martin Lipton Professor of Law at NYU. He's a world-renowned, impressively published, and highly skilled legal scholar who embodies the spirit of education, research, and most of all, to me, also mentorship. His main areas of teaching and research are corporate law and corporate governance. In his 50 or so articles, he's written about poison pills, politics and corporate law, hedge funds, corporate voting, proxy access, corporate federalism, and mergers and acquisitions, among other things. I'm also going to mention a few of his amazing contribution to the literature. He examined the relationship between law and non-legally enforceable norms in the governance of business enterprises, and collaborated with Professor Wachter. He also tackled the question of proxy access to shareholders, and he also collaborated with Professor Kahan. And in the most recent paper with Professor Rubenfeld, they tackled the issue of common ownership. He's the director of NYU's Institute for Corporate Governance and Finance, and he's the reporter for the American Law Institute's restatement of the law of corporate governance. And just a quick note for our law students in the audience, the ALI draft discusses, revises, and publishes the restatement of laws, model codes, and principles of law, which are enormously influential in the courts and legislators, as well as in legal scholarship and educations. And Professor Rock is the reporter. What reporters do, they structure the project, they prepare the draft, they present the draft to the advisors, and he will oversee drafting of the first, yes, the first LI Restatement on Corporate Governance. It's an amazing project. I know that in the past they haven't been able to do that, so it's an amazing challenge, and I know it's the right person who's doing this, and that's Professor Rock. Also, he spent the first part of his teaching career at the University of Pennsylvania, where he served as a co-director of the Institute of Law and Economics, as an associate dean, and as a senior advisor to the president and provost and director of the Open Course Initiative. He was visiting at Columbia at NYU, and also Hebrew University as a Fulbright senior scholar. I know they're still waiting for him every year at Hebrew University. He was recently named a fellow of the American College of Governance Council. And I also just wanted to quickly note, in addition to all of his amazing professional accomplishments, Professor Rock is an outstanding teacher. And it is a privilege to say he was an amazing mentor to me when I was at NYU and even beyond to this day. I'm forever grateful for his support and for his friendship. And today you will have the distinct privilege to hear his new work on corporate objective and common ownership. And the stage is yours. Thank you for being with us.
Thank you, Anat. It's a pleasure. It was much too generous an introduction, but I very much appreciate it. What I want to do today is, my talk is, I think, going to be something of a bridge from the discussions we had this morning to the discussions we'll have this afternoon. There have been two big issues recently. One is the so-called corporate purpose debate. For whom should the corporation be managed? There's also a very lively debate over common ownership. Is the oligopoly-wide ownership by the large mutual fund families anti-competitive? And if so, how? This talk is using corporate law mainly to look at the intersection of those two debates. If we conclude, as I think we will, that under traditional corporate law, the answer to the first question is that the corporation is managed for the benefit of the shareholders. The question is, what happens when some of your main shareholders or your dominant shareholders are common owners or universal owners, as some call them? And this talk is going to draw on a variety of work that I've done and also that I've done with Dan Rubenfeld. The current debate over corporate purpose, it's certainly not the original debate, but the current debate in some respects started with Larry Fink's letter, A Sense of Purpose. It got accelerated with the Business Roundtable's embrace of the purpose of a corporation, which is what was most distinctive about their statement, was two things. One is the embrace of a sort of stakeholder vision of the corporation. And the second is a refusal or perhaps a reticence to say whose interests are primary. The prior statement from 1997 said that shareholder interests are primary, and here they say that each of our stakeholders is essential without saying whether ultimately the corporation is managed for the benefit of the shareholders, for the stakeholders, for somebody else. Davos has gotten into it. Marty Lipton has been very, very active in promoting a new paradigm that is not focused on shareholder gain. Colin Mayer from Oxford has been pushing the notion of corporate purpose, most recently in his book Prosperity. And the EU, in its study with EY, has also embraced visions of purpose and stakeholder governance. And the first question is how to understand this debate. It's a lively debate. People are ferocious about it. And I want to argue that, in fact, this is at least four different discussions. The first is a legal discussion. What does the law permit or require? What is the best description of the corporation as an enterprise form? After all, there are a variety of business forms that can be used. When we teach the basic corporations class, we often start with agency and partnership, and we'll often ask in class, so-and-so comes in with a new business idea. How should they organize it? Should they organize it as a sole proprietorship, as a general partnership, as a limited partnership, as a corporation? as an LLC? And to answer that question, you have to know, and this is why we teach this way, you have to know what the characteristics are of each enterprise form. There's a second debate that's going on as well within finance, how to think about the firm. And that's both an issue for theoretical approaches as well as for empirical approaches. And of course, in the public debate, there's a very important debate going on about management. How do you build successful companies? And what's the connection between corporate purpose, if you will, and building successful companies? And finally, and maybe most importantly, there's a political debate going on. What are the social responsibilities of large business entities? And in a period of political gridlock and political dysfunction, can corporate governance substitute for a failure, for instance, of politics to enact reasonable regulation on carbon or to address substantial inequality? And what makes the public debate so confusing, it seems to me, is that the participants often do not make clear in which debate they are intervening. They come from different worlds. The lawyers intervene in the political debate, as do the finance professors, and so on and so forth. And finally, these debates play out differently in different countries. So let me just quickly run through, and the paper I have coming out of the Business Lawyer gives much more detail on this, my preliminary answers to these questions. If, on the law question, if you understand the question as a question about the characteristics of the corporate form, of an enterprise form, and how it differs from other enterprise forms that are used to organize business activities, and I believe that's the correct way to understand the question, because I think that's a question, an approach that we can make progress on, rather than, for instance, as a question of how should actual corporations be governed. But if we understand it as a question about the characteristics of the corporate form, then I think shareholder primacy, as I will define it in a little bit, is an accurate description of the default settings of this enterprise form. Now, once you take that perspective, you can then ask questions like, what is the best enterprise form for a purpose-driven business? Is the corporate form the right form? In finance, as I read the literature, shareholder primacy is still generally accepted as an accurate, approximate description of what firms in the US and the UK actually do. Interesting question when you look comparatively, how true is it of a description of firms, for instance, in Germany, which has co-determination? And a question going towards the future is, as the world changes, is this still the right way to understand how firms are managed? When we get to the management debate, here we see, I think, a real divergence, because what's clear is that shareholder primacy is typically a terrible management strategy when the key goal was to get everyone to work together. After all, the role of management is to coordinate the inputs to the firm to produce whatever it is the firm is producing. And if you spend all your time telling your employees, telling your customers, telling your suppliers that really the only thing you care about is shareholders, that may not be the best way to get firms to move forward, to build the team that is going to produce the value. There are other circumstances, and private equity is a good example, where a shareholder primacy of focus actually is part of the lever of change. But certainly for many corporations, actual corporations today, they view focusing on the purpose of the business as a much better way to move forward and manage the firm than some focus on shareholder primacy. When we get to the political debate, it's quite clear, number one, that large business entities have social responsibilities. And number two, that shareholder primacy is not in the current political environment a winning strategy. That the explicit concern for stakeholders, as in, for instance, the Business Roundtable statement or in Marty Lipton's new paradigm, One way to understand those interventions is that they are a strategy to forestall intrusive mandatory corporate governance regulation. That's what it's all about. It's a political intervention. And it seems to me there's an important but unresolved question as to whether that's a winning strategy or whether in fact it's a losing strategy because it'll pave the way for more inclusive governance regulation at the federal level. And here, the interesting character, the interesting agent is Elizabeth Warren, who in response to the Business Roundtable statement, wrote a letter to Jamie Dimon, the then chair, saying, tell me how you're going to implement it. We agree on the goals. Now just tell me how you're going to do it in a convincing way. And then she has recently sent another letter saying, well, tell me what you've done, because we agree on the goals. I've got my Accountable Capitalism Act. And if you guys don't do it, why don't we just enact the Accountable Capitalism Act? Analytically and conceptually, the best answers to the first two, to the law and finance questions, may not be the best answer to the management and politics question. And that's part of, again, what makes this debate so interesting. Let me just pause for sort of a conceptual point. The term corporate purpose is used a lot. I want to draw a distinction between business purpose, which I view as a management concept. And you can define it, as some do, as a concrete goal or objective for the firm that reaches beyond profit maximization. I want to draw a distinction between business purpose and corporate objective, which is a description of the legal enterprise form. Corporate purpose is a very ambiguous and confusing phrase. For Colin Mayer, for instance, he uses it as a synonym for business purpose and is unconcerned with whether the enterprise is organized as a corporation, as a LLC, as a limited partnership, or in some other form. It's sometimes used as a synonym for what I'm calling corporate objective, which, for instance, is the way that Marty Lipton uses it. And there, I think the move is an attempt to redefine the legal corporate objective in a more stakeholder-friendly way as a way of pushing managers and investors to give greater attention to stakeholder interests. Now it's a very interesting project, but I think when I think of this as the question as a descriptive question, as a question, for instance, for the restatement of corporate governance, it seems to me that my conception, which is a description of the legal enterprise form as it has existed more or less unchanged for the last 150 years, is the better way to proceed. So what do I take to be the traditional description of the corporate objective in traditional jurisdictions? And this is from a document, this is from a draft that the ALI restatement project, the advisors and members consultative group, will be discussing next Thursday. And I think the best description of the corporate objective is that the objective of a corporation is to promote the value of the corporation for the benefit of the shareholders within the boundaries set by law. This first sentence is the key sentence. Promote the value of the corporation. That's to say, the focus is on promoting the value of a particular corporation. There are a variety of parties for whom it could be for the benefit of, and it answers it by saying it's for the benefit of the shareholders, but it must be within the boundaries set by law. And in doing so, a corporation clearly may consider, may but not must, may consider the interests of the employees, suppliers, customers, and others, the community, the environment, a reputation for high standards and so forth, the need to act fairly as between shareholders and any other appropriate matters. Okay, I think that is an accurate description of the corporate form. There are a couple of elements to emphasize here. The first is the focus. The first focus is promote the value of the corporation. And indeed, as a legal matter, the fiduciary duties of officers and directors are fiduciary duties to the corporation. It's not an injunction. While the ultimate beneficiaries are the shareholders, it's not a direct injunction to maximize share value, even though some people have thought it is. It's just not. That's not, I think, the best description of the law. It's not a direct injunction to satisfy the actual preferences of your actual shareholders, although they of course do elect the directors. The goal, as I say, is to promote the value of the firm in the traditional view for the benefit of the shareholders as a group. Now, this is interesting because here what you have is sort of a constructed notion of shareholder interest. In the traditional view, it's not a focus on any particular group of shareholders, and indeed, a big focus of this concept that is called shareholder primacy is that you can't prefer one set of shareholders over another set of shareholders. And importantly, during normal midstream management, the board of directors has huge flexibility, so long as they're disinterested and so long as there is a rational connection with shareholder benefit. Where this for the benefit of the shareholders has teeth is in endgame and boundary cases: sale of the company, the management of wholly owned subsidiaries, conflicts between different pieces of the capital structure, between common stockholders, preferred stockholders, creditors, conflicts between controlling and non-controlling shareholders. Now, in the paper that's coming out of the Business Lawyer, there's a long discussion of why I think this is the correct description of the Delaware view of the objective of the corporation. I'm just going to summarize it here and then move on. The first is that in the Delaware General Corporation Law, basically, of all the stakeholders, only shareholders get to vote on directors, on bylaws, on amending the corporate charter, on sale, on mergers, on sale of all or substantially all the assets, on dissolution. Only shareholders get to sue, and only shareholders are the residual beneficiaries. In the case law, when the interests conflict, shareholder interests are primary. In the sale of the company for cash, the long line of cases that began with Revlon says the shareholder interests are the ones that are primary. When there's a wholly owned subsidiary, so long as the subsidiary is solvent, the duty is to do what the parent shareholder says. When there's a conflict between common stockholders, preferred stockholders, and creditors, the duty is to look after the interests of the common stockholders. And when there's a conflict between controlling and non-controlling shareholders, it's clear that the board should not give preference to the controlling shareholders' interest. And finally, in the reform efforts, both from the 1980s and the current reform efforts, the multi-stakeholder constituency statutes that were passed in many states were an attempt to change shareholder primacy that was viewed to be characteristic of the Delaware approach. And similarly, in the development, the multi-state development of benefit corporations, they were clearly meant to give corporations broader scope beyond this default setting for the benefit of the shareholders. In an interesting recent article by Oliver Hart and Luigi Zingales, they make an argument that shareholder primacy should be replaced with shareholder welfare. They pose a really interesting hypo. If a consumer is willing to spend $100 to reduce pollution by 120, as many of us are, why would that consumer not want a company he or she holds shares in to do this too? And they argue that rather than focus on maximizing the market value of the securities over the short term or the long term, that companies should focus on maximizing shareholder welfare. Now, it's a very interesting paper. There are a variety of things you can say about it. I want to just touch on a few. On the practical side, there's this question: how does a board determine what will enhance shareholder welfare? And what if shareholders have conflicting views, conflicting preferences? How do you figure out the views of your actual shareholders. And this is really reflecting, I think, a deeper set of concerns. One is that as a matter of law, the goal in shareholder primacy is not to maximize shareholder value or stock price. The goal is to promote firm value for the benefit of shareholders as a group. And in this picture, shareholders are taken as having a unitary homogeneous goal, typically but not always financial. So when Hartens and Gallas say in their piece that under the current regime, where corporate directors are elected by shareholders to whom they owe a fiduciary duty, corporate directors have a duty to maximize shareholder welfare, not just shareholder value. That's not actually, in many respects, a correct statement of the law. But this is really the major shift here, is to move to enhancing the welfare of your actual shareholders rather than promoting the value of the firm for the benefit of shareholders as a group. And in a really good ECGI conference last week, Bengt Holmström made a really interesting observation. He said that the Hartens and Gallas move is a move from the homogeneous interests of the traditional view to potentially heterogeneous interests of actual shareholders, thereby giving up one of the key advantages of the corporate form. And here, Bengt was really referring to a line of scholarship that Henry Hansman produced 25 years ago. Henry asked the question is, why are corporations owned typically by stockholders rather than by employees? There are some corporations owned by employees, but typically they're owned by investors. And the argument that Henry develops in a series of articles and ultimately in his book is that the difficulty with employee ownership is not that, in principle, employees won't maximize the value of the firm subject to whatever constraints. In principle, they will. The problem is decision costs, that employees will have very different goals, personal goals and professional goals, and that in the typical business, the decision costs of employee ownership undermine the efficiency characteristics of the form. By contrast, the traditional approach to the corporate form, where you figure out shareholder interest not by reference to your actual shareholders, but by reference to this sort of constructed fictional notion of shareholders, namely that what shareholders want is a more valuable corporation, means that decision costs go way down. And it's on the level of decision costs that the corporate form with investor ownership trumps alternative enterprise forms. And the problem with the Hartens and Gallas approach, and we'll turn to this in a minute, the problem is their approach poses this really hard question, which is, do you promote some shareholders' welfare even when it does not enhance the value of the firm? Let me take one old example to sort of flesh this out. 2001, Hewlett-Packard merged with Compaq in a stock-for-stock merger. And at the time, the Hewlett family owned about 5% of HP and opposed the stock-for-stock merger. And Walter Hewlett, who led the fight against the merger, had two complaints. One is he thought it was a bad business deal because he thought personal computers were a declining business. But he also felt, with some substantial reason, that the merger undervalued Hewlett-Packard, that the exchange ratio between Hewlett-Packard and Compaq advantaged Compaq. So let's focus on that. Let's assume, as the market mostly did, that the merger was a value-increasing merger, but that the exchange ratio undervalued the Hewlett-Packard shares. What do you do if you're an investor who believes that? Well, it depends, right? It depends on where you sit. If you are overweight in Hewlett-Packard, as Walter Hewlett was, even if you see the business logic, you will and should oppose the merger and vote your HP shares and any Compaq shares you have against the merger. If your Vanguard's S&P 500 index fund, which has equally weighted holdings in Hewlett Packard and Compaq, and you believe, as I'm assuming you do, that the companies are worth more together than apart, then you vote your shares in Compaq and your shares in HP in favor, because the merger, the exchange ratio is purely distributional. It has no effect on you. You own an equal share of both. And if you're overweight in Compaq and underweight in HP, then of course you vote all shares in both companies in favor of the merger. Vanguard's an interesting case in how they handled that. Because if you look at the report of their votes, they voted some shares in favor and some shares against, both for HP and Compaq. So why did they do that? And this goes to some of the comments in the morning panel that Ann Lipton made. Well, Vanguard is a family of funds. And it's got the S&P 500 fund, which is equally weighted, but it has a variety of other funds that were either overweight or underweight. And so recognizing that they owed fiduciary duties to the investors in their individual funds, they pushed the decision down to the portfolio managers for the individual funds. And so as you would predict, the portfolio manager for the S&P 500 fund voted all shares in Compaq and HP in favor. But for a fund that was overweight in HP, they voted against. And for a fund that was underweight, that was overweight in Compaq, they voted all of them in favor. And so the net result was you had some shares, some of their Compaq shares in favor, some against, some of their HP shares in favor and against. They got a lot of criticism from various people who thought that they were moronic, when in fact what they were doing was honoring the fiduciary duties that they owed to the investors in their individual funds. Now, the harder question is, what do you do if you're a director of HP? Under shareholder primacy, you ask yourself the question, is this a good merger for HP and for HP's shareholders? You have no permission or obligation to think about Compaq's shareholders. That's not what you're being asked to do. You're asked to make a decision of what's best for Hewlett Packard and Hewlett Packard shareholders as a group. Now, under the shareholder welfarism approach, which shareholders' welfare? Do you vote, for instance, in favor? If you're a director, do you say, yeah, we'll do this merger because even though we recognize that the exchange ratio is unfavorable, unfortunately, to Hewlett Packard, we know that Vanguard, State Street, and BlackRock are equally weighted. And so from their perspective, they think this is a good merger because it's value increasing, enhancing. Even more complex set of questions if you're now expanding the scope to stakeholder capitalism. If the merger is going to result in a decline in employment, which mergers often do, does that mean you vote against the merger? The traditional approach is that the duties run to promote the value of this corporation for this corporation's shareholders, and maybe, if you're in a stakeholder jurisdiction, this corporation's stakeholders. And that's a hard enough thing to do without trying to consider the overall welfare of your shareholders. By contrast, shareholders, of course, can typically vote selfishly. So let's now move to what I view as the frontier. What if now we've got this emergence of these owners we refer to as universal owners? They include, but not limited to, BlackRock, Vanguard, and State Street. They own everything, but there are more. Fidelity, CAP. It's not simply an index fund phenomenon. It's a phenomenon of the widely diversified asset managers. So what if the universal owners team up to promote actions that benefit their portfolios at the expense of individual firms? And let's consider two different situations. One is with respect to carbon or climate change, a topic that Madison Condon, who's going to talk this afternoon, has written about. And another is, suppose it's with respect to competition, namely to limit competition a question that's at the heart of the common ownership controversy that we will hear about this afternoon as well. How does this fit with the traditional view of corporate objective? And how does it fit with the traditional view of directors' fiduciary duties? So let's take a step back. When do controlling shareholders have fiduciary duties? Typically, shareholders, as I've said, have no fiduciary duties to firms or other shareholders. They can do whatever they want. What about controlling shareholders? And for those of you who've taken, the students who are taking or have taken the basic corporations course, you know that the answer is that when a controlling shareholder exerts control over the corporation, it takes on duties to the non-controlling shareholder. So for example, when a controlling shareholder has the power to freeze out non-controlling shareholders, but when it does so, because of the obvious conflicts of interest, controlling shareholder wants to buy out the non-controlling shareholders at a low price and they want a high price. The standard of review that the controlling shareholder must satisfy is entire fairness, unless there's either an effective special committee or a majority or minority approval, in which case the burden shifts to the plaintiffs to show it's not entirely fair, or under MFW, an effective special committee and majority of the minority plus some other stuff, in which case it's business judgment rule. So now let's look at the climate change hypo. So let's assume a universal owner with 6% of everything, and that universal owner concludes what I think most of us believe. Climate change is real. Carbon emissions pose a threat to its overall portfolio. And the cost to the portfolio, and this is the most controversial assumption in my hypo, but let's just take it for what it's worth because it sets up an interesting question. The cost to the portfolio of substantially reducing ExxonMobil's output would be offset by the benefit to the portfolio, even though it would be very costly to ExxonMobil. So imagine the hypo of reducing ExxonMobil's carbon footprint by 50% by 2035. And so the universal owner threatens to vote against any director who doesn't support downsizing. So let's now run through the corporate law approach to this. If you are a universal owner acting independently, may you pressure ExxonMobil to downsize? Absolutely. You're a shareholder. You don't have duties to anybody else except to your investors. And if you believe that pressuring ExxonMobil to downsize will increase the value of your portfolio, that's a perfectly appropriate thing for you to do, even if it's costly to ExxonMobil and its shareholders. What if you're an actively managed mutual fund overweight in ExxonMobil? Well, then you obviously want to push against downsizing because you're going to get hit with a substantial decrease in my hypo in the ExxonMobil stock price if this succeeds. And that's going to undermine your returns and not be good for your investors. What if you're an ExxonMobil director? Now you ask the question, what is best for ExxonMobil? And you might convince yourself, as I think maybe the directors at Shell did, that committing to reducing your carbon footprint 20% by 2035, 50% by 2050 is a way of stealing a march on your competitors in developing renewable energy sources and developing alternative technologies. And if you believe that, then it's perfectly appropriate as a Shell director to agree to reduce your output. But if you believe that in fact this is going to be devastating to ExxonMobil, however wonderful it is for the portfolios of your universal owners, then the legal structure we've just gone through says, no, you have to resist the pressure and do what's best for ExxonMobil. But now let's ratchet it up a bit. Suppose the universal owners agree to collectively push for downsizing, and they run a downsizing slate of directors and win. What about now? So now we begin, now the material on controlling shareholders becomes relevant, because under Delaware law, there is a notion of an effectively controlling shareholder. You don't have to have 51% of the shares if you can exercise effective control. And arguably, this group of universal owners that has succeeded in electing this slate of downsizing directors is now a controlling shareholder that is sacrificing the value of Exxon for the benefit of other firms in their portfolios. And that looks an awful lot like a whole range of controlling shareholder cases where the controlling shareholder uses control to injure in a way that injures the non-controlling shareholders of firm X in order to benefit firm Y in which the controlling shareholder has an interest. And that's a breach of the duty of loyalty, which entitles shareholders to sue for damages. So now let's take the second hypo, the competition hypo. So now again, same setup, universal owner with 6% of everything concludes that competition among individual airlines is destructive to portfolio value, that the airlines should adopt a soft competition equilibrium. What may the universal owner do? Well, acting independently, of course, whatever the universal owner wants, can vote selfishly, can vote against directors who support hard competition if universal owner can figure who they are, can vote for shareholders who support soft competition, can lobby for soft competition. Under corporate law, even though this may disadvantage other shareholders who are do not hold all of the airlines in their portfolio, a universal owner has no obligations to other shareholders and is perfectly free to act selfishly in the interest of its portfolio. What if you're a United director, say, and you believe that this approach, that a soft competition equilibrium might benefit airlines as a group, but will be damaging, very damaging to United? Can you so here we have to figure out what's going to go on. If you think it's just a short-term hit to profits, but you believe that it'll be effective in raising fares over the middle term to United's benefit, then as a United director, it's perfectly appropriate. As a matter, we'll get to the antitrust issue in a moment. As a matter of corporate law, it's perfectly appropriate to say we will sacrifice short-term because we think long-term soft competition is profitable. But if you think that you will be sacrificing United's profits without a return for the benefit of your universal owner's portfolio, then you can't do that, right? That's part of what this notion of the objective of the corporation is to promote the value of the corporation, this corporation, for the benefit of the shareholders as a group. That's one of the implications of that. But now let's push it to a level where this might be actually pretty effective. Where suppose with the help of some portfolio manager from one of your investors, the universal owners agree to collectively push for soft competition and succeed. And suppose that achieving that soft competition equilibrium hurts United, but helps the industry overall. Now let's look at the corporate law question here. Now we've got exactly the same setup. Arguably, this group of universal owners that's been organized by the portfolio manager is now a controlling shareholder. And the question is, have they as a group and their directors breached their fiduciary duty of loyalty? And the note here, we're going to get to this in a moment. To the extent that this is a problem, a fiduciary duty problem for the directors, to the extent that the duty of loyalty keeps the directors focused not on other firms in the industry, not on their shareholders' portfolios, but on what's good for this corporation, then the traditional approach pushes back against some of the channels of influence that have been proposed in the emerging antitrust literature for how common ownership can be anti-competitive. Not saying it eliminates the possibility, but from an antitrust perspective, it pushes back. So now let's turn to the antitrust analysis of this hypo. The first version of the hypo, without coordination, is common ownership anti-competitive. I mean, that's the topic of a lively current debate. We'll hear about it this afternoon. There's lots of interesting stuff coming out. It's a fascinating debate. From the law perspective, the key question with respect to these unilateral effects theories, that is to say, anti-competitive effects in the absence of coordination. The core legal question comes up under Clayton Act Section 7. Clayton Act Section 7 has an exemption that says this section shall not apply to persons purchasing such stocks solely for investment and not using the same by voting or otherwise to bring about or in attempting to bring about the substantial lessening of competition. And now when you think about what I described in terms of the universal owners acting independently, they're on the first prong, solely for investment. Well, if universal owners are not buying stocks solely for investment, who is? It's got to include those purchases. And so then the question is whether they are using the same by voting or otherwise to bring about or in attempting to bring about the substantial lessening of competition. And if they're not doing anything, if it's genuinely a unilateral effects story, if this is simply on the attempt of directors to anticipate the desires of their universal owners, it's not clear under the cases whether that constitutes using by voting or otherwise in attempting to bring about, it's an active verb, to bring about the substantial lessening of competition. This is a set of issues that Dan Rubenfeld and I talked about extensively in our first article on common ownership. In my second hypo here, where the portfolio manager is organizing the universal owners, now the question comes up, is that a violation of Section 1 of the Sherman Act as a contract combination in the form of otherwise or conspiracy and restraint of trade, in addition to Clayton Act Section 7. Here it seems to me there's a very strong argument that it is a violation of Section 1 by the Universal Owners Group, by the airlines, and by the portfolio manager. And this is something that Dan Rubenfeld and I talked about in our second article on common ownership. So what is this all, when you put it together, what are the implications for this? First of all, common ownership or universal ownership, it's here to stay. The biggest index funds are, and the other large institutional investors, Fidelity, the Cap Group, and so forth, they are the major forces in the capital markets now. In any proxy contest between a hedge fund and a management team, it's the big 3, 4, 5, the 12. It's a very small group of common owners who cast the decisive votes and decide who's going to win. That's not going to change. And as we've seen, it has really interesting possibilities. Some potentially good, such as collective action to limit carbon emissions. Some potentially bad, such as collective action to reduce competition. Here it seems to me that the contrast between the universal owner sort of welfare approach and the traditional firm value for the benefit of shareholders approach is a really important contrast. There are sharp tensions within existing corporate law for both the happy story and the sad story of universal ownership stewardship. Problem whether it's being used to limit carbon emissions or to limit competition. From the traditional perspective of corporate law, there are real tensions with boards listening to their universal owners when the focus is not simply on increasing firm value, but rather portfolio value, whether it be of the sort of stewardship, systemic stewardship that Jeff Gordon's been talking about, or other varieties. There are other substantial benefits to this traditional focus on firm value, namely, it avoids high decision costs from integrating heterogeneous interests, and it mitigates, though does not prevent, common ownership's anti-competitive potential. Finally, and this is sort of, I think, a general takeaway, it would be nice to have proper regulation that could regulate carbon and leave traditional corporate law's single firm focus in place, because it works pretty well. And to the extent that it's political dysfunction that is pushing corporate law from its traditional firm value for the benefit of shareholders focus to either a universal owner welfare approach or some other sort of stakeholder approach, there are losses to that. Let me stop there and get comments questions from the panelists as well as from the audience.
Thank you so much. That was amazing. Thank you. I already have here questions from the audience that I'm going to quickly present to you. I just want to tell the panelists, please turn on your videos if you want to ask a question, okay? So just feel free to start turning on your videos and then raise your hand and I'll just call on you. So we'll start with the audience quickly. There's a particular question with regards to the phrase to promote the value of the corporation. How is value defined? They would think the monetary value, including any goodwill value, but is there anyone advocating that the term value means social value, something more than just the corporation's book value?
So Ann Lipton this morning, I think, talked about Vanguard, the Vanguard Group. And the Vanguard Group, VGI, the management company for the Vanguard Group, is owned by the Vanguard funds and thus indirectly owned by the investors in the Vanguard funds. In other words, it's a mutual ownership, it's a mutual corporation where the customers of the corporation own it. It seems to me it would be incorrect to say that corporate law requires, in any sense, that VGI seek to maximize its financial value by charging the different Vanguard's funds high prices. Because what VGI is doing is serving. It's a service corporation for the funds. And the directors of VGI should be trying to make it the best service organization, the best management company for the Vanguard funds. That's not a financial measure. It will typically be true. In a typical shareholder-owned corporation, it will be typically true that what you're trying to do is promote the financial value of the corporation. But if you're describing the corporate form, the characteristics of the corporate form, it seems to me that you cannot be that narrow, precisely because you have circumstances like the mutual ownership structure, like a wholly owned subsidiary. So often in groups of companies, you will have service subsidiaries that are not managed to promote their financial value, but the value to the firm, to the overall group.
Thank you. Thank you so much. What I'll do now, I'll actually ask each one of the panelists to present the questions because I want you to get all the questions. And then I also have a question here from Marty Schmaltz. So we'll start with Josh, then Charlie, Michal, and Ann, and then I'll read Martin's question as well. So Josh, please.
Okay. Hey, Ed. So just to follow up on this question that you attributed to the recent discussion, the ACGI discussion on the decision costs. Could one say that for a publicly traded firm where marginal traders are buying and selling the traded securities of the corporation, that the marginal traders' preferences are likely to be impounded in the price, such that we don't necessarily need coordination. We just need a properly functioning capital market, and we get preference aggregation, right? So this kind of harkens back to all the literature on heterogeneity in finance, and basically says if markets are complete, we actually don't need any other mechanism other than just risk allocation in complete markets. So I'm wondering if this framework this divergence between shareholder welfare and market prices works or applies to publicly traded firms, or if this is more compelling in the case of a non-publicly traded firm, perhaps, where that wedge might arise because we don't have capital markets to transfer risk.
So as a description of the characteristics of the corporate form, we know that the corporate form, in more or less the same form, is used in really efficient, informationally efficient capital markets, in informationally inefficient capital markets, with the largest publicly traded corporations, with really small publicly traded corporations, with closely held firms, in US capital markets, in foreign capital markets, and so forth. So as a description of the enterprise form, I think the form is, the argument is that it's a characteristic of the form that it saves on decision costs. The question you're raising is, in what particular instantiations of that form are those decision costs likely to be high? And they will undoubtedly vary. They will undoubtedly vary in market context over time, the nature of the business, what their investment projects are, and so forth. So that for some companies, maybe a closed-end mutual fund, you might think that the share price is a perfect signal, though not exactly of the value of the firm, since it's typically discounted. For other companies that are where much of their value is in projects that are not transparent and that are long term, you may not have that confidence. So it's gonna vary. This is an argument, and Beng's argument is not an argument about decision costs in any particular company. It's an argument about the virtues of the enterprise form, and which is in part an argument, now going back to Henry, as an explanation for why in so many different market contexts, the investor-owned for-profit corporation has won out as the preferred business form.
Thank you. Yes, Charlie, please.
Yeah, two things actually. First, very quickly on your HP and Comcast example, just Minor Myers and I have looked at a lot of merger votes, and it is not at all uncommon for stock for stock deals like that to have sort of a decisive margin by index investors that are on both sides of the deal. And I frankly, I struggle with whether or not that's a good thing, and that it's a value creating deal, and it's avoiding letting haggling costs either block or consume the added value, or is it a bad thing in that it's adding extra risk to active investors, non-index investors? It's going to raise the cost of equity capital over the long term. Anyway, an interesting question to consider. The other point I had was on your list of sort of 4 answers that you had at the beginning. I mean, I think one that is missing from that is just management self-interest. And if you look at what's actually being proposed by the Business Roundtable or Marty Lipton or any of those, what's being actually proposed is pretty vague usually, first of all, but it mostly boils down to relieving management from the legally enforceable duty to maximize stockholder wealth without really imposing any new legally enforceable duty to anybody else. And I wonder what you think of that characterization. Is this good marketing that is also just cover for a return to sort of 50s or 60s style managerialism?
So I should start with a disclosure of conflicts of interest. Obviously, I am the Martin Lipton Professor of Law at NYU Law School, where Martin Lipton was the chair of the Board of Trustees, the chair of the University Board of Trustees. He did not, by the way, give the money for the chair. The money for the chair was given by Eric Gleacher, a great investment banker from the 1980s, 1990s, who's no longer active, but he gave the money. And when I got the chair and spoke to him about it to thank him, he told me that in the 1970s, in 1975, when he was a young investment banker, he used to sit with Marty Lipton on Saturday mornings, and Marty would teach him about M&A. And it became the foundation of his career. And so when the opportunity came to honor Marty, he was pleased to do so. And Marty and I also teach a corporate governance seminar together. So I don't think that that is an accurate description of what Marty thinks he's up to. Marty genuinely and sincerely believes that giving more discretion to boards to, for instance, prefer stakeholder interests, employee interests over shareholder interests if the board believes that this is the right thing to do. That number one, that requires insulation from shareholder pressure. And a staggered board is one way, but shareholders realizing that deferring to boards is another. A poison pill is another. But that in Marty's view, this is actually not at all managerial self-entrenchment. There are lots and lots, in his view, of checks on management discretion and ways to keep management focused on shareholder value. But in fact, this level of discretion, he firmly believes, is necessary to give sufficient attention to non-shareholder constituencies, such as employees and communities and customers, to forestall political intervention through mandatory legislation. And so for Marty, this is all about preserving the ability of corporations to continue to function without the heavy-handed regulation of the state. And that his belief, and I don't have enough, he has better political instincts than I do. His belief is that the shareholder primacy approach, the view that the duty is to maximize shareholder value, interpreted as maximizing shareholder value in the short term, that spells the doom for the corporate sector that we have. Now, if that's right, if he's right about that, that is to say, if the alternative to the new paradigm is the Accountable Capitalism Act, or something like the Accountable Capitalism Act, then I think even you would agree that if that's the choice, you prefer the new paradigm. Am I wrong about that?
Maybe not the accountable, maybe you're right about the Accountable Capital Act, but the last thing you said in your presentation, actually, if the alternative is government regulation of the substantive issues rather than the corporate form, I don't know, I tend to think that is a more fruitful long-term project than hoping.
And I agree with you. I agree that it's much better to have the government handle externalities and let the corporate sector try to maximize within the constraints imposed than to ask the corporate sector to balance these competing and incommensurable interests, a balancing that is not only difficult, but politically illegitimate. So I think on that, but the world that Marty is proposing, the world that the new paradigm enters is a world that says we can't count on the legislature to enact a carbon tax. And it's not clear to me that the election that is still working, that we're still counting the votes on, has changed that gridlock one whit.
But is it any more plausible that a government that won't pass a carbon tax will pass the Accountable Capitalism Act?
Well, yeah, in the sense that the one thing that Trump and Biden, less so Biden, the one thing that Trump and the Democratic left agree on is that big corporations are bad. In any event.
Thank you. Thank you so much. Michal, yes, please, you need to unmute yourself. Yes, you just need to unmute.
It was a really interesting lecture, especially the way you differentiate between the different questions that people are like mixing together. It's really interesting. But I have a question about, even to take her example on the climate change. Isn't it always possible to show something as benefiting the corporation as a whole on the very long term, and using the business judgment rule is to say, we do believe that in the very long run, it will benefit the corporation if there will be less carbon and better climate and better green energy, have you?
I think the business judgment rule gives a great deal of flexibility, but not unlimited. So it seems to me there's a strong argument that if I am a universal owner and we're genuinely worried about climate change's effect on my portfolio, that the optimal strategy is that the publicly traded oil firms should close, should shut down, period. Now, you can't justify that on the business judgment rule. A board of directors that says, well, we're just going to shut down because we're going to cut our production to 25% or 10%, just the specialty oils for sewing machines or whatever, right? That's in the long-term interest of the shareholders. So in that circumstance, in the climate context, depending on where you go, so there's a range. If you view this as sort of a portfolio-wide systemic stewardship, where you say what you really need is standardized disclosure on climate across the whole portfolio so we can compare. I see no problem with that. That's not trading off one company's interest against another. On the other hand, and if you say, as Shell Oil did, that we genuinely believe that this is going to be value enhancing over the next 30 years, then yes, that's consistent. It's consistent with the business judgment rule. It may or may not be consistent with your shareholders re-electing the directors. And the thing to keep in mind here is that you don't want court supervision of this to be anything other than exceptional. And you want arguments over whether we should cut our production in order to switch to other forms of energy to be a question in the first instance that management decides, and ultimately that the shareholders get to vote on, because you can be sure if in the real world, if you have a decision that destroys a great deal of value in the corporation but is reversible, that some hedge fund's going to show up and say, it's a really dumb idea, we should reverse it. And then what you get is, if they can't work it out, you've got the hedge fund presenting one view, management presenting another view, and the largest institutional investors who have plenty of incentives, plenty of personnel, and plenty of time to figure out who they prefer, because there are only on the order of 20 proxy contests that go to a vote a year.
Thank you.
Thank you. Thank you so much. I also have a question here from Martin Schmaltz. Martin, thank you for joining us. He says, thank you for a very interesting talk. Your premise seems to be that in order for common ownership to reduce competition, one company needs to be hurt at the benefit of the common owner's other portfolio holdings. What's the basis for that premise?
Well, it may or may not be the case. There are some scenarios, and I would put this as at least the way Martin presented it in the early versions of his paper, and certainly when he came and presented it at NYU, that it looked like it was a loss to one to benefit others. There are certainly other models where ultimately it benefits everybody. From the perspective of the board of directors of United, they have to convince themselves, if they're going to opt for a soft competition equilibrium and it's going to cost them in the short term, then they have to convince themselves that it will be bearing that cost will be worthwhile, because A, the soft competition equilibrium will emerge and will emerge long enough that their returns from this investment will be positive. And that's an open question, is whether that's a hard question, because these kind of equilibrium tend to be unstable, especially in the airline industry over historically. So I'm not assuming anything. I'm saying there are different scenarios. And from the point of view of the board of directors, the question is, what is best for our corporation, not what is best for the portfolios of our principal shareholders. under current corporate law.
Thank you. And if that's okay, Florian wanted to respond to that.
Yeah, I think it needs to be very, very clear here that there are no dynamics. It is a perfectly static model that would still imply that because of reduced competition, nobody is hurt. In fact, United benefits from softer competition. Yes, United is not as profitable as other portfolio companies, but because we immediately go to soft competition, okay, because this is a unilateral model, and in fact, Martin Schmalz and other co-authors have always clearly pointed out that this is a unilateral static model, it is not clear at all whether common ownership need actually hurt any single company. It can be immediately profitable for everybody.
And if it's immediately profitable for everybody, then in terms of the fiduciary duties of the United directors, and if it's more profitable than alternatives, then there's no problem. There may be an antitrust problem, but there's no problem. There's no fiduciary duty problem. But there will be some circumstances in the real world, as opposed to the world of a static model, where there will be a risk that pulling your punches in time one, which will injure United, will not result in higher profits in time two. And in those circumstances, then under traditional corporate law, the director's duty is to figure out whether pulling punches in time one on the uncertain prospect of profiting in time two benefits United, without regard to whether it benefits BlackRock's portfolio.
Thank you so much. And we're going to let Ann Lipton ask the last question. Yes, please, Ann.
So, well, now that was said, I just have to throw in that, yeah, I mean, I agree with that. I mean, I don't know the financial model, although I know this issue, obviously, but I mean, like, it's really common in cartels for somebody to defect, and they're defecting for, like, cartels, when they form, they always have a problem policing their members. And there's a reason for that. It's because at some point, members of it decide it's actually more profitable not to go along with the cooperation. So I think you can go either way. But anyway, so two things. So first, just because and we've talked about this before, obviously, and because Charlie mentioned the issue of mergers where, you've got the funds on both sides, so they're sort of different. And the compact merger situation, I always have to counter with like the T. Rowe Price situation in CSX, where T. Rowe Price had funds that had both sides of a merger and had like one fund manager and negotiating what price T. Rowe Price would accept across all its funds, even though the funds had like some were just the target and some had both the target and the acquirer. And T. Rowe Price went ahead and just negotiated what it would accept for the price of the deal without regard to the different interests of the funds. It came up as an issue of cleansing rather than as an issue of T. Rowe Price's fiduciary duty to its own funds. But I think that different fund families may handle this differently at different times. It's not always obvious.
No, and it's one of the interesting, strikes me as one of the most interesting sort of compliance or legal design features. So there are two main, this is something that Marcel Kahan and I have written about in our Let Shareholders Be Shareholders paper. Vanguard handles it the way I said, which is they are very sensitive to the issue. Where they think there's potential conflict, they push the decision down to the portfolio manager responsible for a particular fund, and they let that portfolio manager make the best decision he or she can make for the beneficiaries of that fund. Fidelity, for historic reasons, has a different approach. So Fidelity has a big index operation, but Fidelity offloaded the management of their index fund to a company called Geode for funny sorts of reasons. They didn't want the passive style to infect the culture of their active managers. And separate management teams is another way to handle conflicts of interest. There they did it with a separate company, which is like a prophylactic approach, or it works as a prophylactic approach. And I think there's everything in between. It's an interesting question whether you want to do this prospectively or through an architectural design, or whether you want to do it when it comes up, because they don't come up all that often, which is the way Vanguard approaches it.
Well, thank you so much. Thank you so much, Ed. Oh my God, it was amazing, amazing. We had so many people joining us and so many questions, so many interesting, ideas and new ideas. And it's really an honor and a privilege to have you with us today. And thank you again for doing this and, for giving us this amazing, amazing talk. And I want to introduce actually my amazing colleague, Julianne Kostritsky, who's the director of our business center here. She's going to be managing the next panel. Juliette, do you want us to have a few minutes of a break? When would you like the next panel to start? Oh, sorry, we can't hear you. You're muted.
So I am not doing the next panel. That is actually Bob Rapp.
Oh, I'm sorry.
That's okay. He's that's the third panel. I do the fourth panel on ESG. Okay. So yes, I think everybody should have a break. And so let's reconvene here in maybe, should we say 10 or 15 minutes? Bob Rapp, you decide.
Well, I'll go with whatever the rest would prefer.
Oh,
I'm ready to go, but yeah, we need to pause.
Okay, so let's say 10 minutes, all right? We'll reconvene in 10 minutes. Wonderful. Okay, great. Thank you, Anat. Thank you, Professor Rock. It was just wonderful.
Well, thank you, Juliet. It was a great pleasure. Thank you, Anat.
Great to have you here.
And if any of the panelists want to turn on their videos, want to talk, this is like a coffee break, please feel free to do that, okay? Hi.
And we'll do just that. And good afternoon, everyone. I am Bob Rapp, and I have really the privilege to serve as moderator for this segment, this panel of our symposium that we have titled Potential Anti-Competitive Effects on Market Dynamics and Efficiency. It certainly almost goes without saying, as has been illustrated so far today by the presentations, the growth of passively managed portfolios and common ownership of index funds has generated a very, very lively debate about the impact on securities markets and corporate governance generally. And part of that debate focuses certainly on how concentration of ownership in index funds impacts competition among rival firms and their incentive to innovate, and where there is common ownership through index funds. We have an absolutely outstanding panel to address these issues and challenges in this segment. Briefly introduce them to you. Professor Florian Ederer is Associate Professor in Economics at the Yale School of Management, where he's also an affiliated member of the Department of Economics. Professor Ederer is also a research staff member of the Cowles Foundation for Research in Economics. He holds a doctorate in economics from the Massachusetts Institute of Technology. Professor Maria Genet is Associate Professor in the Financial Management Department of the ISE Business School of the University of Navarra in Barcelona. She holds a doctorate from the University of Barcelona. And the third esteemed member of our panel, Professor Joshua Mitz, is Associate Professor of Law and the Milton Handler Fellow at Columbia Law School, where he is also a member of the Center for Financial and Business Analytics at Columbia's Data Science Institute. Professor Mitz was awarded his Juris Doctor degree from the Yale Law School, and he holds a doctorate in finance and economics from the Columbia Business School. Keep in mind as we proceed to use the Q&A function if you want to address questions to any of our panelists. I've also invited them, as we have done so far today, to interact with each other with comments or questions they may have for their respective presentations. Now, we will begin our session with Professor Ederer, and his widely published research focuses on organizational economics, innovation, behavioral economics, and I think particularly significant for all of us today is very recent work focuses on the impact of common ownership And today he's going to present an overview on theoretical analysis of the product market implications of horizontal shareholdings, or as we have commonly referred to them today, common ownership by large asset management companies. Florian, the floor is yours.
Thank you very much, Rob. And thank you very much to all panelists so far. I've learned a great deal. I particularly enjoy always this exchange between both economists and lawyers and law practitioners that I get from these conferences. Now, before I begin, let me give the usual disclaimer that I always give when talking about this topic and other antitrust topics on which I've worked on. I have no conflicts of interest. I have never worked as an expert witness or as a consultant in antitrust cases. I also am not affiliated with any research centers that receive funding from the financial services industry. And other than the index funds that I hold, I therefore have no conflict of interest. The work that I'm going to talk about is about common ownership. Our wonderful keynote speaker, Ed Rock, has already set the stage for what I will be talking about. This is joint work with Miguel Anton, Mireille Chinet, and Martin Schmalz. And usually I would give a bit of an overview of what common ownership is, but because we've had all these panels that already told you what essentially common ownership is, and this is a very sophisticated audience, I'll just skip over this and just leave you with this, now often repeated slide that shows how much of the largest airlines are owned by pretty much the same set of investors. Now, what is the impact of such common ownership or horizontal shareholdings, as Herb Hovenkamp and Fiona Scott-Morton have called it? When large investors own shares in many firms within the same industries, those firms may now have reduced incentives to compete. So this would be anti-competitive effects. Basically, the way this works is that firms produce fewer units, raise prices, reduce investment, innovate less, limit entry. It has a long intellectual history. It goes all the way back to Julio Rothenberg's seminal work in the 1980s. But there has been a tremendous increase in common ownership over the past 3 decades, wonderfully chronicled by the work of Matt Backus, Chris Conlon, and Mike Sinkinson in recent issue of the AJ Micro. This is also one of the hottest topics in antitrust. Prominent law scholars claim, in fact, that common ownership has stimulated a major rethinking of antitrust enforcement. And this academic and policy interest is indeed driven by many market, industry, and macro level empirical studies. Some of these studies are listed here. It really is a plethora of empirical evidence, both on the relationship between incentive slopes, which I'll be more explicit about in a second, and Mireille Chinet will speak to the empirical part in more detail, but it also shows not just up in the positive relationship between common ownership and product market prices, which is going back to the famous airlines paper of Azar et al. It also shows up in positive relationship with regards to cost, negative relationship with regards to quantity output, negative relationship with regards to concentration, negative relationship with regards to entry, negative relationship with regards to investment. I've listed many of these papers here, but there are many, many, many more, including a special symposium of the AEA papers and proceedings, as well as a forthcoming issue of the Antitrust Bulletin. Now, this is a very controversial literature. In particular, the literature that is critical of these claims that I've just shown you is actually rife with retractions. And I think this is very important to point out because, when people claim there are two sides of the debate, well, this one side of the debate has retracted many of its claims. So for example, Dennis et al. Previously claimed to overturn the results of the airline paper of Azar et al., but several papers actually disprove their claim to overturn, and Dennis et al. Have since retracted it in a recent version. Kennedy et al. Claimed to overturn the results of Azar et al. Too, in the sense that they claim to find no positive point estimates and do not reject positive effects. But actually what they do is they just do estimates based on a very selected subsample of the data. And when other researchers such as Park and Seo in a recently published paper do this with a larger data sample and use a more standard estimation procedure, it is very clear immediately that common ownership does indeed raise prices, just like the original Azar et al. Paper showed. Or, for example, there's a paper by Kwon that previously claimed to overturn the results of a paper by Anton et al. On compensation as a mechanism for common ownership. But in fact, that very same paper again has been retracted. So I'm not even mentioning several of these other studies funded and authored by ICI, the Levering Group of the mutual fund industry, or BlackRock, but there's really not all that much to this two sides of the debate. It's pretty much just a one-sided debate. There are effects of common ownership. Still, the policy discourse on all this is heavily slanted. It's probably evidenced by the recent, or 2 years ago, the panels that we had at the FTC NYU Law School hearings, where actually, rather than academic and empirical papers and authors being discussed and being represented, most of the panelists that presented were people that had done no own empirics, had presented factually incorrect claims, or were industry affiliated or sponsored. Okay, now, those of you who know this common ownership literature, their number one question is always going to be, what is the mechanism? Because the investors don't run the firms. So even if the investors are common owners, well, they don't get to run the firms. BlackRock's Larry Fink doesn't phone up the managers and tells them, here's how you're supposed to price in on different airline routes. And of course, if we're relying on some argument that has dynamic effects, well, collusion or coordination really is illegal. And in fact, Noah Phillips, the FTC commissioner, very clearly states that why do we need a mechanism? Well, until we have a mechanism through which common ownership affects product market outcomes, and we're no longer disputing that the product market outcomes are there, but now we're looking for this mechanism. And that's exactly what this paper is about. So first, I'll talk a little bit about the theoretical framework. It's actually a very simple theoretical idea that just combines three ingredients from three different fields. You have a managerial incentive design problem, so they're going to be managers in our model. They're going to be pricing specialists, so that's the industrial organization part of this. And then there's going to be corporate finance aspect, which is that you have common owners or investors. Basic idea, and this is where kind of for those of you who are just interested in the mechanism, the main idea is that more common ownership leads to lower managerial incentives at the firm level. That leads to essentially managers slacking off, enjoying the quiet life. That leads to lower productivity at the firm level, which in turn leads to higher prices, lower quantity, and lower concentration at the product market level, as well as to even within firm variation across markets. Very much in line with all of these empirical studies that I previously showed you. So the mechanism that we propose is one that reconciles the seemingly conflicting evidence that is already out there. I'll skip over the model really. The basic idea is just that you have a principal agent problem. You have these agency conflicts already between owners and managers. Okay? The managers just improve how well the company is run, but the actual pricing, that is done by a totally different set of people. Again, it's pricing specialists. So it's not that investors have directly an influence of what airline prices are being set. The only way that investors can influence the way the company is run is through an incentive contract given to the manager. And a manager can't decide exactly which prices to set. So the CEO of United doesn't get to set the prices. Instead, the only thing that the CEO of United does is how well run the company is. For those of you who are not really all that interested in theory, now is a good time to check your emails. Okay? The basic reminder here is just that this model is totally standard. It has pricing specialists in there that really decide on the prices. It has a top manager in there that just decides how well and how hard do I work, how well run is my firm. And then finally, we have owners. This could be the largest owner, it could be a majority owner, it could be a coalition of owners. The model allows for all of these to essentially then say, okay, what is the incentive slope that I'm going to give the manager? How hard do I want my manager to work? Okay, everything here is super standard. It's just a combination of three different fields here. Now, what is the key intuition again? Let me repeat it. The main idea is that if you are an investor, you want your company to be run very efficiently. So therefore, you give strong incentives to the CEO. Therefore, when the CEO has strong incentives, he exerts a lot of effort. That's the EI here. Okay? That productivity improving effect has three effects. Again, totally standard. It increases the margin. The firm is more well run. It also has a price effect because the firm is more well run now. It expands its output, expands its market share. There's a third effect, which is this competition effect, which is that as I expand output, as I lower prices of my one company, then that lowers the competitors' profits. Now, an undiversified owner, okay, one that doesn't care about profits of other firms, so the kappa ij that I have down here is 0, they only care about those first two effects. But a common owner, they care potentially about, to some extent, the profits of other firms in the industry. They're going to care about that third effect. What is the upshot of that third effect? The upshot of that third effect is that those common owners, they do not want to set such strong incentives for the managers, because that would mean that the firm is then competing too aggressively in the product market. Okay, that's the basic intuition of the model. I'm now going to give you what the interpretation of this is. What happens here is that actually the common owners are excessively deferential towards managers. You can even call them lazy owners. They're super passive. They just sit back. Okay. Now, here, this is optimally chosen. This is very much in line with a trend that we observe over and over, that we would want to have more corporate governance. We would want corporate governance to be stronger, because that would make firms run more efficiently. But here, these owners choose to be passive because it is in their interest to be passive. They sit back, they let the CEO just enjoy the quiet life. And that's why those companies are not so well run. And that's why they compete less aggressively. And the model explains, therefore, why the common owners are passive. So the managers get to enjoy the quiet life. The common owners are passive. There is no intervention. There's no need to push for lower compensation contracts here by the common owners. Something that is perfectly sufficient is just to say, I'm not going to bother with anything here. I'm not going to intervene. I'm not going to pay these governance costs of intervening with managers. I'm just going to let them enjoy the quiet life, okay, which will then lead to softer competition. So to paraphrase John F. Kennedy, the only thing necessary for the triumph of anti-competitive common ownership is for good governance to do nothing. Okay? So really what we have here is a situation where passivity explains all of those results. Now, of course, you might be interested, okay, with this passivity, how can we get then variation across different firms in the same industry? Our model also accounts for that. So for example, we have an explanation for why Virgin America, before its merger with Alaska Airlines, why they competed so aggressively. Well, all you need to do is look at the ownership structure of Virgin America. It has large undiversified investors, Richard Branson, Cyrus Capital Partners, and Virgin Group Holdings Limited. Those people pushed for very, very strong incentives for their managers. What happens then? The managers really made the firm run very competitively. Okay? That wasn't really great for all these other airlines in the industry. But Richard Branson and Stephen Freidheim at Cyrus Capital Partners, they didn't care about this, because they were only interested in the one firm that they care about, which was Virgin America. Very different, of course, to the ownership structure of all these other airlines that I showed you previously. So what can happen in this type of model is that you can have variation across firms, so maverick firms competing very aggressively, like this firm 1 here that I have in red, and then other firms that are more commonly owned, like firm 2 and 3, actually competing much less aggressively. Interestingly, what this can also then lead to is that you can get price effects that look like collusion, namely that the two commonly owned firms, when they compete against each other, they're going to actually compete even more softly than when they compete against the maverick. But that is not driven by any form of coordination or collusion. None of this is necessary, but it's actually just driven by endogenously determined costs, which are in turn influenced just by the managerial incentive contract. Okay, now that allows us now to reconcile all of this empirical evidence. So our theoretical model explains all of these empirical studies and proposes a very simple mechanism that says all of that is necessary to generate these anti-competitive effects of common ownership is passivity of large investors, which in turn translates into passivity or laziness of the managers, which in turn translates into anti-competitive behavior, i.e. soft competition in the product market. Now, let me reinforce here, and I think there's always a bit of confusion here. These theoretical results do not rely on owners using sophisticated market level incentives, or on top managers knowing the underlying ownership structure, or top managers making market specific strategic choices like pricing, or product market specialists knowing what the owners own in other firms, or what the top managers' preferred strategies are. None of this is necessary. It is totally robust to different informational assumptions. Now, that clarifies a fundamental misunderstanding in corporate governance literature. People have mentioned the arguments of Babchuk et al., okay, namely Scott Hurst and Lucien Babchuk, that have claimed that really these common owners, they don't have incentives which would lead them to limit intervention with portfolio companies, because it will be implausible to expect that the index fund managers would seek to facilitate significant anti-competitive behavior. Now, what we very clearly show is that it's passivity. You can be totally passive, okay, and you would still get anti-competitive effects of common ownership. So there doesn't need to be any form of intervention of common owners. Passivity is enough. Or, for example, Rock and Rubenfeld claim that, well, while shareholders have a periodic non-binding vote on management compensation, this is too blunt an instrument to be plausible. Well, we show in our theoretical model and then later also with our empirical analysis that this is not too blunt an instrument. Management compensation is the only thing that's necessary to drive all of these anti-competitive effects. And it's certainly not true that the manager has to know what the owner's specific interests regarding specific competitive actions are, and they don't have to decide how much weight to give each owner's preferences in deciding what they do. All they need to do is respond to the very, very simple incentive contract given to them. Now, I will spare you some of these other details that are probably more interesting to an economics audience, so I'll just skip over them here. I think one important thing, though, to recognize is that what you have here is a principal agent problem between managers and shareholders. And that means that we cannot take it as given that the investors directly translate their own interest into corporate strategy. It has to be filtered first through managers. So I want to conclude here and just say that what this paper says is that managerial compensation is a very simple mechanism through which common ownership can affect product market outcomes. The mechanism does not rely on any implausible assumptions about what investors or managers do. The theoretical predictions can explain the empirical evidence that already exists on product market outcomes. And as Mireille Chinet will show you, the empirical evidence that we'll present also confirms the negative link between common ownership and managerial incentives. Okay, I'll leave the floor here now because I've gone on too long to Mireille Chinet and to the other panelists. Thank you.
Thank you, Florian. That's fascinating. And I want to take a moment, if we can, to ask your colleagues on the panel, Mireille and Josh, do you have any thoughts or comments or particular question you might want to address to Florian at that point?
Not on my side. I will. I might discuss with him after I do my part.
I will take the chance and throw a question out to you, Florian, on the model. So did I understand correctly that your assumption is that common ownership increases what we often call agency costs, kind of broadly defined?
Only endogenously. Okay, so it's true that that is a result of the model. It's not that that is an assumption. Okay. It is endogenously arises that the agency conflict gets worse in some sense because the managers get lower incentive slopes. Okay, and so that in some sense magnifies the efficiency losses that you would always see in principal agent models.
So I asked this question because there's a new paper by my colleagues Zohar Goshen and Doron Levitt at Penn, in which they make just the opposite argument. Their argument is that common ownership enhances governance because it reduces the collective action problem. And I'm trying to think if that's inconsistent with your model or consistent.
I think that's I think that is very much a story that is complementary to ours, which is there are many other effects of common ownership One would be, for example, as you know, Doron has another very nice paper in the Review of Financial Studies together with Alex Edmonds, okay, that says maybe we learn something. There's learning by doing about governance, and holding several firms in the same portfolio allows me maybe to do better governance. Okay? So I view those stories as perfectly complementary to ours, because what really our key thing in our story is, and one that also the IO and the industrial organization literature has focused on, is one, what ours is specifically about product market competition. So all of this common ownership stories that exist otherwise, that are about collective action problems or that are about learning problems, they're not specific to any given industry. And all of that existing empirical evidence that has fueled this common ownership literature comes from like specific industry stuff. So it would have to be kind of explain those existing empirical trends to be conflicting or not with ours. But I don't view it as conflicting at all. I view it entirely as complementary.
Thank you. Thank you, Josh, for those additional insights. Let's bring on some more insight here, and I want to turn to Professor Janae, who specializes in corporate governance, executive comp, mergers and acquisitions, and she's currently engaged in examining how common ownership by institutional investors impacts corporate decision-making by companies in their portfolios. And her research has been widely published, and today she is going to present for us a mechanism for connecting common ownership to product market outcomes. Maria.
Thank you very much. Thank you for the invitation to present in this great conference. I'm based at IES Business School, so this is in Barcelona. So good evening from Spain, late evening from Spain. So as Florian, as Florian was mentioning, our theoretical framework provides some testable implications that I'm going to be talking about between the relationship between common ownership and top management incentives. So let me first provide some of the links between the theory and the empirics. So first of all, our theory considers that the totality of managerial incentives are what is here at stake, right? So when we talk about managerial incentives at large, we have to take into account all the channels. And here I would like to use Alex Edmonds and Dirk Genter's wording, in the sense that what they mention is that executive incentives must take into account the incentives provided by the changes in the value of executives' equity holdings. So what we are looking here is at the changes in these equity holdings, which would be the changes in executive wealth, rather than looking at year-on-year pay-to-performance sensitivity. Because if we focus only on these changes in salary, bonuses, and equity grants, we're just looking at a very partial way of incenting executives. And this part really dwarfs relative to the whole wealth performance sensitivity. So there are different measures of wealth performance sensitivity out there in the literature, and those are going to be connected to the type of CEO productivity that you model. Yeah? So if you model it as an additive function or a linear function or multiplicative, you're going to be able to choose between different measures of wealth performance sensitivity. In our measure, the CEO productivity is modeled multiplicative, and therefore we use the Edmonds, Gabet, and Landier. But conceptually, for those of you that have never thought about this wealth performance sensitivity, what those measures estimate is the change in CEO wealth for a percentage change in firm value. Yeah? And there are going to be small differences with regard if the CEO productivity is additive, linear, or multiplicative. The second element, the second connection between the theory and the empirics is that the theory, as Florian was mentioning, uses profit weights. And the profit weights, this is going to be the weight that shareholders, for example, this would be as kappa, so kappa ij, right? This is going to be the weight that shareholders I put on firm J, yeah, on firms J's net profits, right? So this is a coefficient of sympathy, as we say, right? In the interest of other competitors' profits. This kappa can be then added, right? We can do a value weighted at the firm level, and it can be weighted by the stock market value weighting of all these competitors, or it can be equally weighted. Okay, so these are the two main connections: wealth performance sensitivity and CAPAs, that are driven from the theory onto the empirics. When we look into the data, so executive data will come from ExecuComp, and here, which covers all companies that are or were part of the S&P 1500 index. And the measures of wealth performance sensitivity, those come from Alex Edmonds directly. He was generous enough to share the code, and we updated it to cover these measures up to 2019. Then firms' information obviously comes from Compustat. And interestingly, for those of you that work on ownership, right, so we use the 13F data, but we augmented by scraping data from the SEC 13F filings directly because of known issues, especially from the 2000 onwards, known issues on stale information and omitted information on institutional owners. So that as well is an important addition as well. Our universe is from 92 to 2019. And this is our baseline specification. So on the left-hand side, we have wealth performance sensitivity, the different measures of wealth performance sensitivity, and how this is going to be affected by common ownership. As well, we will control for a vector of important controls. This specification closely follows Edmonds, Gabet, and Landier when they measure the effect of size on wealth performance sensitivity. And here we extend this model, which naturally follows our theory, adding the different measures of common ownership. Of course, this is panel, and these are, there are going to be correlations, but importantly, we're going to add here fixed effects. So we want to control for industry trends, those industry trends that are going to be correlated potentially with common ownership rising, let's say, and correlated as well with long-term trends in managerial incentives. So industry trends are going to be controlled, and as well, we're going to control for firm characteristics. Some omitted characteristics could be as well correlated with these two measures. So what we are hopefully capturing with this specification is within firm and within year variation. Okay, and I'll show you a battery of robustness checks. Okay, so this is our main table. And essentially what we're doing is regressing wealth performance sensitivity on common ownership. And we have here CAPAs equally weighted and value weighted. Let's focus on column 1, right? So column 1 shows us a negative and very significant coefficient. And we observe as well that for column 2, when we take into account the value weighted measure of the CAPAs as well, we have a very similar coefficient and significant as well. This is both for industry definitions following CRISP, following Compustat, and following as well the measures of Holberg-Phillips. To put these coefficients into perspective, so the first coefficient with respect to SIC CRISP, if a corporation moves from, if the corporation's CAPA moves from the 25th percentile to the 75th percentile, that shift means a 6% decrease in wealth performance sensitivity. Okay, and we're showing how this is very much in line with changes in one standard deviation from the volatility, which has been as well captured in the literature. Okay, so what we get from this initial table is that for the CAPA measures that come directly from the theory, we have a very robust coefficient that is negative and statistically significant across different industry definitions of competitors. Next, I want to show you the effect for different measures of common ownership. The second column shows you the coefficient for the cosine similarity. So CAPAs can be decomposed in two, can be decomposed cosine similarity, really looking specifically at the correlations at the commonality of ownership. And we observe as well a negative and statistically significant coefficient. And the top 5 overlap, the third measure here, as well. This would be a very intuitive, if you wish, naive and detached from the theory, which just accounts for those top 5 owners that have as well stock in my main competitors. The last measures that I would like to point you out, these are the standard measures, the MHHI-D, value weighted and equally weighted. These are at the industry level, and we thought that were interesting as well to portray since have been extremely popular in this first wave of common ownership literature. All right, so overall, these tables show us that as well across these measures, these results are very robust. Next, I would like to show you for the main three measures of common ownership, the effect on the other two measures of wealth performance sensitivity, the Jensen and Murphy and the Hall and Lippmann, that capture slightly different variation in wealth performance sensitivity. And as you can see as well, we see negative coefficient and statistically significant. And finally, the question is this only happening for the CEOs, or is this as well affecting top executives? And as you know, ExecuComp provides information on the top 5, at least the top 5 executives. When we include this much larger set of executives, again, very robust, negative and statistically significant effect of common ownership on wealth performance sensitivity. Good. So summary of these panel regression results, there's clearly a negative relationship between common ownership and managerial incentives across very different dimensions and robustness checks. And if we have to think about the economic magnitude, if we think of kappas moving from the 25th to the 75th percentile, this is associated with a decrease in the CEO wealth performance sensitivity of 6%. And this is quite similar to estimated effects in the literature with regards to firm volatility. So it's really much on a par. It seems to be a reasonable effect. But of course, you are all probably thinking, well, but can you just give us a more of a causal estimate here, right? Because yes, our theory assumes that there is exogenous ownership, right? But when we go into the data, this is not realistic. So it could be the case that there are changes in the firm's product market strategies that could drive both changes in common ownership and changes in the structure of executive compensation. So how do we deal with that? How do we go one step further? And here we use a quasi-experiment, we would say, where we use additions to the S&P 500 of industry competitors. And we think that this could be potentially a good exogenous shock. And let me tell you precisely how this works. This is presented by Boller and Scott Morton in a very recent paper. So essentially, imagine that you have an industry with three firms, A, B, and C. Two of them, A and B, are already in the S&P 500. Now, corporation C is added to the index, and therefore index funds that already own shares in A and B will be forced to buy shares C as well. So our treated firms, those firms that we are looking at, are both A and B. Those are already in the index, and therefore they experience an increase in common ownership. Precisely because they are already in the index, the addition of a competitor to the index, it's not going to change monitoring to them. It's not going to change attention to them, right? What we claim here, I'm going to show you in the data is, well, if now index funds have to acquire shares in C, in the competitor, that naturally will lead to more common ownership within that industry. So we believe that this is not a problematic shock like the standard index additions, where there could be selection, or mergers of institutional investors, or even index reconstitutions, right? Moving from the Russell 3000 to other indices, for example. Okay, so let me show you, the classic first stage here. So what do these graphs show us? So look at the blue line. This is the distribution of kappas on the left-hand side, or the distribution of the cosine similarity on the right-hand side. Before the inclusion, blue line. After the inclusion, the red line. And you see clearly that there is a shift to the right, right? So there is slightly more common ownership, more overlap after the inclusion. For CRISP, let me show you now the graphs for defining competitors through CompuStat. And let me show you now for Holberg and Phillips for robustness, right? So clearly across these different definitions of industry, there is this shift. This is the first stage. Second stage, well, the classic diff in diff specification. And what we observe here is that the treat times post. So here we are comparing treated firms, those that are already in the index, right, to controls. Those firms, sorry, treated are firms that are already in the index that experience an inclusion, yeah, versus firms that are in the index but do not experience an inclusion, times post. Okay, good. So as you can see here, these coefficients are negative and very statistically significant. Yeah. We use in this specification firm fixed effects and year fixed effects, and from column 2, 4, and 6, note that we add even inclusion fixed effects to this comparison between treatment and control, pre and post inclusion. And let me finish with some graphs that will give us very straightforward intuition of what's going on here. So what I'm showing you here, I'm plotting the coefficients of this estimation, right, of the diff in diff before. So from year, so here we see before inclusion and then after inclusion. So what we observe, there are two things that come out from these graphs. First is that before inclusion, these coefficients tend to be very similar to 0. And after inclusion, the effect is gradual. Yeah? It's not immediate, it's gradual. Okay, so this is for industry definition CRISP. We have a very similar graph for industry definition CompuStat. Before this, it's not distinguishable from 0, and then the coefficient starts to be slowly distinguishable from 0 and negative. And finally, going through the Holberg-Phillips definition again. All right, so summary of the diff in diff results. Again, a negative relationship between common ownership and managerial incentives. The index addition of competitors leads to a reduction of the CEO wealth performance sensitivity at index incumbents, and the effect is between 10 and 16%, depending on the industry definition. So it's slightly larger than, a little bit larger than our panel estimates. And the negative effect is not present before inclusion, that's important, and increases in magnitude afterwards. So let me conclude and reiterate some of the conclusions that Florian mentioned about the goal of this paper. So the goal of this paper is to present one possible mechanism among many mechanisms that would be out there, right? A simple mechanism which, through which common ownership can affect product market outcomes. This mechanism does not rely on implausible assumptions of what investors or managers do. On the contrary, assumptions are extremely simple and straightforward from canonical theory. The theory predictions can explain existing empirical evidence on product market outcomes. And finally, our empirical evidence, and I hope I've been able to show you clearly, confirm this negative link between common ownership and managerial incentives. So let me pause here and open to questions and debate. Thank you very much.
Thank you so much. Florian, do you have any follow-up comment on that?
Yeah, I think it's something that Josh raised with this previous question already is, you know, and I think it's also highlighted here in our conclusions, is that what this paper does not say is how much negative effects is there, or how big are these negative effects of common ownership relative to the positive effects of common ownership. So I would probably ask, I know, Mireia maybe to whether she can take a stance of saying what is kind of where do we land overall on welfare effects?
Overall on welfare effects, I think that, you know, what we are showing in our paper is something that is very specific, right? And I think that there is this tension between being specific and trying to be as precise as possible, right? So what we show is this negative effect negative effect in terms of incentives. However, this paper doesn't say anything in terms of the potential benefits that this diversification may have in other spaces. So I think that in this sense, right, when we say this paper does not say that common ownership is necessarily welfare reducing, there are other potential channels working in parallel or other effects. We are trying to make here a very specific point on a simple and plausible mechanism.
Thanks so much again. Let's turn now to round out the panel presentations with Professor Josh Mitz, who uses advanced data science for research on corporate and securities law. And his primary focus is on information disclosure and capital markets and consumer financial protection and related topics in law and finance, including in particular short selling. Now, Professor Mitz has extensively researched and is going to discuss for us today the role of short sellers in corporate governance, and particularly the relationship between short sellers and passive index fund investors. Josh?
Okay, thank you. It's great to see everyone. I wanted to give a roadmap for this project, which is really a multi-part project in that it really focuses on three big themes. The first, which I'll talk about maybe at greater length today, is an idea that we should think about short selling in the capital markets as more than just a type of trade that one can engage in on the stock market, but as really a form of delegated stewardship or delegated monitoring, which has the capacity to reduce agency costs and create value for well-diversified passive index funds in particular. A second part of the project looks at how the rates that large institutional index funds charge to lend their shares to short sellers are in fact de facto sensitive to negative information that is out there about firms which might be the target of short seller campaigns. And because short sellers have to pay in order to borrow shares from large passive institutions in order to open a short position, this necessarily implies that passive investors share de facto in the price decline to some extent. And the question that we should be thinking about is how much and what's the nature of that profit sharing. Finally, the third point is that passive investors with market power end up actually, I find, constricting supply and raising share lending rates in order to maximize their profits. This is, I think, important in light of our discussion in this panel of common ownership. This is really not so much technically, I think, a product of common ownership as it is a product of concentrated ownership. But since the two inevitably go hand in hand in today's markets, I think this is an important aspect that we should be thinking about. So I want to start by conceptualizing the role of exit in corporate governance as it was traditionally conceived of. So a great paper on this is by Alex Edmonds in 2009, and really one can go back to my colleague Jack Coffey's work in 1991, which sets out the following simple story. Suppose a shareholder observes some kind of negative signal about the value of the firm. Well, we've been spending a lot of time today talking about voice, about ways in which shareholders might try to change things at a company to increase its value or reduce the private benefits of control. An alternative is to just sell their shares. And the point that's made in this literature is that the very act of selling shares by existing shareholders will put downward pressure on the share price. That downward pressure will in turn discipline underperforming management, inducing, for example, a hostile takeover or activism or some other form of governance intervention. And the key idea here is that in the classical paradigm, selling one's shares is in effect an informationally sensitive event. it has to be informationally sensitive. And by that, I mean, the information that the shareholder has is not yet in the stock price, because otherwise the exit would not have the effect of disciplining. It wouldn't do anything to the price if the price had already fallen. So at the core of exit models is the acquisition of information, negative information, and the transmission of that information to the market by selling one stock. Now, a point that Jill Fish and co-authors have made in their 2019 paper is that the rise of index investing precludes ordinary exit. It precludes ordinary exit for the very reason, the simple reason, that large institutional investors who pursue an index investing strategy are by definition not trading on firm-specific information and have no incentive to monitor individual portfolio firms. That's long been understood as a consequence of diversification and the passive strategy. The claim in my project here is that despite these inherent limitations on exit in the passive investing context, passive investors can nonetheless delegate the monitoring that would have occurred, this sort of exit-driven monitoring, to short sellers. What are short sellers? Well, short sellers are financial market participants who sell stock first by borrowing shares, and then they go ahead and repurchase those shares, hopefully some point in the future after the price has fallen. Because a necessary predicate, especially under Reg Show, is that short sellers have borrowed, located shares to borrow and sold shares that they have borrowed before subsequently repurchasing those shares. It thus follows that share lending is the means, the mechanism by which this sort of institutional delegation occurs. That is to say, the very fact of borrowing shares to sell means that passive investors who are lending their shares to short sellers are in effect a critical component in the mechanism by which short selling can happen in the markets. Now, one might ask yourself, why is it that an index fund who has a large diversified portfolio would even be willing to put their shares up for borrow? Or another way to put this is, why would they care about short selling in their portfolio as a whole? I mean, for one, they may want to just collect the lending fees, but as we'll see shortly, the lending fees from securities lending are really quite small. So there's actually not a powerful rationale most of the time for collecting a lot of revenues via lending fees. But one, when viewed through this exit lens, one can see that the reason why passive investors might want to, in effect, contract and profit share with short sellers is that short selling can be beneficial to a diversified portfolio. My colleague Jeff Gordon refers to these kinds of benefits, agency cost reduction and other portfolio-wide benefits, to actions that affect the value of a single security. He refers to those as governance externalities. And so a central part of the theoretical claim here is that short selling can be beneficial for a portfolio because it enhances the value of a portfolio. Short selling a single stock can impose positive externalities on a portfolio as a whole. That is to say, we should think about short selling not just as a trading strategy, but as a way to enhance the fundamental value of a portfolio by deterring fraud, mismanagement, or otherwise enhancing the stewardship of companies across a portfolio as a whole. And for a recent example of this, you can look no further than the famed case of Nikola, which involved a short seller who pointed out that this company had arguably fabricated a truck rolling down a highway, a truck moving along a highway when it was actually on an angle and rolling down the highway. This was their manufacturer of electric truck. And the big claim in this research report by the short seller was that this is a sort of a fraud in a sense. This was, as the short seller claimed, that the truck was not actually moving, but rather had been positioned on a hill. And I should at this juncture say that my hands are far less clean than Florian's. I regularly serve as an expert witness and a consultant and advisor and testify in cases involving short sellers and market manipulation. You can read on my CV for that disclosure if you'd like to see more. I'm also an advisor to the Department of Justice, more generally in areas of manipulation and securities fraud. So I come at this from having seen these issues on all sides. And this is a pretty powerful claim, right? This is a claim which says, look, this company is a fraud. And in fact, that allegation led to the founder of Nikola resigning from the company amid these allegations that, among others, that the commercial and so forth had been faked, but there were a series of other problems which sort of followed in the wake, including an announcement of government investigations of Nikola. So one can see this sort of action, this sort of short selling campaign as a kind of value enhancing operation in the capital markets, by which I mean other firms who might be in the position of Nikola are going to be deterred lest they become the next target. And so really the claim is that short selling can be a kind of delegated stewardship, a kind of delegated monitoring, whereby short sellers can hold companies accountable on an individual firm by firm basis by selling stock, by driving the price down when those companies are failing to take actions that would maximize the value of the portfolio, like not engaging in agency costs or fraud and manipulation. The key question when one thinks about short selling through this paradigm is how to align incentives between shareholders and short sellers. After all, short sellers profit when share prices go down. Diversified shareholders profit when declining share price for a single firm increases portfolio value as a whole. Of course, the shareholders of a firm whose price is declining, their interests are diametrically opposed to the short seller in that case. But again, here we're thinking about the portfolio as a whole. The question is, if short seller profits are larger, when they have more damaging information, if you will, better information, stronger information about a single stock, when does that imply that the value of a portfolio is going to be higher? And it seems that the contracting problem that we have here, what we really like to do is to align the incentives of a short seller in a single case with those of a portfolio as a whole. That is to say, we want short sellers to have the strongest incentive to go after a single company like a Nikola, when doing so would be most likely to deter fraud, manipulation, or otherwise, or promote other goals that investors have, even, for example, ESG goals more generally, across a portfolio as a whole. In effect, this is a contracting problem, and one that is made particularly difficult by the opaque nature of share lending markets. And I'll say a little bit about that. Securities lending is a very unique kind of market, and that it involves a number of legal loopholes and exceptions. And for the lawyers in the audience who worked in this area, you know that it begins with Rule 17F2C to the 1940 Act, which allows mutual funds to lend shares so long as the shares are collateralized to the extent of their full market value. This has led to a practice of volume versus value lending, in which some large institutions will lend a lot of shares at a very low lending fee and collect money on volume. And most of their returns are actually generated by reinvesting the cash collateral that they receive from short sellers, from their brokers. Another much smaller segment of the market that I'm really interested in is the value lending segment of the market, which is really, I think here, Vanguard would be the most well-known. Value lending seeks to capture a scarcity premium by lending hard-to-borrow securities or specials. These provide lenders with a high return per dollar of securities, though with fewer opportunities. So it's a small volume, high return, high rate situation. In effect, value lending is employed in situations where a short seller is willing to pay a high price for the opportunity to borrow a security. And that means that value lending programs are likely to be the situations where there's negative information about the firm. One can see that simply by thinking about the willingness of a short seller to pay a high lending fee. They're more likely to pay a higher lending fee when they expect to make more money from the short position. The key, I think, point to realize here is that what my research finds is that passive exit, this sort of delegation to short sellers, is informationally sensitive, just like ordinary exit. And what that means is that while index funds and ETFs cannot sell shares directly, they enjoy, in fact, de facto higher rates when lending to short sellers. That is to say, simply by operation of supply and demand, there's greater demand to borrow stock, and thus share lending rates on average will increase when there is negative information. Thus, that implies that share lenders and short sellers are de facto profit sharing. Now, the magnitude of this profit sharing is an open question, as is the microstructure, if you will, of this market. How exactly does it come about that passive investors, lenders like your BlackRocks and Vanguards, and particularly Vanguard in this case, can in fact participate in this market in such a way that they maximize their returns? And that's really brings me to the sort of last 2 points that I touched on at the outset, which is the question of whether this is a demand side or a supply side story, or both. What do I mean by that? Well, the demand side baseline story here is just that passive investors share in the surplus from shorting just by lending their shares. Increased demand drives up the rates, and therefore there's de facto profit sharing. This is true even if passive investors have no information themselves. One could imagine that this could be visualized as the arrival of negative information makes share lending rates go up. This is what we see in the data, and I'm not going to get into the data for the time, but I have an empirical paper which illustrates this. I think the open question, I'll wrap up shortly here, is whether there's a supply side story. The supply side story would say, look, from the standpoint of a securities lender, profit sharing is likely to be maximized when they both have negative information about the firm and there's sufficient market power such that a share lender can price discriminate against borrowers. What I mean by price discriminate in this setting is that if a securities lender is informed, they can adjust the lending rate in theory based on the value of the information that they have, exploiting the fact that they may be a monopolist. It turns out that in a great many cases, Vanguard is in fact such a large owner of the shares of an issuer that they in effect likely possess market power, and this is often driven by the need of short sellers to acquire a large block of shares from a single owner. This is in fact an implication of concentrated ownership. It thus follows that raising prices can serve two functions. One, to maximize lender revenue, and two, raising prices could be a way of screening for more informative short sellers. Of course, this takes us back to the question at the outset: are more informed short sellers also better at generating value for a portfolio as a whole? That's an open question that I haven't yet come to a view on. There's an empirical study, which I'm not going to spend much time on because we're short on time, but I'll just say that what I end up doing in this paper is look at information flows between the active and passive side of a fund family. Turns out that there's no barrier on sharing information between the active funds that are affiliated with, that belong to a fund family, which is also lending its shares like a Vanguard. And it turns out that even when you have externally managed funds like the Vanguard Wellington Fund, in the case of Vanguard, there is in fact a explicit disclosure which allows daily ongoing transmission of portfolio decisions to the passive side, really to all of Vanguard as a whole. And I've spoke with some insiders at these funds families who've said to me that share lending desks are in fact like trading operations, seeking to use every bit of information that they can to maximize revenues. For the sake of time, I won't get into the empirics so much, but what in fact we see in the data is that when there's a change in the identity of an active management team, which I use as an exogenous shock to the transmissibility of information between the active and passive side of a fund family, that is followed by a change in the lending rate. So there does seem to be some supply side component, and the identification here is off of this supply side change. Last thing I'll say is that this does seem to be driven in the data by Vanguard, by the exploitation of negative information via value lending programs. And when you try to calculate what that profit sharing looks like, it ends up being on the order of between 62 to 87%, depending on which model you use. So it turns out that, Vanguard is extracting, it seems, quite a bit of the surplus that short sellers would be making. This is consistent with their market power. It turns out that the price declines here are large enough that it's still worth it for short sellers to engage in these campaigns, even when they pay a high price. I'll stop here, and I would love to talk more in the Q&A.
Thanks, Josh. Mirjane has raised a question in regard to your presentation. She asks, and Mira, excuse me if I may do it, what determines lending rates, and to which degree there is market power versus being competitive, and what's the evidence on whether they don't lend or recall the votes when an important vote is coming up?
I think the first part of the question refers to your last slides when you're showing the actual distribution of the surplus, right, between how much Vanguard manages to capture. But if you could explain, develop a little bit more of that empirical side, that would be excellent.
Sure. So just for the sake of time, I'll give a quick overview, and we can continue this after. What I basically do is say, if we get disclosure on a monthly basis of portfolio changes. So there's some limitations to how rapidly we can see portfolio changes, but the idea is to say, if you have a situation where by next month, a company has been removed from an active fund portfolio, that's a proxy for some negative information that arrived earlier. And then you can look back and say, all right, so I have daily share lending rates. How much did rates go up by? And if we take that as a fraction, or if we run a regression where we're just going to look for the average correlation between the increase in share lending rates that's attributable to some supply side change, and we compare that to like an abnormal return, how much did the stock price change? You can kind of get a rough estimate for the increase in lending rates, the share of the abnormal return that's sort of captured by the increase in lending rates, and it's spelled out more in detail in the paper. And I should say that the number you get is pretty high, but that's going to have really two components. It's going to have a supply side change that's going to be part of that. A part of that is just the demand side, that prices are going to go up when negative information arises. What I try to do in the paper is to separate those two out, but that overall fraction is going to have both components in it. Right. So in effect, this is the extraction that's happening de facto when viewed the rates against the stock price change.
Thank you, Josh.
Thanks, Florian. One of our panelists from earlier today, Cindy Alexander, has raised a question that I think is perhaps best directed to you. Cindy, would you come on and just directly pose that question for Florian? If you're there. There she is.
Yes, I'm here. Yes, I'm here. So this goes to linking up our panels, because there's a question of whether agency costs are going up or down in these portfolio companies. And I thought that something you said was pretty intriguing. So you're suggesting that the mechanism for going from common ownership to higher prices is lazy managers, which I think of as a slack problem. So my question is, who's getting the rents here? Because it looks like if there's slack in management, that means that we have pretty happy managers, but I'm not sure that we get benefit to shareholders.
Yeah, first of all, I think it's a great question that gets at the heart of the mechanism. Number one, I want to say is that it's not necessarily lazy managers. It can be lazy managers, okay? So it can be very much in line with this sort of enjoying the quiet life a la Bertrand Muller-Nathan, one of the most influential papers in corporate governance over the last 2 decades. Our model endogenously generates this. Now, Cindy correctly points out and says, well, if there's more managerial slack, okay, where do these rents go? In our model, actually, these rents they don't go necessarily anywhere. There's just rent dissipation. Why? Because you're holding the top manager still to his outside option. So whether he's exerting a lot of effort or whether he's not exerting a lot of effort, in equilibrium, he always gets paid just his outside option. Now, of course, that's the contracting view, and there's now questions of like, maybe the right way to model stuff is the skimming view. Our model can also accommodate that. So the skimming view is that you let the managers just do whatever they want, and they extract enough rents by not working very hard and just getting very, very high base salaries with little performance sensitivity. One additional thing about the extraction of rents here that I would like to speak to is like, there's also additional rent dissipation here. Where's this rent dissipation come from? Well, it's common owners, they give lower managerial incentives, therefore the firms are less productively run. That doesn't necessarily mean, though, that those firms are actually less profitable. Why? Because you also get the benefit of weaker competition. So you get soft competition that is, and these gains that result in higher profits from softer competition are somewhat dissipated by less productively run firms. Now, the firms that really benefit from all of this are actually the maverick firms, the Virgin Americas and so on in the world, because they directly enjoy both the strong managerial incentives, a productive efficiency, while at the same time also benefiting from the weak competition or the less aggressive behavior of commonly owned firms.
Cindy, you're muted.
It seems very important because it gets to how you're closing off your model. And if it's slack, the way we normally think of it in management, I know we had in other panels a discussion of other mechanisms for intervening, like hedge funds. So I can imagine someone who hears your presentation thinking they should go set up a fund and start picking off. And this is back to, you know, do you have is your equilibrium intervention proof? And maybe you want an intervention proofedness assumption here.
Well,
and we can, that would be its own literature, right?
Yes.
Because if you're really in your equilibrium, because you closed it off, you don't really have an outside intervener as a possibility. If there's an outside intervener, then it becomes more important where the rents go.
Great question. And so our model, you know, sort of assumes that the ownership is exogenous. Okay. Now, of course, you could say, well, now what if we allowed activist investors to pick up those firms that are inefficiently run? Okay. Because we would just give the manager strong incentives. Now, it's actually not clear cut. Why? It's not clear cut because those firms also benefit from the weaker competition. And so if you allow, we're picking up those firms that were previously inefficiently run, and you make them run more efficiently, that also then leads to more intense competition.
Well, but they're chiseling on the coordinated agreement, so it should fall up.
Well,
I'm still thinking some student somewhere should have a fund.
I think the moderator is going to agree with that and exercise, unfortunately, some administrative authority here. Cindy, thank you for those insights and Florian and all the panelists. Fascinating presentation. We have come to, we spent our allotted time, and I'm sure that you can have lively conversation outside. Juliet, I'm going to turn it over to you. You have the next panel, but you also may want to set the time up here for what you're going to do with it. So with that, again, my thanks to our panel. And Juliet, I turn it over to you.
So normally we have a 5-minute, 10-minute break in between panels, but we could just go right into it. What are people inclined to do? I guess I'll just take the lead here and say that we'll just proceed. Anyways, my pleasure to welcome the last panel of the day. It's certainly been an intellectually stimulating set of presentations, and we've gotten lots to think about. I want to introduce the last panel on environmental social governance investing to tell you a bit about the speakers. So we're delighted to have the Honorable Mikhail Agman-Gonen, with us. She is a judge at the District Court of Tel Aviv, and she's also a professor of corporate law at Tel Aviv University, the Buckman Faculty of Law in Israel. She is the co-author, along with Anat Beck and Darren Rosenblum, of a paper that's been talked about today called No More Old Boys Club, Institutional Investors' Fiduciary Duty to Diversify Corporate Boards. And our first speaker in this panel will be Eric Chafee. He is a distinguished university professor at the University of Toledo. It's wonderful to have him back here. He was a colleague of mine for some time. He's an expert in business law, contract law, tax law, and trust and estates. His scholarship focuses on business and tax law with an emphasis on securities regulation, cyber law, compliance, and business ethics. He is the author of 2 leading treatises, one on securities regulation in cyberspace and one on international securities regulation. His work has appeared in numerous law reviews, as you can imagine. Before coming to the Academy, he was a lawyer at Jones Day. Professor Madison Condon is here from the Boston University School of Law. She began as an associate professor in July of 2020. She teaches environmental law corporations, a seminar on climate risk in financial institutions. A focus of her recent research is on climate change's relationship to corporate governance, market risk, and manipulation, and corporate governance, market risk, and regulation. She also has an interest in the manipulation of science and economics and administrative law. So she finally was a Fulbright Fellow in the Netherlands, where she researched water resources at Delft University of Technology. So we have a wonderful group of speakers to talk about environmental social governance in the context of index funds. As you have heard today and already know, there's been increasing pressure by shareholder activists like Larry Fink to advocate for responding not only to shareholders, but also to stakeholders. In that context, we're going to have 3 different perspectives. Eric Chafee is going to address index funds and ESG hypocrisy. Professor Condon will address market myopia's climate bubble, and Judge Agman Gonen will focus on what the pandemic means for focusing on ESG. So just a couple of reminders. First of all, if you have a question and you're in the audience, you should put it in the Q&A, and I will convey that question to the panelists. The other thing is panelists should feel free to pose questions by chat, and we can monitor those. Finally, I will give our panelists a note that you're at 15 minutes and then a note that you're at 20 minutes. So with that, I'm going to turn the first presentation over to Eric Chafee, and it's just wonderful to have you here.
Nice to be here. Thanks for that great introduction. Hopefully I can live up to it. I'm not sure if I can. Yeah, it's wonderful to be invited to this. Each one of the moderators, Anat, Bob, Charlie, and Juliet, are all people I respect, all thought leaders, and that goes for a lot of cases faculty. So it's an honor to be part of this and to see so many old friends on the agenda and make some new ones. So the title of my presentation is Index Funds and ESG Hypocrisy, going along with the general notion in the Academy that you ought to have a provocative title that really draws people in. I think another title that potentially I could use here is Jack of all trades and master of none, meaning that in terms of thinking about this topic, really my concern is not with the importance of index funds, not with the concern with the importance of ESG, but really a concern about whether or not they can actually be married together in any sort of coherent way. In terms of what I plan to talk about, I'll talk a little bit about the intersection of index funds and ESG through the language that the big three are actually using on this issue. After that, I'll talk about the problems with pursuing ESG through index funds, and then a few of my solutions. And I'm really excited to hear the thoughts of the audience on this and the other panelists on this, because there's a lot to say on this particular issue, which is why it's so wonderful that CASE decided to hold this event. So in terms of thinking about the intersection of index funds and ESG, one of the places we can actually start with, or probably actually should start with, is a statement by the big three themselves. BlackRock, for example, in its 2020 letter to CEOs stated the following: where we feel companies and boards are not producing effective sustainability disclosures or implementing frameworks for managing these issues, we will hold board members accountable. Given the groundwork we have already laid engaging on disclosure and growing investment risks surrounding sustainability, we will be increasingly disposed to vote against management and board of directors when companies are not making sufficient progress on sustainability. Very important point. It goes along with David Weber's statement earlier today about the escalation of ESG that's going on with the big three, meaning that they are all competing for those millennial dollars, and as a result of that, all of them want to be seen as the leader in this issue, in this particular area. And what it means as a result of that is that they're likely to continue to push on, trying to make headway, or at least putting out rhetoric that suggests that they plan to make headway in the ESG area. Notably in regard to that, we see similar sorts of statements from State Street, this from a 2018-2019 stewardship report from State Street. Significant challenge for asset managers with index strategies invested in thousands of listed companies globally is to provide active oversight of their holdings. As noted, our stewardship program identifies a series of strategic priorities designed to enhance the quality and define the scope of our stewardship activities for the year. Notably, what that communicates to us is something that first off was implicated by Jill Fish's presentation at the beginning of the day. We're talking about portfolios or funds that have portfolios of literally hundreds, if not thousands of companies, meaning that ultimately you're going to end up with some monitoring problems. And implicit in this statement from State Street and going along with Bernie Scharfman's statements earlier today, there definitely are monitoring issues, meaning that the stewardship functions of these investment advisors, while sizable, probably are not of quite the size that they ought to be for sufficiently monitoring the contents of their portfolios. And then finally, with Vanguard, we also see a similar statement from an April 2019 Vanguard Investment Stewardship Commentary. As they stated, we consistently engage with portfolio companies about climate risk, especially companies in carbon-intensive industries. We believe that climate risk can potentially have a long-term impact on companies in many sectors, but our discussions on these issues are anchored to a broader conversation about governance, in particular how a company's strategy and the related risks are governed by the board. Our index fund, by design, generally hold all the companies in their benchmark. These include winners and losers, leaders and laggards. And I think that last statement is really important, which is why I used an especially long quote. Essentially what this statement is that we think ESG is really important and we have a diversified fund, which is something that I think if you are going to push an investment related agenda based on ESG with index funds, it does lead to problems. And in terms of thinking about those problems, I think that they're threefold. First off, they create an unsolvable conflict of interest. Second, they create real concerns about the statements that are being made being materially misleading. And then finally, based on the fact that we have the big three essentially acting as regulators, we have some anti-democratic, anti-technocratic concerns going on here as well. Notably, we know that in regard to index funds, that they are really the grandchild, perhaps, of Harry Markowitz, who pioneered modern portfolio theory when he published his 1952 article, Portfolio Selection in the Journal of Finance, that he eventually won a Nobel Prize in economics for his work on this field. Modern portfolio theory essentially forms the foundation of these funds, and what it teaches us is that passive investors can gain consistent returns and mitigate risk through diversified portfolios. The issue becomes that when you're promising that you are going to push through an ESG agenda, what you're pushing through forward is conformity in a space where you're selling funds that at their core are supposed to be selling diversity. Certainly, this creates duty of loyalty concerns. The notion being that ultimately, if you view your primary focus of your duty of loyalty, which a lot of people do, to bring forward shareholder value, whether or not pushing forward conformity actually is what you ought to be doing when you've been promising value through diversity. Beyond that, in terms of thinking about these index funds, which are organized both as corporations and business trusts, Professor Rock's lunchtime presentation was absolutely wonderful in terms of thinking about some of the fiduciary duties and corporate purpose issues that go in this context. The business trust fiduciary issues are even stronger, meaning that we know within business trusts there are very robust fiduciary duties. You can, in fact, draft those out of a lot of trust agreements, which does happen regularly, but there is a duty of good faith that often is a backdoor to those coming back in many instances. And in terms of thinking about this particular area, beyond the duty of loyalty, when it comes to business trust, you actually have a duty of prudence, which creates a duty to diversify, which makes it potentially problematic if you plan to push principles through a wide variety of investment funds. And beyond that, and this was certainly implicated by Bernie's presentation, we know in the corporate form we have a duty of care, which is referred to as a duty of inquiry in the trust context. Is it really possible, if you're going to engage in activism, active management in regard to index funds, to really ever meet that burden? Meaning that with portfolios filled with hundreds of companies, can you effectively monitor them? Can you make sure that you are consistently pushing through principles and making headway in ways that you have actually promised that you will make headway? All of this leads to a statement that I think is rather Orwellian and probably belongs in the book 1984. What seems to be being sold here is the notion that diversity is conformity, meaning that ultimately somehow we're going to be able to push both of those things at the same time. And one of the responses to this is, well, you know, the smart money is going to realize that that's just not the case, that part of this is puffing, that it's advertising bluster and that sort of thing. And I buy those arguments in the vast majority of instances. You know, I know that Charlie Korsmo actually has a wonderful paper in the Iowa Law Review suggesting that the reasonable person is sophisticated and technologically sophisticated. The issue is when it comes to these index funds, as Jill Fish noted, the shares are mainly held by 401k investors. And as Ann Lipton talked about in her presentation, even people who are sophisticated 401k investors don't always think as deeply about their investments as they should. So this facial, superficial level of things, I think is important in a way that it may not be in other contexts when it comes to index funds because of who the who the reasonable investor is in this context. It may not rise to the level of creating federal and state securities law concerns, but at the same time, certainly in terms of thinking about all of this, the big three should be concerned about making sure that they are providing adequate warnings that pursuing or creating both an index fund and pursuing ESG goals may in fact end up being in opposition to themselves, and that there are genuine issues with actually trying to deliver on an ESG agenda when it comes to thinking about a portfolio fund that's filled with lots and lots of companies. Ultimately, in terms of thinking about this particular area, it's tempting because I signed on to a petition that Jill Fish and Cynthia Williams put together requesting rulemaking for the SEC on ESG. And I'm actually excited about it because I think it's material and I think it's something that the SEC ought to speak about. And this may be the best way to, in fact, start the conversation, or if something happens and we're still working through what's going on with the election, if the Trump administration were to remain in power, maybe the only way that we ultimately see any sort of ESG agenda push forward. But at the same time, it really is truly anti-democratic, meaning that if we're going to argue that BlackRock, State Street, and Vanguard are acting as regulators, well, we have people to act as regulators. They're called regulators. And ultimately, when it comes to addressing this particular issue, I think that there's real virtue to allow the SEC actually to act in this area. And part of that is that there's at least some evidence that what's going on here on the part of the big three really is bluster about commitment to an ESG agenda. Meaning that we have an op-ed from the Financial Times from July 24th, 2018, from the president and CEO of State Street Global, where he states the following. Efforts by large index fund managers to engage with public companies have recently come under attack from some business leaders. They complain that we are misusing our rights as shareholders to enforce arbitrary political or social values because we raise environmental, social, and governance concerns with the boards of directors of the companies in which we invest, which sounds like what they're telling millennials they're doing. The paragraph that comes immediately following that states, this completely misrepresents the mission of State Street Global Advisors and other large index fund managers. We seek long-term value for millions of ordinary investors in a world that has become increasingly obsessed with short-term results. That goal, not some political agenda, is why we have developed a rigorous research-based shareholder engagement program. And what that suggests is the conflict of interest that I was talking about ends up being even more complex than it was before, because not only do we have the tension between the diversity offered by index funds and then pushing forward an ESG agenda, it suggests that it's not really even a true ESG agenda at all. It's just simply a thinly veiled or a veiled attempt to seek profit maximization within these particular firms, which creates serious questions about the particular proposals that they are pushing forward, whether or not they're an adequate way to regulate the market, meaning that the best approach here, in fact, would be to have the SEC act. In terms of thinking about that and my solution, and there are a bunch of different solutions about how to deal with the issue that's foundational to the symposium, what to deal with the voting power of index funds. First off, I think that ultimately the SEC ought to promulgate reasonable ESG standards that tell businesses what is material and what they need to report in an understandable and usable way. Meaning that simply having that relatively amorphous materiality standard that is pervasive through securities regulation, in many instances is wonderful because it yields a lot of disclosure. In this particular area, I think that it's too daunting for businesses to have to deal with, meaning that there's so many different ways of engaging in this type of reporting that it does make sense to have rules here. Second, in addition to that, I think that there ought to be proper and discrete labeling of ESG funds and index funds, with index funds essentially being passive investors who ultimately are trying to gain profits and mitigate risk through diversity, and then ESG funds being more socially active. I think the mixing of the labels is problematic. As Ann Lipton noted, there's a wide range of funds that are calling them index funds because it's something that attracts investors. And because in many instances, it's attracting people who may not have a terrific amount of financial acumen and may not understand that not all index funds are not created equal, that there should be clear and better labeling in this area. Question then becomes what to do with index funds. I'm still working through that question. I'd like to see true passivity. There's a question of how exactly you do that. Maybe pass-through voting, that's something that you see commonly throughout the literature. Essentially, you let the investors themselves vote, although they don't receive true passivity as investors in that particular instance. Maybe you remove index fund shares from quorum requirements, which allows essentially the other share owners to manage the companies that are within these company or within the index fund portfolios. And then maybe in addition to that, it's one of those things where you figure out a way to either break up or maybe better put, segment the big three, meaning that really one of my concerns here is by having these very large investment advisors overseeing so much of the market that we're not getting that competition and that diversity of ideas that we really do need in this field, because we need good ideas on ESG. I think I'll turn it over there.
That's wonderful, Eric. Thank you so much. We actually have a question now in the chat from Bernie Scharfman. Bernie, do you want to ask the question, or would you like me to ask your question for you? It was a very good question.
Oh, I'll ask it. Hi, Eric. How you doing? The question I had, and this is what it's been bothering me, is about the fiduciary duties of investment advisors under the Investment Advisors Act. And I tried to engage with the SEC through the, comment letters on their proxy process roundtable. And I never really, I don't think really got any kind of notice or attention on that idea. But I think it's kind of an area that can be explored is, are these fiduciary duties, do they apply to basically what I consider the shareholder activism of the index fund, investment advisors to index funds? And basically I'm just asking, have you thought about that or not?
Yeah, and that's a great question. Certainly, there are a lot of issues there as to who has the fiduciary duties and what they are. My position, at least in this, is somewhat to gloss over that debate because that's worthy of a symposium or several symposiums in and of itself. My position is that these fiduciary duties are present somewhere. And maybe it's at the fund level, maybe it's at the investment advisor level. But at the same time, ultimately they are present somewhere within the structure. But yeah, I take your argument here that they may be present in some places and not others.
Okay, thank you.
So I will turn the next presentation over to Madison Condon, who is going to talk about climate change.
Thank you, Juliet. Thank you, Eric, and thank you, Anat, for inviting me. And I really enjoyed all of the presentations today. It's been really fun listening in and thinking about all the different ways they relate to the research I'm doing right now. So I'm going to talk about, so I find the term ESG pretty frustrating, as I think Eric indicated that he also does, because there's just too much going on in, is it diversity on boards? So I'm going to focus particularly on climate change and climate risk and argue about climate risk and climate risk pricing as being a material risk of interest to a broad range of investors, but particularly increasingly index funds. So my colleague David Weber thinks that BlackRock is talking a lot about climate change in order to attract millennials, and Bernie Scharfman and his Main Street Investor Coalition thinks that institutional investor attention to climate change is about fund manager political preferences at the expense of returns for individual investors. And I think it's actually absolutely a material risk, and institutional investor pursuit of climate risk disclosure is for the benefit of returns and market pricing. So there's a broad range of financial experts ranging from Hank Paulson to the Bank of England to McKinsey to BlackRock itself, a recent report from the Commodities Futures Trading Commission, that all indicate their belief and provide evidence that the market is mispricing climate-related risks. Last year, a coalition of 42 different central banks recognized that there is a strong risk that climate-related financial risks are not fully reflected in asset valuations. So in my current project, I'm thinking through this misprice, how this mispricing exist at the level of individual assets, and thinking through, drawing from the scholarship on corporate governance theory and the mechanisms of market efficiency. So Ron Gilson and a couple others has a paper where he argues that there's no reason to believe that equity analysts are systematically less able to assess the valuation impacts of climate change. And I think my project at this moment is strongly disagreeing with that claim and arguing that there's actually ample reason to suspect that the institutions we rely on to assess fundamental market value are doing a bad job when it comes to climate change. So climate risks, I'll do a quick overview. Climate risks are typically broken down into 3 categories. There's transition risk, physical risk, and liability risk. Transition risk is the possibility that corporations have failed to foresee the ongoing energy transition as renewables become cheaper and governments begin to regulate carbon, that they're going to be left with stranded assets, that fossil reserves that they have claimed to be profitable will in fact not be profitable, and there'll be a sharp market readjustment. Physical risks are, your factory's in a floodplain and you didn't realize it, and your workers are far less productive because of heat stress, and you didn't project that out when you when you did a merger with some big ag company in the South. And liability risk is the possibility that the companies that contribute to and profit from climate change are at some point in the future held responsible for that contribution. So when I think through the mispricing argument, I'm mostly thinking about physical risks. I'm thinking about your company is very reliant on, you're a mining company and you're very reliant on your tailings dams, and your tailings dams and engineering structure wise were built to withstand a 100-year flood. And that 100-year flood is actually now a 60-year flood. And no one in the institution has done the due diligence to realize this exposure that is latent within your corporation. And none of your shareholders are pressing for the schematics of how your tailings dam was built 20 years ago to see just exactly what your risk exposure is now. What's the type of risk I'm thinking about? So what empirical evidence do we have either way as to whether the market is pricing climate risks? So this year, a study from the IMF examined stock prices across multiple countries and found no association between current stock prices and measures of predicted changes in climate-related physical risks, even after controlling for fundamentals and for countries' capacity to adapt to climate change. Other studies have found that the market does not anticipate the effect of extreme temperatures and droughts. One of the leading physical climate risk consultancies, 427, which was just this year bought by Moody's research service, they have a heat stress factor, and studies have shown that an investment strategy that had been based on selling high risk firms as made by this heat risk factor and selling low risk, so buying low risk firms and selling high risk firms, would have produced extremely high returns over a 10-year period, had this heat stress factor been relied on. The most interesting study for the purposes of today, in my thinking, is so last year, BlackRock actually released its own investigation into the pricing of physical climate risks in 3 different categories of investments: municipal bonds, commercial real estate, and equities of electric utilities. And for each of these 3 different assets, BlackRock concluded that the market is failing to price in the physical risk exposure to these assets. So in the case of municipal bonds, the report pointed out that declines in crop yields from increased temperatures could expect to depress the GDP of many metropolitan areas by multiple percentage points. And they similarly found that exposed municipalities and unexposed municipalities had no pricing differential in their municipal bond market prices. And the same was true for municipalities that were or were not exposed to sea level rise. That BlackRock found no evidence of mispricing in the bond market, of pricing in the bond market of this sea level rise risk. So one question I have, and this is like a little bit of an aside, but it's specific to today, is what does it mean that this massive fund whose main product is passive investing and sort of relies on the efficient capital markets hypothesis being true for its main product? What does it mean that it's discovering market inefficiency and just telling everyone about it and releasing it in public reports? What could they do instead with this information? They could trade on it from their private funds, not by far the majority of the assets that BlackRock controls are passively managed, but they could be using it in their private funds. They could, as Ann Lipton suggests, call up index providers and tell them to make a better climate risk sensitive index. It would be sort of like a hybrid form of passive active investing. And it's not clear how they're using it and how they're using their role to correct mispricings. So I just want to quickly, I think that climate risks are distinctive and require special attention, especially as we think about how to design a disclosure regime to address them. I think they're distinctive in at least 5 ways. So many physical climate risks will occur within the relevant horizon for valuing securities, but outside of the conventional risk assessment horizon that investors and research analysts use. So equity analysts usually employ buy or sell risk analyses that extend 3 to 5 years in the future, despite the fact that about 80% of the value of an investor's portfolio is based on profits that are expected beyond the 5-year horizon. So, and in certain sectors that are particularly exposed to climate risks, like utilities and real estate, they have a much larger percentage of their net present values that are derived from expected cash flows that go 20 years into the future. So it's a problem if the risk analyses and the price and the buying and selling decisions are 3 to 5 years out, but the underlying value is 20 years out. Secondly, this is, I think, one of the biggest problems at the moment in climate risk mispricing. Shareholders and analysts currently lacked the fine-grained asset level data that they need in order to make climate risk assessments. So where corporate operations are located, where their supply chains are sourced, over what distance they travel, the sources and quantities of inputs like energy and water, where they come from. This type of information is needed to assess climate risk exposure, and it's not typically the type of information disclosed in financial reports. And often the information that is voluntarily disclosed aggregates data at the parent or holding company level, and does not disclose information specific to subsidiaries or particular assets. And corporate reporting of climate risks are far more likely to come in qualitative descriptive forms than they are to take a qualitative one. And assessment of risks occur at widely varying timescales, so it's very hard to compare apples and oranges of how a competitor firm might be preparing or like be more or less prepared relative to a competitor, because the types of disclosures are descriptive and over different timescales. So there are a growing number of physical risk consultancy firms. One of the problems with the models that they employ is that they fail to differentiate well between exposure and liability. So they may be able to describe that a certain asset is in a floodplain and exposed to, say, hurricane risk, but they don't assess how resilient that asset will be to the hurricane. So have the operators of the asset made investments in climate adaptation already? Is the asset relatively invulnerable? The models that we're seeing now don't capture that information about what exactly has been done at this particular asset. And while shareholders are beginning to demand the data that they need from corporations, they're impeded on many fronts. So they need to know what to ask for, and climate change impacts are generally pretty poorly understood. There's been decades-long disinformation campaigns that I think actually have had a genuine bias, result into genuine bias on the population. So, while we are at a point where most people will admit that yes, climate change is real, if you do a survey, even I bet in this seminar of what's the expected level of sea level rise in 15 years, a surprisingly few number of people in the private space know what those expected impacts are, even on a timescale that is relevant to the private sector. So, for example, in a survey of 440 institutional investors, more than 60% believe there'll be less than 2 degrees of warming by the year 2100. And that is inconsistent with our scientific understanding of where we will actually be at. Well, we'll actually experience about 3 degrees or more of warming, even if all countries meet their Paris climate agreements, which they are not on track to do. And shareholders have been thwarted in getting this information they need by the current administration, by efforts to take away power from shareholders by the regulators. SEC Commissioner Hester Pierce has argued that climate risk disclosure campaigns are motivated by public shaming rather than interest in informed investing. And I obviously think that's not true. So fourth, corporate managers with an eye towards maintaining their high share price actually have poor or little incentives to disclose information that might reveal their company's stock price is in fact overvalued. So this argument sort of follows from the theory of Michael Jensen's agency cost of overvalued equity. So if you are a manager of a company that has a bunch of physical assets and you discover that these physical assets that you've expected 30-year returns from like actually will be severely impacted by sea level rise 10 years out, you don't necessarily have the best personal advantage to reveal this risk to your shareholders, even if it would actually prepare the company better for climate change. So you would have to say, oh, we have to invest in this seawall, for example. It's going to require like a lot of upfront cost. The share price is going to go down a little bit in order to like account for this expenditure that we're making in the short term, but actually longer term, it's going to protect our company and ensure that we perform well against our competitors in like a longer time scale. We haven't set up managers' incentives to reveal that type of information, to tell the market like, oh, actually our company is very exposed to climate change and here's what we need to do to prepare. Because executive compensation frequently depends on measures that reward short-term over long-term performance. And finally, managers themselves might be unaware of the physical risks of climate change as they continue to rely on outdated means of risk assessment. So they may suffer from a duration mismatch or as well as latent risk. So a duration mismatch is corporate managers often rely on third-party assessors of risk, often insurance companies, as a proxy for pricing their risk. And this is a problem if you're using insurance premiums, which can be renegotiated on an annual basis, to price the risk on a project that you are expecting returns from over a 30-year period. So the insurance company might decide 2 years later after your project has been commenced that like actually the insurance premium needs to be hiked tremendously in order to cover the risk of this project. And it can switch the net present value calculations of that project from positive to negative and strand the asset that has already been underway. Okay, and latent risk. So the entire capital stock of corporate America was built using engineering specifications that are designed to endure certain temperature and weather extremes that may now be regularly exceeded in a climate change world. So the types of disclosures that we currently have now are very poorly designed to assess latent risks that are existing right now in the company that weren't there 20 years ago, but now that the world has changed around these physical assets, they are there. And line item disclosures in particular would hasten the discovery of these latent risks. So in a 2019 PwC survey, about 60% of corporate directors indicated that they thought institutional investors were devoting too much attention to environmental issues. And this was true even though 50% of directors agreed that their board has a strong understanding of the ESG issues impacting the company. So I think that the same biases that can impact shareholders in terms of their myopic ignorance of climate risks and obviously, of course, also affect managers. So why should we care? So there's the widespread underassessment of climate risk may lead to two undesirable economy-wide harms. So one is like a systemic risk to the financial system. So if individual mispricings and a breakdown of incentives to prepare for climate change can potentially amass at the level of the portfolio or the economy, this amounts to a systemic risk that is particularly relevant to index firms who are designed to be sort of ambivalent about idiosyncratic risks, but of course are exposed to systemic risk and might, as Eric indicated, take on sort of a regulatory role, step into the shoes of an otherwise reluctant SEC to monitor and police these risks. And I think that disclosure is necessary, but not sufficient to remedy this climate mispricing problem. And I've been spending a lot of time thinking about what this disclosure regime should look like. So the Task Force on Climate-Related Financial Disclosures, which is a byproduct of the Financial Stability Board and of Bloomberg and a few others, that's sort of become like the gold standard of climate risk disclosure, and it has been endorsed by many of the index funds that we're talking about today. BlackRock has sent hundreds of letters to the managers of firms within its portfolio, indicating that the index fund expects that companies will report against this TCFD standard. So it's an open question of whether, if under a new administration, a mandatory climate risk disclosure regime is implemented, whether or not it really makes sense for the US to just sort of copy and paste and staple the TCFD into the Federal Register. And in the interest of time, I won't say too much about what I think about that, other than I think that, so the TCFD requires reporting against different scenarios. It requires scenario analysis even at the level of issuers. And those scenarios that are provided are not standardized. The companies have a lot of discretion deciding like what they think a climate change world will look like. And I think there's a really big role for federal government regulators to provide scenarios for companies to report against. So I guess I'll stop there, and I look forward to talking more about these issues in the Q&A.
So Madison, one question I have for you is what this disclosure regime would look like. You started to talk about that, but this is an SEC disclosure regime. And how do you see the standards? I mean, you've talked about all the risks that are not really accounted for. So how would you sort of sketch out a model of how the SEC should go about approaching this, and to make sure that these kinds of latent risk and things that you talk about would be in fact priced, in these securities?
Yeah, I mean, I think that we need to start requiring companies to report much more quantitatively. And I think that this is obviously going to result in a big industry for the McKinseys of the world and the physical risk consultants of the world to actually help companies do physical risk analyses, like where do we get our water from? Like, will this aquifer exist in 10 years? Like, I think that those types of questions aren't being asked sufficiently. So the TCFD right now does sort of a hybrid approach where it requires that you report quantitatively against these scenario analyses, but they also have a qualitative component where they sort of ask open-ended questions like, what variables do you rely upon in assessing your risks? And so like, part of what I see a disclosure regime like this doing is like, yes, helping investors to price risks, but I think part of what also it's doing, and I think why index funds are interested in supporting it, is just forcing managers to address things that they would rather ignore, or things that they haven't even thought of existing yet. Like I think even the director level understanding of the physical changes that are going to come in the next 10 years from climate change is like woefully weak. And any kind of mandatory disclosure regime, even if it's at the level of like, what variables did you rely upon, will at least force some sort of like internal reckoning about the state of the company in the face of a climate change future. Oh, you're muted, Juliet.
Sorry. So one follow-up question is, are there any private incentives for companies to do this? You talked about the fact that they don't really have any. Is, before you suggest this regulation or disclosure regime, can you think of any, private incentives that would cause the disclosure of these risks that, absent a mandatory disclosure regime?
Yeah, I mean, I think one of the problems we have now is that the system doesn't really reward adequately, because I think people are pretty confused about valuing these risks. They don't reward adaptation properly. So in theory, one reason why managers might effectively prepare their company for climate change is because they want to broadcast how well prepared they are relative to their competitors and be like, oh, the competitor's infrastructure like happens to be in the floodplain, but like we anticipated this and we're going to be like super resilient in the future. That I think will begin to happen in some way. I don't think, it also requires shareholders being receptive to that information and like knowing that it's relevant and pricing it in. And I think that's also not happening.
Okay, so if we have no other questions for Madison, we are going to go on to Judge Agman Gonen for her presentation on ESG. You're muted, Judge.
Okay, I'm sorry. I'm trying to share my screen, but it doesn't work out for some reason. Oh, here we are. Okay, can you see the presentation? Yes, all right.
Yes, we can.
Okay, so good afternoon, everybody. Thanks for the invitation. It's a challenge to give the last talk, but I'll do my best not to repeat too much what other people have said. And my short remarks are based on an article I'm working on with Anat Beck and Darren Rosenblum. Our panel is about ESG. I would like to zoom into the S of ESG, the social aspect, and within that to gender equality, and just a second, gender equality or inequality, what we have right now. And this is really one of the most primitive and oldest forms of inequality. It's very much a reality in most parts of the world, and even in Western economies, we still see it, especially in lack of representation of women directors in the boardrooms of major public and private corporations, which I would like to talk about. I would like to show you a little bit of statistics. It's not a very elaborated graphs, but just to have an idea. The average of women directors across the world is 15%. In the EU, it's around 21. In the States, between 18 and 30, depend on the listing. In the UK, it's the best, 28 to 32. In Israel, it's 20. So in light of these numbers, I think one has to agree that change have to be made. And why we thought of, there are many ways to achieve this goal, toward equality. Some were mentioned in Darren's presentation earlier. And in our research, we would like to suggest a way that will bring change about sooner, recognizing institutional investors' fiduciary duty to promote women directors on the company they invest in. Our thesis is that if institutional investor will not consider gender representation on the board of the investee companies, they breach their fiduciary duty. There were a lot of people talked about institutional investors as stewards, and we think that as stewards, they have a duty, not just a choice, to take into account the question of women representation in the boardroom. They must consider the gender looking at companies to invest, as well as in their capacity as shareholders in the investee companies in their portfolio. Institutional investors, as we heard all day long, are key players in the world capital markets. They hold a significant portion of securities in public companies. They're the one who invest most of the public funds, saving, pensions, insurance, etc. And it gives them a great power. Institutional investors' influence on corporate governance is hard to overstate, as they're really universal owners. A lot of people talked about that too. And as Churchill said, or maybe more famously Spider-Man, with great power comes great responsibility. And their responsibility stems not only from the volume of assets they manage for others, but from the fact that in the last 2 decades, most of the public savings are held in their hands. Banks are not an attractive option for a long time because of low, even negative interest rates. So behind all of this institutional investors we're talking about all day long are millions of savers, workers, pensioners, and other investors who trust them and entrust their future in their hands. And given their experience, significant holdings, knowledge, and expertise, their investment policy and decision have a huge impact on corporate governance, fair performance, and overall behavior of the companies in the market. We heard about it a lot, but they can influence the way companies behave in different ways by publishing their investment policies and letting the market know what consideration they will take into account. There were talk about if it's for the millennials, business reasons, or for real reasons, but it doesn't matter, they still do it. By exercising their voting right at the general shareholder meetings, and some of them even by engaging in a dialogue with investee companies regarding ESG consideration. And actually, the question is, who do they work for, or who do they have to take in consideration? And the question is, of course, the purpose of the company. And I will not repeat Ed Rock's excellent keynote on that subject. So I will really not elaborate. I will just say that this ongoing debate between scholars of the traditional view, which Ed Rock still holds, the American view, if you want, who claim that management is responsible for protecting the interest of the shareholders, or not the shareholders, but the company as a whole, but the shareholder as the main representatives of the company. And scholars of the stakeholder approach, Professor Ed Rock mentioned some of those who claim that management is responsible for protecting the interest of all stakeholders, and they have to take these into account as well. And here I would like to talk a little bit about the pandemic and where I think it's going to take us in the direction of the purpose of the company. I believe that the corona pandemic or COVID, whatever you call it, would affect this debate and tip the scales in favor of the more holistic, more stakeholder approach. Right now, the power and influence that corporate institutions hold over wider society has reached new heights in the pandemic, with respect to making the big decision about allowing workers to work from home, for remotely, healthcare benefits and other forms of economic relief given to workers who are let out or shut down or whatever. Corporations are stepping up to fulfill a leadership role very seriously. For leaders, this necessitates a closer look at the values and underlying purpose of their organization and re-examine the way they're making decisions. People are now put first before profits. We pray that the crisis will be over soon, but we hope this trend toward cooperation and the social good will stay with us, and that new business models will be developed based on sharing, reciprocity, and cooperation. Okay. Sorry. Okay. Now, how does this goes with what I said before, what I'm going to say about women? First of all, in the pandemic, women are the ones who are hurt most. They were fired first. They're not going back to work. Their load of work at home is being increased. Not to mention violence in the home, but I'll not talk about this here today. But what we think is that really promoting equality for women is one of the purposes that we can really insist on from institutional investors. Now, as Darren Rosenblum, and I'm going to show one of his slides, mentioned, there are many ways to do it, starting with quotas and as other people say, market solutions that should work from themselves. Now, quotas are actually the best in terms of how many women there are. I mean, in countries where the quota set at 40%, they have 40%, but there is a lot of countries are against quotas for various reasons. Again, it was talked about. I will not repeat that, but we think that we think that this should be promoted, and I want to talk about the three main reasons for in favor of gender equality in boards. So the first one is a human right approach. I think the Convention on the Elimination of All Forms of Discrimination or the American Constitution are all for equal rights for men and women. So I think this is the most important reason. The second thing is that heterogeneous board works better and makes better decisions. They're getting the best directors. Women are 50% out of all the workforce today, at least. And the last thing is debatable between finance and business academics, better business outcomes. Most of the institutional investors say that they do have better business outcome. Others say the opposite. I think we should not rely too much on this because it's really debatable. And so if it's so good, why not actually? So there's some objections I would like to relate to. Some of them had come up during today. So the first one is socially controversial argument. Professor Ed Rock talked about it. Is that many issues regarding as ESG are subjective and socially controversial. If we take the debate over firearms in the United States or climate change, as we just talked about. But this argument is not valid when it comes to sex equality. The right to equality is declared both, as I said, both by international law and constitutional law in all liberal democracies. So it cannot be argued that gender equality is subjective or a personal agenda of one group of directors or another. The second objection is the vague and immeasurable argument. The second is that ESG considerations are usually general, vague, and indefinite, giving value to our consumers or trading fairly or all of those slogans. So the argument is also not valid when it comes to gender or sex equality, since it's very clear and measurable goal. 50% you can count. The third argument is the price tag argument that in many cases, again, it was mentioned in Ed Rock's lecture, when taking ESG consideration into account, it is associated with a high price tag, especially climate change. expensive green energy. This example was given before. Appointing more women to the board to reach equal gender board does not carry any price tag with it, or almost nothing. And the research showed even that the opposite is true. So I think that after addressing this objection, we can say that we need to go in this direction and use the ESG as a way to promote sex equality in the boardroom. Now, actually, we need affirmative action, because if we take equality seriously, we don't have to take sex into account while appointing people to the board. But we're talking about a little bit different of affirmative action, not saying how many women there should be, and not saying a specific woman was discriminated against when coming or applying to a board seat, because there is no such data. What we think is the nomination process should be more equal opportunities, proactively reach out to women, have existing pools or pools prepared for this purpose. Women who want to be directors should be included in dedicated lists made out for this purpose. The allocation procedure should be set up like that the same number of men and women candidates to each position to the board will be every time there is an opening. So it's very important, because we think that the way it now happens, men who dominate the boards turn to their friends in other boards or in the corporate field and ask them to join them, and this way we will not get there. So the call for action, very briefly to sum up. First and foremost, to institutional investors themselves, not to settle for passive investment in share of trading companies, but to take active action to maintain good corporate governance. Now, I want to show you an example of BlackRock and Goldman Sachs, who both said women is very, very important on the board. But as you see, they're around 30%, which is not bad. It's above average, but still we're very, very far from the 50%. So first of all, we need them to take action. And then we have all the intermediaries, legal advisor, investments consultants, integrate gender diversity practices into conventional financial practices. It's very important. And finally, policymakers and regulators, we need a recognition of the fiduciary duty and disclosure of how many women in Israel, for example, you don't know how many women are in the board. And since in Israel, many names are, men and women names are the same, if you have the list, you don't know if it's men or women. So at least to have disclosure of how many women and of the way to promote women, how you choose women to the board, and so forth. And I would like to end with the saying, all is fair in love and war. And I do believe that not all is fair in investing, and equality of women cannot be overlooked for making short-run profits. And I think in the long run, it will also be profitable. So it can also be there with the traditional purpose of the company, even if we want to leave it at that. And I think the pandemic should make us think differently. And equality for women in the long run will benefit us all. Thank you.
Well, thank you for that wonderful presentation about the diversity of women on boards. It was wonderful to hear that. Now, I'm the moderator and I have some questions from the chat for our panel. So one of the questions is for Madison. In the UK, there's a requirement now for directors to disclose in their strategic report their attempt to promote the success of the company. This views environmental considerations in terms of corporate success and shareholder value. Do you see, Madison, the SEC regime as something similar, or should it be calculated risk impact for society generally, separate from the value given for the given company?
Yeah, I mean, I see, you know, the TCFD disclosure regime and sort of what I envision as a potential move in the US, which is just to staple the TCFD into the SEC's disclosure regime, is asking for reporting about company-specific value, about risks that are facing the company. Now, those individual company risks are the step one in assessing broader risks to the economy. And, you know, individual idiosyncratic risk is necessary to assess the systemic risk of climate change to the financial system. And I organized an event on climate risk disclosure, and I had former SEC Commissioner Rob Jackson talk about like whether or not legally the SEC can mandate a disclosure regime on the basis of revealing systemic risks rather than issuer specific risks. And his position is that like, absolutely, that is within the SEC's authority. So, you know, obviously we're not talking about like societal welfare in that sense, but when you're talking about climate change, those concepts are pretty related or overlapping. So yeah.
Okay, so, all right, we have another question from a student for the whole panel. Do you think ESG statements by the big three, particularly BlackRock and Vanguard, are more or less PR fluff, given the relatively low support of shareholder environmental and social proposals? Are these public statements possibly even misleading to investors?
I think it's a lot of PR and a lot of not only PR, but looking at the millennials and wanting their business But I think that even though it's a lot of PR, I think it's important because I think it brings up very important subjects like climate change, like sex equality, and other subjects that are important. And I think that we are talking about fiduciary duty because we think that if it's misleading, like what I showed you, BlackRock talks about women equality and how women are important in the boardroom, but they have 30% women in the boardroom. So I think if the investors will start making them put their money where their mouth is, so it's important. It's important that they say this is our purpose, and then people can say, okay, what are you doing with this? It's not enough just to have a nice letter at the beginning of the year. You need to follow through.
Do other panelists want to comment on the misleading aspect of it?
I mean, I think it's a lot of puff, meaning that, you know, ultimately, I think that the big three know that they're going to be increasingly competing for millennials' investment dollars. And as a consequence of that, you know, they're putting these statements out. I still think we're at the point where, you know, we haven't reached the level of sophistication that we need in this field. And what I mean by that is, you know, based on the fact that a lot of securities regulation is based on materiality, we haven't really defined that as well as we should have in regard to ESG. You know, it's interesting what the course of the big three will ultimately be from this. I mean, maybe we develop really good standards and they become leaders and assume that regulator role that I would be nice. And I think that I know Madison had talked to me about that a little bit in another conversation, but I don't have the greatest confidence. What's being put out right now, I think, is more aspirational than reality, but I doubt it's actionable.
We have another question for Professor Condon, saying that it strikes me, this speaker here, that the short-term quarterly objectives of most companies disincentivize the kinds of fact-finding and disclosure that Professor Condon is advocating for. Is that a fair assessment, and how might that be remedied?
Yeah, absolutely. I mean, so generally, yes, I think that I think that quarterly reporting does not help incentivize managers to prepare for climate change adaptation. And I think in certain industries, actually managerial incentives in terms of like what their compensation is pegged to metric wise is actually completely the opposite of what we should hope for in a climate change world. So, I mean, fossil fuel executives often have a significant percentage of their compensation linked directly to the reserves replacement ratio. So like how many reserves they add in a given year relative to how much was extracted. So their compensation is tied to that number instead of like profits that year or even revenue that year, because it's supposed to incentivize, it's supposed to make them think longer term about the future of the company. So they like build up their reserves. In a world in which like most of the reserves that companies are currently claiming will be profitable, like couldn't actually be extracted in a world that like limits in any way warming to like 2 degrees C, maybe that incentive structure like really doesn't make any sense anymore. And that's up to individual shareholders to change, like through the proxy process.
So does anyone have any further questions for the panelists? Either panelists or audience? I think none from the audience. So I think I could wrap up and give a few closing remarks, but I don't want to cut off questioning. Okay, so then we're at the end of the Leet Symposium, and we're going to bring it to a close. We're very lucky to have had this great group of panelists from legal scholars, legal practitioners, and economists. We set out this morning to address the fiduciary obligations of index fund managers, the implications for corporate governance and stockholder activism, potential anti-competitive effects and effects on market efficiency, the rise of ESG. So we've learned so much. Professor Ed Rock presented his keynote, and he addressed this fundamental question of for whom the corporation is managed, but that he also connected that question to whether common management is anti-competitive. He also explored the difference between business purpose and corporate objectives, and looked at the difference between welfare of actual shareholders and firm value from the perspective of the entire shareholder group. The speakers today addressed the profound corporate governance and fiduciary implications of passive investors owning nearly 1/4 of the stock in S&P 500 companies. One panelist linked the increasing activism of index funds on ESG as a response to the pressures of the millennial generation. Another speaker addressed the conflict between BlackRock's shareholder activism and ERISA's fiduciary duties. Several speakers addressed the concentration of ownership effects, or how the concentration of ownership affects or undermines competition, with one speaker addressing the relationship between short sellers, corporate governance, and index fund investors, and also another looking at the market implications of horizontal shareholdings by large asset management companies. There were so many questions that were raised today that I think will require further exploration. Who should best handle externalities, the firm or some government regulator? How large, we looked at how large management companies could actually help solve principal agent problems. We looked at the tactics of activist shareholders. We looked at how shareholder engagement has changed over time. We asked whether better stewardship could lead to better economic results. We looked at how an index fund is supposed to determine investor preferences, or yes, and maybe there are different solutions to that, including pass-through voting. There was an interesting distinguishing between fiduciary duties of fund managers to funds and then to investors, and distinguishing those obligations to portfolio companies that are really not fiduciary in nature, but there are obligations, but not fiduciary. And we looked at gender diversity on boards. And so we've explored just an incredibly wide range of topics. And it's been wonderful to hear all of these talks. And we look forward to this dialogue continuing, both with the publication of the symposium issue, with some of the speakers today's papers being published in that issue, and then just to reading the papers and following this dialogue in the future.